hear us now. Withdrawals are not urgent matters.
My lord, it is why it is urgent, my lord, because the tender has been awarded in favor of me. So due to pendency of this matter, my lord, the collector is not granting the award, my lord. So this is the, my lord.
So you should have filed the IA instead of filing.
Already I filed, my lord. IA number 10203 of 2026. I have already filed, my lord.
When did you file?
I have filed on 25th, my lord.
Today's?
My lord. 25th, my lord. 25th May.
So 25th May. So you mentioned the IA. Along with the IA, you mentioned before the deputy registrar next date. Tomorrow you mention it. Tomorrow or day after you have to mention.
My lord.
Because we are not, whatever has been notified, we are following that only.
Yes, my lord. Before that, your lordship, I will mention before this, dear my lord.
My lord,
your
lordship, so I
beg. Find the memo in the Dropbox.
My lord, my lord.
Along with the IA, you have to mention the IA.
Yes,
because apparently today, to 25th May, if you would have mentioned the IA, it would have been listed.
My lord.
May I humbly make a mention, my lords, before your lordships? It's a very urgent matter.
Mention for listing, oral mentions are not notified in the notice. So please appreciate, you file it in the Dropbox.
My lords, we have already filed it in the Dropbox. My lords, it was supposed to be listed today before your lordship's single bench. I'm aware that I'm mentioning before that.
So what is that? So what is that? Case number?
My lord, there are two CMPs, my lords.
So maybe because it was delayed, because you see, even if it is notified till 11, it is working till 6 or 7. So they might have missed it.
The urgency is such that I am before your lordships with folded hands, my lords. The urgency is such. And this is a mention on behalf of the state government, my lords.
Let us not deviate. We are also folding our hands. So it will be listed. It will be listed.
My lords.
Yes.
My lord, today before your lordship's single bench, my lords, if your lordship permits, kindly permits.
No, I'm really kind. So you must kindly understand that. I cannot accept because you are holding your hands and you are saying me kind. So
but that is not, my lordship may kindly listen to my urgency. If your lordship feels that it is not urgent, I will simply.
So apart from listening to you, you have to listen to me. If you have done the needful before the DR, it will be registered. It will be listed. You need not worry.
My lord,
use the Dropbox. Use the Dropbox. So no, he says he has already done it.
Already done. My lord, already mentioned before the DR.
So you can simply check with the DR.
My lords.
Maybe it will be listed today. Still there is time. You check with the DR.
My lord. High lord.
Yes.
Lordship, 1 minute. I may be.
At least we are obliged that you have started listening to us.
No, my yes. Lord. The urgency is such, my lords.
Yes. Every matter is urgent. Without urgency, nothing is listed. By spending time in discussing who is urgent and who is not urgent, we are wasting time. Yes.
My lord, I will be pardoned, my lord.
Why you will be pardoned, sir? You have done nothing wrong. Yes.
My lord, I am pardoned to mention it.
What do you want, sir? Please straight away come to the point.
RC cancellation matter is there under the OST, under the GST.
Sir, is it in the list or you want to mention?
Sir, I want to mention it is not in the list.
Oral mentioning is not notified, sir. We cannot deviate from the notification of the High Court. So make it, use the Dropbox.
Okay, ma'am.
Please, it is elaborate method is mentioned and we are allowing time to almost till 2 p.m. Instead of though it is, so you file it, then you remove the defects, it will be listed.
Lordship, one mention matter.
Yes, please.
The petitioner GAIL has authority India input tax credit has been blocked and the GST authority has
sir, oral mentions are not notified during vacations. We are just simply wasting time.
Lordship, urgent listing for the matter.
Yes, urgent listing are only listed and you have to follow the procedure like others have been listed.
Yes, sir. Please, Lordship.
No, if you presume that others have been listed due to oral mentioning, it's not correct. Please follow the way it has been notified, please follow it.
May I be pardoned, my lord, to make a small mention?
Yes.
I understand, my lord, that it is not notified, my lord. But the reason I am mentioning is that content.
No oral mentioning. No oral mentioning. Content matters are not urgent. Whatever urgency, you have to use the Dropbox today.
Understood, my lord. My lord, since they instruction as like you allow list of
because instruction
खाली
मो इंस्ट्रक्शन दे देले मो अलाउ आमे अलाउ करिवु से करिवे सेंटी इंस्ट्रक्शन ताक पारे नाही
My lord, since content matters are not urgent as notified by the Honorable High Court, my lord, I'll just make khali urgency ta khali koi doji. The
No,
fourth
no, no.
order-
It oral mention karantuni. We are simply wasting time. We are
My
not
lord.
supposed to start listening oral mentioning.
My lord. And I'll put
mentioning
it to the
ଆପଣଙ୍କୁ ସେଥିପାଇଁ ତ one day ahead ଦିଆଯାଉଛି
my lord.
ଆପଣ ଆଜି ଏଇ ଜିନିଷଟା ଡ୍ରପ୍ ବକ୍ସ ରେ ଫାଇଲ କରିଦିଅନ୍ତୁ.
My lord. I shall comply.
The matters which cannot wait
My lord.
till reopening.
This cannot wait, my lord. There is a
Punishment can wait.
no, my lord.
Contempt punishment it can wait.
My lord, the urgency is my
If
lord.
the contempt is decided in your favor, that contempt you will be punished. After vacation you will be punished.
My lord, order ta comply na hele the entire year comply hei paribani. Rainy season is approaching.
So in contempt I cannot pass orders on merits.
My lord.
The law is very clear on that.
My lord.
Whether for half year or full year. So
I shall file it in the proposal.
yes, contempt is correct merit. So that another point you have to think your strategy also. Whether you are following the correct. We will punish him after vacation if he has committed contempt.
Fine.
Yes. Call the list.
Vacation list, press admission, item 1.
Lordships,
May
Lordships, sorry to I have to want to mention, my lord. Let
Oral
this-
mentioning, sir, oral mentioning, you are getting carried away by the practice prior to vacation. Sir, there is a special way of mentioning in vacation. It is notified. You have to follow that.
Lordships,
We-
again.
Sorry.
Sorry for Lordship, interrupting
No, why
Lordship.
should be sorry?
There is a-
ଆପଣ ସବୁ କଥାରେ sorry କାହିଁ କହୁଛନ୍ତି? ଆପଣ ଯୋଉଟା ଜାଣିନାହାନ୍ତି ଆମେ ଆପଣଙ୍କୁ କହିଲୁ ସେଟା ବି ଆପଣ ଭାବୁଛନ୍ତି ବୋଧେ oral mention ଆମେ list କରୁଛୁ ଆମେ oral mention ରେ list କରଉନୁ ସେଟା ଏଟା ଅଧିକା ସମୟ ଦିଆଯାଇଛି ଅଧିକା facility ଦିଆଯାଇଛି because of vacation ହଉନି ହେଲା follow କରନ୍ତୁ 11 ରୁ 12 memo ଦିଅନ୍ତୁ if it is urgent it cannot wait till reopening it will be listed.
Oblige Lordships.
May I please, Lord? Item 1, my lord.
Yes, please.
Petitioner challenged the order as at Annex 8 by Honorable Single Judge, page running page 39.
Yes,
Is it-
Mr. Das, straight away come to this since it is a writ
Yes,
appellate
it-
jurisdiction. Straight away
yes.
come to the
It,
para of the order where you are agreed.
Yes, 5.1, my lord, page 40. Is a batch of case, my lord, it was listed. Is a transfer matter, my lord. It was disposed of 5.1, page 40.
Yes.
It is contained that since in the present batch of writ petition, all the petitioners have already continued for more than 3 years in their present place of posting as per the guidelines governing the field, petitioners have been duly transferred and no interference is called for, my lord. In this present case, my lord, my date of joining annexure 1,
That cannot be corrected in appeal. That cannot be corrected in appeal. You have to file for review of that order where the 3 years is less than 3 years.
yes, because my lord, there is a in vacation, my
So,
lord.
and the problem is that it is disposed of in a batch. You were present.
Yes.
So you should have
Yes, I
filed.
already by order dated 21, Lord, so 21.5 in my single writ petition, it was already mentioned my order dated 21.5 in my double PC, my lord. 14,842
Disposal date କେବେ?
22/5/26
କେମିତି ଆପଣଙ୍କର ରିଭ୍ୟୁଟା disposal ପୂର୍ବରୁ କେମିତି ହବ ଆଗେ?
ନା ରିଭ୍ୟୁ ନୁହଁ ସେଟା 21/5 ରେ ସେ
ଆପଣ ବୁଝିବା ଦରକାର ଯେ now by observing that the petitioner has not continued for for 3
Yes.
years,
Yes.
we cannot pass a order because that's not a ground to overturn a order in appeal.
because that is a
Read appeal is very limited. ଆପଣ ଯଦି you are alleging that there is some wrong appreciation or
that is it is
kindly listen, sir. Kindly listen. If it is a wrong appreciation, because the other problem is that it's a batch of matters.
yes
So it was more so your duty to point out to the court that on 23 at least ଯେ ଏଟା ଆପଣଙ୍କର 22 ରେ ପରେ ଆପଣ 21 ରେ କହିଲେ କେମିତି ହବ?
21 ରେ it was mentioned that I have already stated in
Mr. Das, is there a separate order for in your case?
no
So then,
but it's a
so you
fact.
have understood it.
It is a
We
fact.
cannot. So if in your case the facts are different, just kindly mention before you have to seek a review.
But no time is there. It's a factual dispute, my lord, because
Why no time
because
is there?
I am
The
in
bench is available. The bench is available. The bench is available.
but
You must understand that. On
there-
this ground, we cannot issue notice. We cannot interfere.
They have proceeded with my transfer order, the opposite party, my lord. There is no time
So,
for.
sir, I don't know how we should advise you. We as lawyers, we can advise you still, but we have left that side.
Like, factually, my lord, I am in premature 1 year and 7 days.
So you should have taken steps for on the same date itself to file that. That I have mentioned in my memo or whatever in 21.5, so that it has continued less than 3 years, and the same bench is available during vacation.
My only case is that only basis of that I have.
So thus your writ appeal can be dismissed, or we have to advise. You have to follow what we have advised you.
No, lordship.
Free legal advice. Because that judgment is well reasoned, and you can challenge it before the higher forum. That's a different thing, but there is no ground. You are saying that instead of 3 years, you have spent 2.5 years. That you should have mentioned before the court when a batch matter is disposed of. And this usually happens in batch matters. Possibly the fact cannot be taken note of. And you should have filed that application on 22nd. Serve the copy on the other side. They should have said that yes.
No, this is the last date. 22 is the last day before summer vacation. On that date, was it?
जो order टा हिची ताको आपण एबे move करंतु. After arguing for this, so we will observe anything on merit or simply adjourn it.
Yeah, adjourn.
After arguing for some time on merits of the case, no, the writ appeal रे लिखिबे appearance लिखंतु. Mr. P.S. Das for the appellant. Mr.
My lord, I am appearing along with Laurent Days. Along with Laurent Days, I am appearing.
Mr. Bhukta.
My lord, my lord.
Mr.
D.R. Bhukta. D.R.
P.K. Padi, senior advocate, Laurent DSJ, along with Mr. Dipti Ranjan Bhukta, CGC.
My lord, CGC.
Mr. Padi, if you have heard Mr. Das, he is saying that he has not continued for 3 years.
No, fact remains that I have received instruction. He is continuing since 9/8/2019, more than 6 years, my lord, in Odisha battalion.
It is a false one.
We have understood it correctly.
Yes.
Anyway, so that is how the writ appeal.
My lord.
Whoever in Odisha, they are not ready to leave. They love Odisha, it's pride.
Yes.
But nobody is ready to leave Odisha.
You create Odisha everywhere, Mr. Padi. You have to create Odisha everywhere. Wherever they go, there should be an Odisha.
Yes.
Odisha atmosphere.
In All India service, if nobody is ready to leave this place, it is another
Padi, you
problem.
are appealing for all OPs, all respondents.
Yes, all the
Yes, we are for all respondents.
All respondents, along with him, respondents, the Laurent Counsel for the appellant. Very tricky to observe Korean. Let us give them a chance. Submits that he seeks adjournment of the matter to move the vacation bench as and when advised. Stop. Accordingly, the matter stands adjourned. Liberty with liberty to mention.
oblige.
And notice that along with I have sub notice.
Yes, we have received the copy. Unless and until we received the copy.
Obliged.
So the 7 ବର୍ଷ କହିଲେନି ଆଉ କଣ କରାଯିବ?
ନାଇଁ ଏଟା false statement. Present place of ବର୍ଷେ 3 ମାସ ହେଇଛି.
They are saying so, but the fact is different. We will clarify. Already in repeat clarify now.
Present place what I use करनांती Laurent single judge. Anyway,
Same area, 2 places.
yes, please. Next.
Item to
May I please, Your Lordship?
Yes, please.
Item to Lord, the judgment of Lord single judge.
Yes, Mr. Mehra, the same. No error apparent on the face of the record. Nothing.
Not because
The problem is you should have instead of establishing your right this way, you could have moved the declaratory relief, because the property is recorded in name of the the mother-in-law.
That
Yes,
observation.
yes, it is admittedly, the building is property is recorded in the name of mother-in-law. I don't have any claim or any
So don't
right,
claim
or interest.
So I mean, you are
because
the only thing is that if you are thinking that you will be prejudiced in your efforts for declaratory relief, maybe we can clarify that.
Mr. Behra.
Yes, please.
Yes,
Just Mr. Behra, your paragraph 7, which you have admitted, is very clear.
Can you respond to Lordship's query?
paragraph 7 of
Paragraph 7 of your petition, appeal.
I mean, though the Honorable Single Judge has referred to a plethora of judgments, one judgment is enough and the principle is clear.
no, that is the fact. That is the fact. Not
Mr.
I
Behra,
have never.
kindly listen. Mr. Behra, kindly listen. These are 50-50 cases. In some cases you will succeed, and in some cases, but here it's I think Mr. Tripathi is also, since he appears for the authority, he is saying the same thing. Here the property is in the lady's name. So
Yes, I don't dispute that. Not only thing I have to. My appeal is not being a woman.
Let's see,
and
my Justice Raman has rightly pointed out it is
daughter-in-law. Let me. A daughter-in-law cannot be thrown out in a simple.
No, she has not been thrown out.
manner.
You cannot re-argue the matter. She being thrown out was not your argument. You must understand. She being thrown out was not your argument before the authority. That
yes. That was my grievance.
No. You have not read. With greatest of respect, you have not read your assertions before the trial court. You see, Mr. Behra, if the lady has said certain truth, let us not distort it. The appellant has been truthful to certain extent. She says that her husband stays in Germany. She stays at times at her woman's place, daughter studies, and he says that she stays in Hon'Ble for looking after her daughter.
No,
at times.
No. That is not the evidence, not. That is not the evidence, nor any evidence.
The problem is that it is an administrative order. Then it has been confirmed by fact-finding appellate court. We cannot interfere. Only thing is that if you want to file any in future, if you want to pursue any litigation, you can wait. And you see there is a fact-finding inquiry by a neutral revenue authority. The appellate court need not have gone to that. The fact-finding authority is that you have logged it.
No evidence.
No, my lord,
no evidence.
This is not a debate competition. I have been emphasizing. We have to go by the pleadings.
Yes.
We may what you say. You have to please refer to the pleadings. There is a fact-finding inquiry by the Tahsildar. Tahsildar says it. You have logged it. So that way, sir, this is not the problem is that when this is an administrative order, it's not a kind of declaring right title and interest. You have to go that far.
Yes.
For declaration of right title interest, you have to go that far.
Other remedies?
Obviously, possibly you have to. It's a long drawn battle. That is a different aspect altogether. And Mr. Behra, you being a lady, your mother-in-law is also a lady. So that is these are competing claims.
Look,
at least this proceeding is concerned. You leave it there. Maybe you have to achieve something else by some other litigation, and let it be adjourned. If you want, we will observe on merits, or you adjourn it.
Let it be adjourned.
After arguing for,
I have been protected in DB proceeding.
Sorry, sir.
I have been protected in DB proceeding.
DB proceeding has been discussed in detail by the learned court, single judge.
Yes, Lord.
So we are not if you are taking benefit of any part of the judgment of the honorable single judge, we are not interfering.
Yes, Lord.
The other side may challenge. If so advised, they may challenge. That's a different thing.
Yes.
Mr. Ashok Kumar Behra for the appellate. Mr. Devasis Tripathi, additional government advocate for R1 and 2. R3, 4, blank. The learned counsel for the appellant, after arguing for some time, seeks adjournment to obtain instructions. Accordingly, the matter is adjourned, shall be listed after vacation before the assigned bench. Liberty to mention.
Well, can I pray a simple, make a simple prayer? No?
Yes, why not?
Till my husband is allowed
Too complex prayer. We can't put another condition that till your husband returns from Germany after the this Hormuz is opened, Pakistan airspace and this Middle East airspace is open. So all those things that is too uncertain. ଆପଣ ଯେମିତି ଅଛନ୍ତି ସେମିତି ଥାଆନ୍ତୁ. I think this is you have to be patient. ଆପଣଙ୍କର ଯେତିକି ଅଛି ସେତିକିରେ ଆପଣ ଯଦି କିଛି ଚାହୁଁଛନ୍ତି ଆପଣଙ୍କର ସେୟାର ହେଲେ go for a declaratory. ସିଏ ଯାଇକି କହିବେ ଆଜ୍ଞା ତାଲା ପକେଇଛନ୍ତି ଆପଣ କହିବେ ମୁଁ ତାଲା ପକେଇନି ଏଇ ଜିନିଷରେ leads to nowhere. ତାଲା ପକେଇଦେଲେ ଆପଣଙ୍କର ମିଷ୍ଟର ବେହେରା again the same legal advice. ତାଲା ପକେଇଦେଲେ କି କୋଟି କଣଟା ଜିନିଷ ହେଇଯାଏ.
ନା ତାଲା ସିଏ ପକେଇଥିଲେ ମୁଁ ଯାଇଥିଲି ଭିସା କନଫର୍ମେସନ ପାଇଁ ଆସିଲା ମୋ ତାଲା
ଆପଣ ସେଇ ଲାଇନ ରୁ ସେଇ ଲାଇନ ରେ ଆପଣ you are too seasoned to advise your client. ଆପଣ ଏଥିରେ ଡିକ୍ଲାରେଟରୀ ରିଲିଫ ଦରକାର ନହେଲେ ଏଟା କରିହବନି. ତାଙ୍କ ନାଁରେ ଘର ସବୁ ଜିନିଷ ତାଙ୍କର ସେ ରହୁଛନ୍ତି ସେଠି ବୟସ ଅଧିକା ସବୁ ଜିନିଷ ତାଙ୍କ ଆଡମିନିଷ୍ଟ୍ରେଟିଭ ସାଇଡ ରେ ଏତିକି ଏନକ୍ୱାରି ଇଜ ଏନଫ୍. Yes, next item.
ମ୍ୟାଟ୍ରିମୋନିଆଲ ଡିସ୍ପ୍ୟୁଟ କିଛି ନାହିଁ.
ମତେ ବି ଲାଗୁଛି ସେ so one aspect of our adjourning the matter is that maybe better sense will prevail. ଆପଣଙ୍କର ଯଦି ଆପଣ ମନେଇ ପାରିଲେ ଆପଣଙ୍କର ଶାଶୁ ଶ୍ୱଶୁରଙ୍କୁ ସେ ଆହୁରି ଭଲ.
କିଛି ଡିସ୍ପ୍ୟୁଟ ନାହିଁ ଆଜ୍ଞା ହଜବେଣ୍ଡ ସାଙ୍ଗରେ ଡିସ୍ପ୍ୟୁଟ ନାହିଁ କିଛି ଡିସ୍ପ୍ୟୁଟ ନାହିଁ.
You mediate ଏଇଥିରେ mediate କରନ୍ତୁ.
ଆଜ୍ଞା ସେତିକି ଖାଲି ହେଇଗଲେ ମୁଁ ସେତିକି ଚାହୁଁଥିଲି.
ସେ ରେଗୁଲାର ବେଞ୍ଚରେ ହବ. ସେ ରେଗୁଲାର ବେଞ୍ଚରେ ହବ. Yes. Item 3. Till then, can I be protected? No. There is absolutely no question of protection because it is a possessory right you are seeking. How a possessory right will be protected in a writ appeal?
Possessor simply.
So you see, Mr. Behra, we can address the issue in by merit. Okay. So we are just restraining ourselves. Leave it there. My esteemed brother will. Yes, Mr.
Maybe I'm for the petitioner in this case, Your Lordship. A batch of the writ petition is pending before the coordinate bench, Your Lordship, where my lord 73-4B, Your Lordship. I have passed on one order. I have passed one modified order.
So thank you.
I have passed one modified order.
Yes. The same order. Lordship has suggested for the same order.
I have passed on to the court master, Your Lordship.
I am appearing for the OP.
I have sent an
correction.
Correction.
Your Lordship.
This is
Grateful, Your Lordship.
Yes, Ms. Tripathi.
Millards, item number 4, Millards. In this case, Millards, we are challenging the notification.
168A.
168A, Millards. Extended adjudication.
Similar.
Change करके दियो.
Yes, Millards. Similar order, Millards, with
yes. As my lord has suggested, kindly hand it over.
I
so the same order.
Handed over, Millards. Already
Same order. Appearance.
My lord, I am appearing for the OP number 4 and 5.
I am appearing on behalf of the OP number 2-3.
Lekhantu, Ms. Siti Tripathi for the petitioner.
My lord, I am appearing for OP number 1.
Mr. Patnaik, 1.
Satyanarayan Patnaik.
Satyanarayan Patnaik.
My lord, DSG office,
The
Mr.
DSG
P.
ଓହୋ ଆଚ୍ଛା ଆଚ୍ଛା ପାଢୀ ହେଇଯାଇଛନ୍ତି ଠିକ ଅଛି ସାର୍
Along with,
Union
along with
Bank.
Mr.
ଆଚ୍ଛା ଆଚ୍ଛା ମୁଁ ଆପଣଙ୍କୁ ପାଢୀ ବାବୁ କଣ ଏମିତି ପାଢୀ ସାହେବ ବଦଳି ଗଲେ ମୁଁ ଭାଇ ମୁଁ ଆଶ୍ଚର୍ଯ୍ୟ ହେଇଗଲି ମିଷ୍ଟର ସତ୍ୟନାରାୟଣ ପଟ୍ଟନାୟକ ସିଜିସି
CGC.
ସିନିୟର ପ୍ୟାନେଲ କାଉନସିଲ
No, CGC.
along with Mr. Padhi.
Along with Mr.
Mr.
DSG.
PK Padhi, Mr. Agar likhe, Mr. PK Padhi, senior advocate, DSGI, along with Mr. Satyanarayan Patnaik, CGC. For
One.
Opposite no one.
one. Mr.
Your Lordship,
Yeah,
Your Lordship, I am appearing.
Sujan Rai Chaudhary.
No,
I am appearing for OP number 4 and 5, my lords.
foreign.
Acha, tahle Mr. Sunil Misra,
I am for 2 and 3.
standing counsel, City and GST,
Your Lordship.
3 and 4.
2 and 3. Sorry, 2 and 3.
2 and 3.
Your Lordship.
4, my lords, 4 and 5, senior standing council, CGST.
4 and 5 hele, Sujan Kumar Rai Chaudhary, senior standing counsel, CGST. Eitra add kariye. Item number okay ki de do. Yes.
Great, my lords.
Obliged, my lords.
My lord, this is a dispute under the GST Act. I have challenging the order passed under the 74. Here, kindly state, kindly have a glance to page 137. They are relying on the WAMIS data, only relying on, they have not considered my return anything. Kindly have a glance to 137.
Yes.
Kindly have a glance to page 137. Here, during they have received the payment available from WAMIS
Mr.
data.
Mishra, you have instructions? He has enclosed one earlier order of ours.
Your Lordship, so far as 74 is concerned.
With respect to natural justice is concerned.
Your
He
Lordship,
has, he
Not a
is
single-
relying on Janardhan Panda case, which is delivered by division bench, where I was one of the party. Page number 215.
You say 1557.
Your Lordship, here
You check up whether natural justice is complied on.
he has a
Otherwise, he has a remedy.
Your Lordship, he has a better case in other ground, not this ground, not
No,
particular.
apart from that, already 623 order has been passed. Apart from that,
That
DGI has already considered and passed the order. Kindly have a glance. Annexure
oh, it is appealable order.
already detailed. Minor, how appealable? Is a double taxation. My return is 100 crores. They're asking for 78 crores. I have disclosed 100 crores in my return, and they have how much data is 78 crores. Already I paid tax on 100 crores, and DGI already considered that. Kindly have
If
that
that
order
is
is there. my
so,
lord.
Mr. Harichandan, if
My
there
lord.
is dispute regarding this payment and adjustment, there is a scope for 161. So
No, my lord,
when on merit, you have alternative remedy.
No,
There is
they
no
have not
scope
given
for,
a single opportunity. Kindly demand to I have noticed before the assessing officer. They have not given a single
Sir,
opportunity.
if he has not considered with regard to the figures and amount which you are stating to have deposited, then you have a remedy under section 161. You could have.
My lord, that is there.
Thereafter,
Right,
you
that is-
have pre-deposit. You cannot circumvent appellate forum and come directly on merit.
He has not given a single opportunity of hearing. I have replied.
That is why I
Kindly have a glance to
Mr. Harichandan, that's why I asked Mr. Misra whether he is conceding for this natural justice in the line.
Then
Janardhan Panda case.
kindly
Your
take the instruction.
Just a minute. Your Lordship has rightly pointed out so far as 161. My learned senior's point is very valuable point, Your Lordship. Why, Your Lordship, may kindly turn to page 144. His point is that he has been assessed before CGST, Your Lordship, by taking 100 crores, Your Lordship, and we have taken here 71 crores. And when we have issued notice and everything, he has never pointed out. He has said that 2023 the assessment has been completed by CGST. And
No, I have not done. I have not. Kindly have a glance to my reply. I have not said that. I have not done that.
Let me.
No, you are misleading.
Mr. Harichandan, is it a debate competition.
No, my lord.
You are all arguing, sir.
Sorry.
Argue. Let him. Then Mr. Mishra is making out a point. That's why from the very beginning, I asked Mr. Mishra whether he has verified the record that it is in the line of Janardhan case.
Janardhan,
Janardhan case is
so we have he has to take instruction.
in the assessment order.
Only my
Please listen to us, Mr. Mishra. In Janardhan case, on the simple ground that the assessing authority has recorded that he has given opportunity and the assessee participated. But in effect, you considered that no, that there was no opportunity. So on that ground, we have set aside for redoing the assessment. Right?
Your Lordship.
Here, some other point is taken. If you are considering that there is no natural justice granted, now you are saying that opportunities were given and he never turned up to say that there was double taxation.
Your Lordship.
Well, kindly have an Annexure 5, my reply.
So what do you want to say? Do you have any instruction? If you don't have the instruction, then please tell us you verify the record and come back on 5th or any other date.
Your Lordship.
After reopening, we are noting down your submission, Mr. Pranay, Mr. P.K. Harichandan for the petitioner, Mr.
I am for Union of India, Satyanarayan Patnaik, CGC.
P.K. Padis, senior advocate, DSGI, along with Satyanarayan Patnaik, CGC, for
Union of India, one.
Mr. For state, Mr. Suryanarayan Patnaik.
Yes, my lord.
Suryanarayan Patnaik for OP2. For 3, 4, and 5, Sunil Mishra, standing counsel.
Union.
Your Lordship.
Satyanarayan.
Both are Samasya Narayan. Suryanarayan Kotraj. Satyanarayan Chayavachan. 3, 4, 5 Mr. Sunil Mishra standing. It is submitted by the learned counsel for the petitioner that the petitioner's case is covered by the judgment of the coordinate bench dated 14 May 2026 rendered by the coordinate bench of Honorable the Chief Justice, in which one of us, into bracket M.S.RAMAN J, was member. The learned standing counsel shall obtain instruction in response to the said submissions. The matter shall be listed after the ensuing summer vacation before the assigned bench liberty to mention.
Specific date will.
Dates, sir, we have a limitation actually because it is not our assignment, becomes difficult.
But when an interim protection will be given, be 16th is the last limitation date.
Let him take instruction.
Let him take instruction. Let us see. So since there is liberty, so we can always mention.
Item 6.
May I please allow?
Yes.
Lord, the petitioner.
Mr. for the petitioner.
Let the petitioners 40 in numbers, my lord, they are working under the opposite party number 1 in the perennial nature of job, my lords, from 2014, 15, 16, like this, my lords, during the time of NESCO, and thereafter by this TPNODL. What is the TPNODL doing, my lords? Is changing the contractor, but the workmen, these petitioners are continuing, my lords. Now, by the next year,
Mr. Marana, will you accept notice?
My lords, I have instruction to appear in this case.
Okay.
Let's let a copy be served. Now, I'll take instruction if they.
Okay. So status quo as on date.
Let's.
Status quo as on today.
Yes,
shall be maintained. If whatever they will accept it. So it is not in their favor.
My lords, may May I pray, my lords, may I pray something if your lordship permits, my lords? Let
No,
the
you are
copy be,
always permitted.
my lords, my lords. My lords, let a copy be served. My lords, I'll
But
take
the
immediate.
difficulty is that for granting interim order, we don't have to seek any of your permission, neither Mr. Mishra or Mr.
My lords,
Maran.
my lords,
Because status quo as on date is not in favoring Mr. Mishra also.
Yes, my lord.
my lords.
He consists there.
That order may be passed. And my difficulty, my lords, I'm going out from tomorrow morning, my lord. That is the whole difficulty, my lords. I'll not be there. Your lords may call it after vacation.
But I mean, you are traveling.
My lords, from tomorrow onwards, I'll not be there. So what I pray your lordship may fix it to after vacation, and status quo order as on date shall be maintained, because
You have to accept. Yes.
Yes.
Mr. Maharana, you prevail over them, at least till reopening, if status quo can be maintained.
My lords,
We are only we are not passing in express order, but you talk to them.
my lords,
Because they are of perennial workers. Perennial, their job is perennial in nature.
my
And
lords.
I have a case for regulation, my lords. I have working from
Somnath
2014.
Mishra for the petitioner. Mr. State party na.
नहीं sir.
OERC को notice दिबो.
आइए समस्त को नोटिस ये एक्सेप्ट करिए ओपी नंबर 1.
ठीक है. चलो opposite party black. Opposite party black. Hard noted counsel for the petitioner. It is submitted that all the petitioners are continuing at present under the OP number 1, Tata Power North Odisha Distribution Limited. They are engaged in job which are perennial in nature. Through contractor, service provider.
Yes, ma'am. Through contract, paper arrangement.
Through service provider, oblique contractor. They apprehend disengagement and discontinuation from service, though they are entitled for regularization in their respective job. Stuff. Issue notice along with this order. Mr. L.K. Maharana, noted counsel, is present in VC. He submits that he has instructions to appear on behalf of the OP number 1. Let 2 extra copies of the writ petition be served on Mr. Maharana during course of the day. Notice to the OP number 2, 3 and 4 by speed post with registration and proof of delivery. With speed post with registration and proof of delivery shall be filed within, Mr. Mishra?
My lords. Within 3 days, my lords?
Within 3 working days. Within 3 working days. Since Mr. Maharana has instructions to appear on behalf of next delivery, appears and accepts notice. Name of Mr. Maharana. Upon कितने time name वकालत नामा पे Mr. Maharana?
Well, 3 days.
Mr. Maharana shall file his shall file duly executed wakalatnama on behalf of OP number 1 within 5 working days. On filing of the wakalatnama, name of Mr. Maharana, learned counsel and the learned associate shall be reflected in the cause list as well as the case brief. Stop. IE 103540 of 2026, hard learned counsel for the petitioner. He reiterates his submissions as noted above. Issue notice as above along with the writ petition. In the interim, it is directed that status quo regarding services of the petitioners under the OP number 1 as on date shall be maintained till the next date of hearing. The matter shall be listed before the assigned bench in the week commencing 13/7/2024.
Right.
Yes, Mr. Maharana, or you want earlier?
My lords, can it be a bit earlier, subject to your lordship's consideration?
Oh my, it's not, there is a problem if we add everything in other benches.
My lords, I bow down.
It becomes a problem.
My lords.
So let it be there so that liberty to mention. You have a
My
liberty
lords.
to mention.
My lords, may I pray, my lord?
Listed for orders, Mr. Marana.
My lords.
So Mr. For orders.
No problem, my lords.
Mr. For orders.
And may I pray, my lords, urgent certified copy, and your lordship may direct, they will act upon this website copy because.
Urgent certified copy as produced. The petitioner shall have liberty. Sorry, the party shall have liberty to act upon the copy of the order obtained from the official website of this.
Deeply obliged.
Let's only if your lordship may kindly record the objection in the IA only for the purpose.
No, because we are stating that then there is a problem. If you are not granting status quo, then you can have objection.
My lords.
If you record that, even if you are objecting for status quo as on date.
No, my lords, I could not hear your lordship.
I'm sorry. Status quo as on date, as on today.
My lords.
We could have directed
my lords.
Without leave of the court.
My lords, I did not. Could not hear it, my lords. Therefore,
no, Mr. Maran, it is like this. We can observe your objection to the interim prayer and direct no disengagement without leave of the court. That I'm asking you.
No, my lords, I could not actually hear that part. Therefore, my lords, I could not hear.
No, I'm actually, we are seeking your suggestion.
No, that will also do, my lords. That what
my lords, am I audible, my lords?
Yes.
My lords, status quo, if your lordship has recorded, my lords, I'll take notice and let it be there for orders.
Yes, status quo as on date.
My lords.
Yes.
Obliged.
Item 7.
Item 7, my lords. It's a tender matter pertaining to Odaga NEC Nayagat. If your lordship comes to page 30 for a moment, lordship.
Yes.
Page 30, serial number 3A, your lordship may see.
Yes.
This is an office memorandum issued by the Government Finance Department, which says that now the state government has been pleased to fix the following rate of service charge in outsourcing of services. The minimum service charge shall be 3.85.
You straight away come to the this advertisement inviting tender.
Yes.
Notice, or the detailed brochure. Whether
yes.
that is important. Because
yes,
that notification, unless it is mandatory for all the municipalities, notified
yes,
by the Economic Department, then that's a problem.
That is exactly my case. That is if your lordship comes to page 44. This was the Koraput municipality which had advertised for similar work. The lordship comes to page 44 of the rate application.
No, you are not getting it. Similarity, dissimilarity, we are not asking. We are not following. Koraput is not binding on the High Court also. If you say that this is a mandatory condition imposed by the HR department, the administrative department of the municipality, then so that.
Because annexure 2, for your lordship's kind consideration, your lordship sees annexure 2 at the bottom, point number 4. These instructions have deemed to be part of the Orissa General Financial Law. That means it's had a binding effect. It has a statutory effect.
That is a bit too much of extrapolation.
Well,
that unless notified, because you see the lowest bidder has to get it.
Yes, lowest bidder, but that
lowest bidder has to get it.
Yes, your lordship is absolutely correct, I bow down to that. So, as far as the office memorandum goes, it indicates the minimum service charge shall be 3.85. Now, if the lordship comes to the tender, which is the subject tender,
even at that price, 3.8 can be charged. You must understand.
Yes,
so that cannot be a matter of conjecture. Suppose 3.8 is the minimum, so they will charge 3.8.
Yes.
So even in the lowest price.
Yes. Because, so if your lordship comes to what they have done, well, the reason I was showing your lordship page 44 is, your lordship must just for a moment have a look at page 44. I'll bow down to your lordships. Page 44.
So your problem is that you are seeking implementation of 11/7/2023 for the municipality.
Yes.
You can take notice that much.
No,
but the general principle is that lowest bidder is to get.
Yes, I am not on that, my lord. If the lordship kindly appreciate. For a moment, page 25.
You were a participant?
Yes.
Are you the lowest bidder?
I am not the lowest bidder.
So you take notice. That much. That much help you can render.
Lordship will kindly appreciate. I'll come just 2 minutes.
No,
if the lordship gives me please 2 minutes.
After appreciating your point, only we are speaking to you. So otherwise, you could not have remained silent. You have also understood. You are saying 23.7 that circular 11.7.23 is mandatory and they have not followed it. That is your point. So for that, you are imagining that even the lowest bidder will not follow that. They may follow, they may not follow. So that we cannot say.
No, I'm not on the. If Lordship may bear with me for 2 minutes, just 2 minutes.
No, you take exactly 4 minutes.
No, what they have done.
The problem is that after you speak for 4 minutes, we'll again ask. Then it will be wastage of time.
No,
so
Your Lordship they have already, what they have done, they have gone below 3.85. If Your Lordship comes to page 55.
You see, if whether it is 3.85 is mandatory or they will go, because you see, now the mantra is lowest bidder. So whether 3.85 or 3.3, that will be adjudicated. We cannot stay that or we can't find fault with that. If you want,
my submission before Lordship is, if entire tendering, all the bidders are submitting their bids in terms of this office memorandum, which has a binding effect in terms of 3.85, then they could not have accepted. If Your Lordship comes to page 55 of the writ application.
You have missed the point we told you that even the lowest bidder has to comply with 3.85 even after being succeeding. He cannot wriggle out of that.
Yes.
So you are reading it differently. You are saying that since he is successful, he will not give it 3.85. That's not there.
No, my lord. Your Lordship comes to page 55 for a moment.
So whether you want issuance of notice or not, that we have been asking you.
My lord, Your Lordship, I'll be deeply obliged, grateful if Your Lordship comes to page 55 for a minute.
No, we are already there in 55 because we are in paperless. It does not become difficult.
Yes.
We are not turning pages.
Serial number 7 and 9. If Your Lordship sees 3.24, 3.24. And others also 3.24. What they have done at the bottom, lowest amount quoted, CORAM, securities.
Mr. Nanda, you can replay in YouTube how many times you have said that he will be compelled to give 3.85. At least this is the 5th time I have since I am speaking for my brother also. You are saying that you are presuming that he will not pay 3.85 or 3.24. So if that is a defect, let us see. We can't find a fault with that.
My lord, they have already given less than 3.85. That is my case before Your Lordship. They have already offered less than 3.85. They were given 3.24.
Correct. So 3.24.
And on the basis of that,
he can be compelled to give 3.85. No difficulty.
My lord, they have already. The final list is at page 59.
As many times you have said they have already given 3.24. So many times you have said that he can be compelled to give 3.85. That is a different issue altogether. But since you are not the lowest bidder, he is the lowest bidder. So we have to hear him.
No. Your Lordship, my case is that the authorities are not following the mandate under the office memorandum for which
Mr.
the
Nanda,
other party which...
Mr. Nanda, if the authorities will award you, they will be good. If they award the lowest bidder, they are bad. Could be. But that we have to adjudicate. That we have to adjudicate. That by awarding, that requires adjudication. Not simply sit there by saying, if you do not want issuance of notice, either we will dismiss it or you want adjournment, that we can say.
No, I want the opposite party number 2 to dispose of, take a reasoned decision on my representation under Annexure 6, my lord.
No, representation disposal is not at all urgent. It has to wait after vacation.
My lords, if Your Lordship is saying that this has to be decided with regard to whether 3.85 is binding or not.
Lordship is not saying. Lordship is saying. Lordship will issue notice. They will respond. Then we will decide. You are saying that 3.85 is the mandate. They have not followed 8.5. They have given it to the lowest bidder. That we may not find fault right now.
And you have not made the L1.
L1 has to be heard.
No, he has not been a party.
Make the L1 a party, Mr.
I'll make party. What I'm saying is I'll take the notice by special messenger both on writ petition and IA. Your Lordship,
nothing, no special messenger. We do not have persons in vacation. You take by speed post. Speed post is faster than special messenger. And you implead the L1A party.
Yes.
Today you will implead or you will adjourn it?
Today I will implead.
By oral prayer.
Lordship, I implead on the oral request. I'll file.
Name and address को आपण देबे ताले. ठीक अछि. Hard Lorette Sudarshan Nanda Lekili. OP2 Huchonti, Mr.
DK sir.
Mr. Sahoo is there. Yes, Mr. DK Sahoo.
Yes.
AG for OP2. OP1 blank. Hard Lorette counsel for the petitioner. The petitioner is a competing bidder. Pursuant to the tender call notice dated 10/4/2026 into bracket annexure 1. For several works, single work.
Single work in Odaga Noyagarh district in Odaga NSC. Odaga NSC.
For like for work under the Odaga NSC in the Noyagarh, the district of Noyagarh. The learned counsel for the petitioner refers to the finance department notification office memorandum dated 11/7/2023. Particularly the paragraph 3A and B, 3 into bracket small a, 3 dot small a and 3 dot small b. To submit that, the said finance department memorandum is pursuant to the Department of Expenditure, Ministry of Finance, Government of India. Minimum rate of service charges with a office memorandum dated 6/1/2023. Then the learned counsel refers to the summary and details of BOQ. What a BOQ done?
Say BOQ annex to 7. They were
Now,
L1 sir,
then he refers to the annexure 4 of the writ application, that is e-procurement system, Government of Orissa, giving the details of the bids furnished. He submits that.
Financial
bidder. Serial number 7.
7 and 9 both.
The bidders
are there,
serial number 7 and 9 have quoted the percentage of
9
service charge at rupees at 3.24%, which is less than 3.85. Similarly, the bidders at serial number 12 and 13 have bidded have offered at 3.25, and bidders at serial numbers 12 and 13 have also offered at 3.25%, which is below 3.85. It is further submitted by the learned counsel for the petitioner that the petitioner shall implead the lowest bidder who is successful pursuant to the bidding.
And sir, 2 L1s.
Tender process.
2L at page 59, 2 L1s.
By filing appropriate memo, and he may be permitted to carry out the necessary corrections in the constituted page of the brief. Prayer for adding party, prayer for adding the lowest bidder as party is allowed. Issue notice along with this order with the opposite parties, to the opposite parties. The learned AG upon advance copy served appears and waives notice on behalf of OP number 2. Issue notice to OP number 1 and newly added OP number 3 by speed post with registration and proof of delivery. Requisites for issuance of within 3 working days. Fine.
Yes. Your Lordship, at page 15, the 2 L1s. If your Lordship says Sriram and Alim, both are L1.
L1 plural kar diyo. Lowest tenderers. Upon that, bujivar kale instruction nahi naanti ho. Successful kiye lowest. So
issue notice to not decided.
That is the problem. They have participated. Bid has been opened.
Since they have not yet decided.
Requisites for issuance of notice by speed post with registration and proof of delivery within 5 working days. 1, 3 and 4. आइए लिखिए at ordered counsel for the petitioner. He reiterates his submissions as noted above. Issue notice as above. In the interim, it is directed that any action taken pursuant to the tender call notice, so and so, by the organization, so and so, shall be subject to result of the petition and shall abide by the orders that will be passed by this court. The matter shall be listed for orders in the week commencing. What is it? Bujichandi kete opening hearing anti the week commencing for orders in the week commencing 13/7, Mr. Nanda.
Yes, madam.
13/7 before the assigned bench. Liberty to mention.
Just small. Is it possible second week of
6/7
say
last week
second week of
last week 38 second 6/7 ठीक है 6/7 करते हैं. What problem is that we cannot predicate I mean the listing of other
yes.
that list कॉल है किंतु हो.
You know, she may say week commencing, that will be appropriate.
हाँ week commencing 6/7 पर liberty to mention.
Deeply obliged.
ठीक है सेटा ठीक है आपण जदी जेतु रिमोट लोकेशन रे अछंती ठीक है सेटा को केमती करिवे करि दियंतु.
My lord.
Notice has to be requisite file of notice issue of.
I am filing the memo, trying to file the memo today itself.
नहीं correction करिवे ना कोर्ट आपनकर कोर्ट ब्रीफ रे करिया पड़िबो सेटा.
I'll carry on.
And instructive.
I assure you. Yes.
So Lalitendu Misra.
My lord. My lord, for kind permission, my lord.
Yes.
My lord,
Yes, please.
Batch of writ petition 8, 9, 10 তিনটা আছে. I may humbly request, my lord, item 9 जोटा আছে के से फाइलটা 17329 से फाइलটা টিকে my lord kindly.
সেটা fees related না auspicious number.
I guess it's a document সেটা দেখে please. It's same, so all are similar. Competitive bidders, they all are before my lord. I will demonstrate, my lord. Say item 9 টা টিকে my lord by pray. So 17329 of 2026.
गोटे टेंडर ना अलग अलग टेंडर.
गोटे टेंडर वर्क गुडा नेचर ऑफ वर्क के तीन चारटा अछि तो सेति.
तो तले अलग काम
गुडा अलग बट टेंडर कॉल नोटिस
जो आपनकर जो तीनटा रिट पिटिशन फाइल करिसंती समस्तकर काम अलग.
समस्त काम अलग.
अच्छा
किंतु क्लॉज टा मु
मतलब एटा नुवा कांसेप्ट बालणी जो सर्विस मैटर बळे बैच केस बैच टेंडर. Yes.
Your lordship may kindly see the competitive bidders before my lord. They have challenged the selection of L1 opposite party number 3, my lord. Where my lord kindly see annexure 2, page 153, where the technical bid evaluation was made.
Yes.
153 annexure 2.
Yes.
And relevant page 154, my lord, kindly see that is Hon'Ble, serial
Yes.
number 4, construction of Sapoi Sahi and work, not the nature of work. Serial
Yes.
number 7 is petitioner before my lord. 7 is Sanjeev Kumar Singh qualified, and Bisudit Sahoo L1 is the qualified. But what happened, my lord? There is a tender clause is there. There's 2.7.1 that a bidder should, my lord, has to maintain transparency and to disclose about the bid capacity. Your lordship may kindly, I will take you lordship kindly page 57. That is the clause where my lord, the authority have overlooked and the lowest bidder has suppressed the aspect, though that is before the subject matter of kind consideration. Page 57. The
सेवन जोटा Hon'Ble 7 रे देखिले
आज्ञा
आपण सक्सेसफुल बिडर की
सक्सेसफुल होची बिस्वजित साहू opposite party number 3. All are successful. से माने सबु जो डिक्लेयर हला तांकर जो रिजल्ट अवार्ड हिची जो तांकर सिलेक्शन
आपण केते नंबर सीरियल रे अछते
आज्ञा दोछि सेटा यू लॉर्डशिप काइंडली सी
सेटा कहले
160 lordship that rightly your lordship was asked me page 160 annexure 3
160 रे आपण अछती
Not legible.
अछि
देखा जाउन
କିଛି ଦେଖା ଯାଉନି ସେଥିରେ।
4 serial
Next
number
ଆଜ୍ଞା
4
serial number
serial number 4
ଆଜ୍ଞା ତାପରେ
ରାଜୀବ
8 ସେ ବିଶ୍ୱଜିତ
ରାଜୀବ
ସାହୁ
କୁମାର
ମୋର ତ କଣ ମୋର ରଘୁନାଥ ଅଗ୍ରୱାଲ ବାହାରିଲା
4
160 ରେ 4
ରାଜୀବ କୁମାର ଅଛି
ରାଜୀବ ଆଜ୍ଞା ଏଇ
ଚାରି
ପିଟିସନ
ନମ୍ବର
ହଉଛି ଆଜ୍ଞା ସଞ୍ଜୀବ କୁମାର ସିଂ ସଞ୍ଜୀବ ସିଂ
17329
ଏଇଠି
ଆପଣ କୋଉଟା ଖୋଜୁଛନ୍ତି
ସଞ୍ଜୀବ କୁମାର ସିଂ ଆଜ୍ଞା
ସେ ଖୋଲୁଛନ୍ତି 17329 ସେ ପ୍ଲେସ୍ କରୁଛନ୍ତି
ଆଜ୍ଞା ମୁଁ ସେଇଟା ପ୍ଲେସ୍ କରୁଛି ଆଜ୍ଞା 17329 ଆଇଟମ ନମ୍ବର 9 ଟା ମୁଁ ପ୍ଲେସ୍ କରୁଛି ଆଜ୍ଞା
ସଞ୍ଜୀବ କୁମାର ସିଂ 7 ନମ୍ବରରେ ଅଛନ୍ତି
7 ନମ୍ବରରେ ଅଛନ୍ତି 8 ନମ୍ବର ଅଛନ୍ତି ବିଶ୍ୱଜିତ ସାହୁ ଯିଏ L1 ହେଇଛନ୍ତି ଆଜ୍ଞା
ହଁ
ଓପି ନମ୍ବର 3
ଆପଣ କଣ ଡିସ୍ପ୍ୟୁଟ କରୁଛନ୍ତି ଯେ ତାଙ୍କର ବିଟ୍ କ୍ୟାପାସିଟି ନାହିଁ
ତାଙ୍କ ବିଟ୍ କ୍ୟାପାସିଟି ନାହିଁ ଆଉ ଅଥରିଟି
ସେଇଠୁ
8.6
ସେ ଆପଣ କେମିତି ଜାଣିଲେ ବିଟ୍
ଆମେ
କ୍ୟାପାସିଟି ନାହିଁ
ଜାଣିଲୁ my lord kindly see already my lord I have handed over one document
ଆପଣ ଏଠି ହ୍ୟାଣ୍ଡ ଓଭର କରନ୍ତୁନି ହ୍ୱାଟ ୱାଜ ଦ ମେଟେରିଆଲ ବିଫୋର ଦ ଅଥରିଟି ସେଟା କହିବେ ନା ଆପଣ ହ୍ୟାଣ୍ଡ ଓଭର
ଆଜ୍ଞା ଆଜ୍ଞା your lordship may
What was the
kindly see
material before authority which the
Yes.
authority ignored?
yes my lord kindly 161 my complaint
Complaint ପୂର୍ବରୁ ତାଙ୍କର material କଣ ଥିଲା?
material ଦଉଛି ଆଜ୍ଞା ମୁଁ ଦେଖେଇ ଦଉଛି ଖାଲି ମୁଁ କହୁଛି କଣ କଣ ସେ ସପ୍ରେସ୍ କରିଛନ୍ତି ତାପରେ I will come to minutes kindly see page 161
ଠିକ ଅଛି ନୋଟିସ ନିଅନ୍ତୁ ଆପଣ କିଛି material ଆପଣ you are not answering whether there was any material on part before the authority which they could have. So the point would be that
My
they
lord,
failed to take relevant materials into consideration.
my lord
ସେଥିରେ ଆପଣ ନାହିଁ ଆପଣ ମ୍ୟୁଟ୍ ରହୁଛନ୍ତି ମାନେ ନାହିଁ ସେଥିରେ କିଛି
ନାଇଁ
ଆପଣ
ଆଜ୍ଞା
କମ୍ପ୍ଲେନ କରୁଛନ୍ତି ଆପଣ କମ୍ପ୍ଲେନ
କରିଛି
ଶୁଣୁନାହାନ୍ତି
ଆଉ ଯୋଉ L1 ଟା ଆଜ୍ଞା ସେ ଡିସକ୍ଲୋଜ କରିବା କଥା 2.7.1 ରେ ଫେୟାରଲି ଟ୍ରାନ୍ସପରେଣ୍ଟଲି ସେ କହୁଛି ମୋ ପାଖେ ଏତିକି ଲୋଡ ଅଛି ଯୋଉଟା କି ସେ ସପ୍ରେସ୍ କରିଛି ଯୋଉଟା ମେମୋରେ ଦେଇଛି
ସେଟା ତ ଆମେ ଟେଣ୍ଡର କରିବୁନି ନା ଆପଣ ସେଥିପାଇଁ the question is that what is the material before the authority to arrive at such conclusion we cannot second guess
well I bow down lordship materials were raised before the authority that
ନାହିଁ ଆଉ ଆପଣ ତ କମ୍ପ୍ଲେନ ଆପଣ ମ୍ୟାଟେରିଆଲ ଥିଲେ ଦେଖେଇଥିଲେ ଆପଣ ତ କମ୍ପ୍ଲେନ ରୁ ଆରମ୍ଭ କଲେ
ଆଜ୍ଞା କମ୍ପ୍ଲେନ ଲେଖିଛି ଏତିକି ତିନିଟା କାମ
ଠିକ ଅଛି ଆପଣ ଡିସାଟିସ୍ଫାଇଡ୍ ପାଇନାହାନ୍ତି କମ୍ପ୍ଲେନ କଲେ
1 2 3 there are 3 works they have suppressed they have three suppressed
that it has been compared.
1 2 3 the 3 works have been suppressed
ନାଇଁ ସେଇଟା obviously Mr. Mishra when he remained silent your instruction is that they have complied
no my lord I am not my lord I am complaining
so it's a matter of it's a matter of argument let us see
the lowest bidder has suppressed 2.7.1 and the authority has
so
not
Mishra,
acted
whatever you will say yes Mr. Naik says we will say
yes.
no
And
Mr. Naik says
8.6
no
authority has to acted upon 8.6 authority has to look into 8.6 there are two conditions nothing
we are not evaluating the tender or you are
I
not.
bow down
So
I
let
bow
us
down
see,
lordship
let us.
my grievance before my lord
for the petitioner is a competing bidder for the work for the tender for pursuant to the tender notice dated 8/8/2025 issued by the opposite party number 2 authority
yeah see
he challenges the selection of OP number 3
my lord
being the lowest bidder for the work को work टा कहबे टिके
ଆଜ୍ଞା work
से दुसुनी आपण
ଆଜ୍ଞା
से आपनकर
work होची आଜ୍ଞा that is page 150 54 रे आଜ୍ଞा अछि that is work construction of Satoposi to
आपण न पढी की just point out 154 रे the serial number
4 serial number 4 Sapoisa sorry serial number 4
quality stopper बोले पारा माने सीरियल नंबर 4 अछि
4 रे से लिखा
construction of
अछि
Sapoisa
अब कॉस्ट लिस्ट कॉस्ट टाइटल लिख दीजिए आज्ञा सब थरे
Sapoisa सेटा तो
आज्ञा आज्ञा
is a bidder for it selection of it is submitted that the authorities, the tender selecting authority has not followed the due procedure for evaluating the tender in as much as the disclosures
2.7.
made by the lowest bidder are not correct. Stop. Issue notice along with this order. से आपण प्रोफर्मा को नेबेनी नोटिस एबे
प्रोफर्मा को आज्ञा देबी
अच्छा ठीक सो नोटिस along with this order Mr. Nayak Lord AG
Yes.
upon advance copy served appears on behalf of the opposite parties 1 and 2 आपन का कॉपी दरकार पड़ो
No, yes, I have already received.
अच्छा ठीक है वो पदन नोटिस भी इशू ये आपण
ना
बुझी देबे ना
Blood, the opinion number 3 has suppressed 2.7.1. My submission that may be recorded.
सेटा
I objected also.
Mr. Nayak aggressive हे गेलनि से करंट जागा सब आपण सब सप्रेस करछन कोर्ट आगे that is a
Yes.
serious allegation
Yes,
so
yes.
we have to
I
report
never.
that
I never.
so कौन लिखले कौन notice be issued to the opinion number 1 and 2 notice to opinion number 3 as well as pro forma opinion number 4 be issued by speed post with registration and proof of delivery. Requisites for issuance of notice be filed within 5 working days. So, the learned AG submits that he has received instructions that due procedure has been followed in evaluating the tender. However, he shall file counter on behalf of the opposite parties. Stop. Counter affidavit on behalf of the opposite parties shall be filed. How much time, Mr. Nayak?
4 weeks, madam.
Sorry, sir.
4 weeks. Madam, 1 week after reopening, madam.
अच्छा ठीक है shall be filed by 3/7/2026. The matter shall be listed before the assigned bench for admission in the week commencing 20/7/2024. Stop. IA 1046/7 of 2026. Hard lauded counsel for the petitioner. He reiterated his submissions as noted above. Issue notice as above. Accept one set of process fee as well as postal requisites along with the writ application. The lauded AG submits that he shall file counter. Stop. The counter, he shall file his response. The response of to the IA shall be filed along with the counter. Stop. In the interim, it is directed that action taken pursuant to the tender call notice for work the work जो अपन लिखते Sahoo or something shall be subject to result of the writ petition and shall abide by further orders to be passed by this court. The matter shall be listed for admission in the week commencing to date police posing 20/7/2024 liberty to nature.
Item number 8, my lord.
So say 8.
In item number 8. In item.
दीटा को खाली लिखा है जी कॉज लिस्ट रे कॉज टाइटल नेचर ऑफ वर्क बाकी रिमेन सेम टेंडर कॉल नोटिस इज डेटेड 8/8/2025 कल वर्क
से भी सापुआ आपण कहले
नहीं सापुआ नो एटा या सेटा
से कहबे ना से भूल भाल हो आगे ना
हां मु कहबे
when there is an entry order we have to be because these are public work.
I just only submit
गोटे काम तापे आ गोटे ऑर्डर हे गेला माने आ गोटे केस सेटा इम्प्लिकेटेड हे गेला
17 आइटम नंबर 8 17327 रे सेटा होची आज्ञा कॉज लिस्ट आप पेज 1 ने
मिस्टर जस्ट गिव अस ए मोमेंट मिस्टर साहू बोधे अपियर करनी सो जस्ट गिव अस
Item number 8, my lord. Item number 8 I am for 1 and 2.
हां आइटम नंबर 8 लिखम तो मिस्टर डीके साहब
मतलब no proper opposite party there. In item number 8, my lord, there is no
ଆପଣଙ୍କର 8 ରେ 4 ନା ନୋଟିସ୍ 3 ଅଛି जो वेस्टर्न नोटिस ଅଛି
and nature of work different, my lord.
से मिस्टर मिश्रा नेचर ऑफ वर्क देखंतु
देखो अछि पेज 1 पेज फर्स्ट पेज रे आज्ञा ए रे लिखा अछि कंस्ट्रक्शन ऑफ पीडब्ल्यूडी रोड
ठीक है पेज आउथरे कोंतु ठीक है सुबिला
ए फर्स्ट पेज ऑफ द ब्रीफ my lord second after index Cost list.
ନାଇଁ
Cost
ଆପଣ
item.
ଆନେ ଆପଣ ଡିଟେଲ ଇଏରୁ ଦେଖାନ୍ତୁ ଟେକ୍ନିକାଲ
Detail, again, detail
notice ରୁ
ଦେଖୁଛି.
ଦେଖାନ୍ତୁ
That is page number, my lord, 153. Annexure 2.
ସିରିयल ନମ୍ବର 153
Serial number 3. 3.
ଏ ଯୋଉ ପିଡବ୍ଲ୍ୟୁଡି ରୋଡ ବିଜା
ଆଜ୍ଞା।
ମଠ ଛକ ଟୁ ରୋହିଳା ରୋଡ
Very grateful, my lord. Yes, that is.
ସେଥିରେ ଆପଣ ଅଛନ୍ତି ଆପଣ
ଆଜ୍ଞା ମୁଁ ସେ ଅଛି ମୋ ନାଁ ଅଛି ଆଜ୍ଞା
ରାଜୀବ କୁମାର ମହାନ୍ତି
ରାଜୀବ କୁମାର ମହାନ୍ତି।
ଆଚ୍ଛା 5 ନମ୍ବର ଅଛନ୍ତି ଠିକ ଅଛି ତାହେଲେ ଏମିତି ଆପଣ ବହୁତ ବ୍ରିଫ ତ ଆପଣ ଦେଖିଲା ବେଳକୁ କୋଉଥିରେ ପାର୍ଟିସିପେଟ କରିନାହାନ୍ତି ରିଟ୍ ଫାଇଲ ହେଇଗଲାଣି ଅଛନ୍ତି ଆପଣ 5 ନମ୍ବରରେ ଅଛନ୍ତି ଠିକ
ଆଜ୍ଞା
ଅଛି
grateful, my lord.
ତାପରେ 10 ରେ
10 ରେ ଆଜ୍ଞା
My lord, I am appearing, my lord, for this state.
1 and 2.
For 1 and 2, my lord, I am appearing.
10 ରେ ମିଷ୍ଟର ସୂର୍ଯ୍ୟନାରାୟଣ
And my lord, opposite pet number 3 is the successful bidder.
ଏଇଟା କରନ୍ତୁ ତ 8
ନାଇଁ 10 ବି ସମାନ କହୁଛୁ 10 ବି ସମାନ ନା
ମାନେ ପ୍ରଥମ ନାହାନ୍ତି ଖାଲି ନେଚର ଅଫ ୱାର୍କ ଟା 156 ରେ ଅଛି ଆଜ୍ଞା
ନାଇଁ ଆପଣଙ୍କ ସବମିଶନ ଏକା ତ ମାଇ ଲର୍ଡ ଇଜ ଆସ୍କିଂ whether submission is same ଯେ ଇଭାଲୁଏସନ ଭୁଲ ହେଇଛି ବୋଲି
ଆଜ୍ଞା ଆଜ୍ଞା ଇଭାଲୁଏସନ ଭୁଲ ହେଇଛି ସପରେସନ ଅଫ ବାଇ ଦି
ଆପଣ କମ କୁହନ୍ତୁ 3 ଜଣ ଛିଡା ହେଇଗଲେଣି ଆପଣ ବର୍ତ୍ତମାନ କେସ୍ ଡିସମିସ ହେଇଯିବ ଫେରେ
ଆଜ୍ଞା
all three AGs have stood up ଆପଣ ଫର୍ମିଡେବଲ ଅପୋନେଣ୍ଟ ଆପଣ
महिला read petition 17335 item 10 ने my lord kindly see page 156 nature of work.
Just 1 second. We will go step प्रथम appearance ରୁ ଯିବା ठीक
my lord
just give us a moment.
The opposite pet number 1 and 2, my lord, I am appearing.
ଆଜ୍ଞା 1 and 2 Mr. Suryanarayan
is the successful bidder. Opposite number 4 is the performer party.
ତାହେଲେ 3 ଆଉ 4 ଟା ସେଇ 9 ଭଳିଆ ତ 3 ଆଉ 4 ଅଛି
ହଁ yes great
ଘରେ ଅଛନ୍ତି ସେ ଆପଣ ଏଥିରେ ଆଜ୍ଞା ପାର୍ଟିସିପେଟ କରିଛନ୍ତି ମିଷ୍ଟର ମିଶ୍ର ସୁନିଲ କୁମାର
ଆଜ୍ଞା
ସାହୁ
ପାର୍ଟିସିପେଟ କରିଛି ସୁନିଲ ସାହୁ serial number 2
page
156 that is
just give us a minute. page 156 କୋଉ କେତେ ନମ୍ବର
serial number 2 ରେ ଆଜ୍ଞା ସୁନିଲ କୁମାର ସାହୁ qualified
ନାଇଁ କାମ ସିରିୟଲ ନମ୍ବର ଆଜ୍ଞା
9 top mirror top 9 left side
156 serial number 9 the construction of Ambapala High School
ଆଜ୍ଞା
Ambapala এটা লেখিলো yes
my lord grateful my lord obliged
yes,
my lord
yes,
one more submission I have today morning I have my lord handed over 2 memos before for my lord's consideration before the court master
it is there
that may be taken to record
yes କୋଉଥିରେ ସବୁଥିରେ ଦେଇଛନ୍ତି
ସବୁଥିରେ ତିନିଟା ରିପିଟିସନ ରେ ଲେଖିଛି
ଆଚ୍ଛା ଠିକ ଅଛି କପିଟା ସର୍ଭ କରିବେ ଟିକେ
ଆଜ୍ଞା କୋର୍ସ ଅଫ ଡେ ଆଲ୍ ସର୍ଭ ଦି
କପି ଦେଇନାହାନ୍ତି
ଲଣ୍ଡନ ଷ୍ଟେଟ୍ କାଉନ୍ସିଲ ଦେଇନି ଆଜି ଦେଇଦେବି
ମେମୋ ଦେଖୁ ଲାଷ୍ଟ ଲେଖନ୍ତୁ ମେମୋ ଦେଖୁ ଆଜି କେତେ 2 ତାରିଖ the memo of date is submitted by the is filed by the learned counsel for the petitioner enclosing a document এটা ଆପଣ actually amend କରିକି annexure କରିଦବା this does not work well ସେ ତାକୁ ଫେରେ ଖୋଜିବେ ଇଏ କରିବେ କଲେ submitted document signed by the petitioner ସବୁଡାକ
ନାଇଁ signed by the Millard, the document of the lowest bidder Biswajit Sahu, the opposite party 3.
এটা କୋଉଠୁ ପାଇଲେ ଆପଣ
ମୁଁ ପାଇଲି ଆগে ଅପଲୋଡ କରିକି ଆଜି ପାଇଲି
ଆଚ୍ଛା which is signed by the which he states is signed by the successful bidder and the petitioner has obtained from the official website.
Well, about the 2.7
memo shall be taken on record, scan copy be updated. The petitioner shall amend the writ application to enclose the said memo, said document as annexure. Said document marked as annexure. Stop. A copy of the memo shall be served on the learned AGA during course of the day. Yes, serve କରନ୍ତୁ actually ଆଗ serve କରିବା କଥା take up ହେଲା ପୂର୍ବରୁ
obliged minute grateful I'm not certified copy and uploaded website copy I will do it
acha urgent certified copy as per rules the party shall have liberty to act upon the copy of this order obtained from the official website of this court. Yes.
Obliged.
Item 11
May I please your lordships? Let the petitioner, one of the bidder in respect of tender call notice invited by the Odisha Police State Housing Welfare Corporation. Annexure 2, serial number 2 is the subject matter of work, your lordships. Page 26, your lordship.
Yes. Okay.
The serial number 2 of work, page 26, your lordships. The construction of Atal bus stand B type Badampur under Rajbura Sambar block, Bargad, your lordships.
Yeah.
The tender criteria provides, if which I am disqualified under 110M, that I am securing less mark. The 110M stipulates, 7 entries, each has different.
So you are challenging your disqualification.
Exactly, and selection, because I am the lowest one. If my price will be considered, then it will be state interest, That is also second ground.
Okay, you take notice. So 7 is the successful bidder.
Yes, your lordship.
So,
My lord, for 1, 2, 3, my lord, 1, 2, and 3, I am appearing for the state, my lord.
Yes.
And
noted. Mr. Prabodh Chandra Nayak for the petitioner, Mr. Subhavikas Panda AG for OP number 1, TO2, 3. Baki सब notice jibo.
My lord, I am a submission, my lord. Annexure 5 is the representation, and also in the prayer that the arbitrary decision has been taken by the authority. He asked for,
since in one matter.
My lord, he asked for a speaking order, my lord. He asked for a speaking order. My lord, your lordship may kindly observe that pendency of the writ petition may not stand on the way in passing a speaking order.
No, we are not observing that because there is no urgency there. For representation disposal is not urgent, should not have been listed at all actually.
Yes.
The first prayer, my learned senior is not placed also. Disqualifications.
No, obvious. Your substantive challenge to disqualification. The petitioner is you are a company or a partnership firm, or how you describe yourself. The petitioner is a partnership firm having participated and has participated for the work construction of Atal bus stand. Into bracket B type at Padampur under Rajboda Sambar block, Bargad. That Padampur NSC rate not a state project.
The state police housing.
Pursuant to tender call notice dated number dated 30/2024.
Yes.
He having been unsuccessful, being selected as disqualified, having scored less mark in the competitive bidding, challenges the said decision. Stop. It is submitted that the marks given to the petitioner bidder is not based on reasons and is contrary to material available on record. Stop. Para issue notice along with this order. The learned AG, the learned AG appears on behalf of the opposite parties 1, 2, and 3. Upon advance copy served and waives notice. Stop. Notice to OP number 4, TO27. Be issued by speed post with registration and proof of delivery. Requisites for issuance of notice shall be filed within 5 or 3.
Please.
Within 5 working days. Stop. The matter shall be listed for admission before the assigned bench in the week commencing today. Mr. Nayak Kodie. The week commencing. Na 27 ହେଲେ ଚଳିବ.
20 था भाई.
तो 27 24. Para. Liberty to bench. IA 10436 of 2026. Hard learned counsel for the petitioner. He reiterates his submissions as noted above. Stop. Para issue notice as above. In the interim, it is directed that accept one set. Issue notice as above, accept one set of process fee as well as postal requisites along with the writ application. In the interim, it is directed that action taken pursuant to the notification tender call notice for the work so and so shall be subject to result of the petition and shall abide by the orders to be passed by this court. So data to last 2 days listing data. Liberty to mention no. Yes.
Lord, I renew my prayer for using up soft copy, my lord. That is my
Original certified copy as per rules. Issued as per rules, the parties shall have liberty to rely upon the sentence to act upon the copy of this order obtained from the official website of this court. Yes, please.
Item 12.
Item 12, my lords. My lord, item 11. We may dispose of the representation in the meantime, my lord. That representation.
I believe, my lord, my learned senior is not the tender authority. Police I think ought to dispose of. Is the tender we grievance to post. State is not nothing because state is the only country.
Again, chairman is different. Yes.
I'm a police house chief engineer. He's not before your lordship at present.
Mr. Milan Kanungo, senior advocate, allocate Mr. Soumyaranjan Mahathi for the petitioner.
My lords, may it please your lordships?
Yes, please.
Am I audible, my lord?
Yes, please. Yes, please.
My lord,
there is little bit difficulty in audio. Okay, but we hope we are also audible.
Yes, my lord.
Yes, my lord.
Am I audible right now?
Yes, yes. Yes, please.
My lords,
yes, you are audible, Mr. Kanungo.
Yes, my lords. Maybe I was sitting a bit far away from the mic, my lords. My lords, in this case, what has happened, it's a matter covered by your lordships. What had happened, my lords, I had emerged successful as for a Blackstone quarry. Now, for 5 years, the lease was not granted to me because of some PIL filed, my lords. Ultimately, after 5 years, my lords, they arbitrarily cancelled my lease, which I challenged before your lordships, and the ultimate cancellation of lease was set aside. Anyway, that is a matter which is already over, and this honorable court asked the government to take a fresh decision in the matter. Now, what happens, my lords? A special petroleum reservoir has come about in that Dankari area, for which, my lords, obviously for larger public interest, my lords, the leases have been taken away from us. We are fine with that. Now, keeping in view the tremendous amount of money that we have invested and, my lords, the clearances, all the clearances we have obtained, the mining officer recommends that the government may consider our case in its proper perspective. Now, unfortunately, the DDM rejects the application, saying that I have no jurisdiction to decide such matters. Now, my lords, we are not asking the DDM to decide these matters, the director of mines. It has to go to the government, and the government will consider my case under Rule 64.
Rule 64 ought to have
Exactly,
been
my lords.
invoked by the government, which we directed
Yes, my lords.
actually.
Yes, my lords. This is Annexure 10.
That order is there. You have annexed.
Yes.
Annexure 10, my lords.
10.
41.
So, yes, Learned AG, I mean, what prompted the DDM to say that because it is the authority. The court directs the authority to decide. Kindly look at page 41.
Mr. Subhakonda, kindly come to page 43, paragraph 5. We have extracted the rules.
My lord. Yes.
64.
Yes, ma'am.
In particular.
Yes.
Rule 64.
Yes, ma'am.
So we ultimately we directed the petitioner to approach.
5.1 you can go through, Mr. Panda.
But my lord,
after 64, 5.1 is the direct direction of the coordinate bench.
Annexure 9, your lordship may see page 40, has been passed by the mining officer.
So he should not have done that. He has not read the court's order. Kindly read first 5.1. Then you go to the mining officer's orders. Kindly read the order of the court, coordinate bench, 5.1, page 43.
My lord, the mining officer has not referred to the honorable court's order because the honorable court's order is dated 19/5/2026.
No. My lord, there is a slight confusion. My lord, this is
Only after
an
one
order.
day, my lord. Only after one day, my lord, the mining officer has passed this order. Perhaps he has not seen the order of the your lordship.
No. My lord, there is a confusion. This order relates to another mine. What I am trying to submit from this order is, my lords, the mining authorities
State order
don't
can
have
be
any.
passed. Perhaps Mr. Kanungo's submission is that the mining officer not looking at 64 is already answered by the coordinate bench.
Yes. He has to refer the matter to the government for consideration
Instead
under
of
Rule
rejecting it
64.
because he is not the authority to reject or to grant. That's the point.
Yes.
So same order, same order.
Mr.
Same order.
Kanungo, Mr. Kanungo, are you suggesting that only name would be changed instead of PJ Mineral? Your petitioner's name would be there. Rest of the order
Rest of the
remains
facts.
intact, and you will
Exactly,
approach
my lords.
the government.
Government, state government.
Yes.
And my lords, in paragraph 2, the query name will be changed.
Mr. Pandit should be happy to dispose of representation. He has been asking in other matters. So today the same order, at least it is a coincidence.
Page number.
And how the petitioner could get you from your vacation place, Mr. Kanungo? Because it is not your usual place of argument. It is somewhere you are vacating in vacation actually.
Well, it's first 7 days you feel free in a vacation, Ballots. You feel as if everything is okay with the world. But the 8th day, Ballots, you start missing the old routine.
Yes.
Annexure 10 the order সেটা হচ্ছে পিজে মিনারেল ইন্টারন্যাশনাল প্রাইভেট লিমিটেড
So Pandit, annexure 10 can be passed.
My lord.
Same
Annexure 10, just kindly look at annexure 10, page 41.
At page 41, my lord.
Yes.
Same खाली सरकारी
So the operative portion would be operative portion is that you can say 5 and 5.1. As Mr. Kanungo was also placing, I hope you have marked that.
Aye.
Just go through if you have any reservation regarding 5 and 5.1. But anyway, it is binding on us, all of us. It's a division bench, coordinate bench judges. Same order.
Malats, another correction is required. Malats, the query number has to be changed.
Mr. Mahanti, can you just carry out the changes? Is it possible for you? And hand it over.
My lord. Malats, only in place of Donkari BSQ 17.
Then just listen to us. Just look at annexure 10, page 41.
My lord.
Instead of PJ mineral, it comes the present petitioner.
My lords.
This is which matter? Vallabh Charan. Prashanta Kumar Jena.
Prashanta Kumar Jena.
So that will do. Prashanta Kumar Jena.
And in paragraph 2, my lords.
So just one second. No, we are waiting because it will be difficult for the secretary to take down. Mr. Milan Kanungo, senior advocate, along with Mr. Somaranjan Mahan. Then Mr. Subhavikas Panda, additional government advocate. তারপরে para 2 রে দেখিবে highest bidder for Donkari Blackstone query number Hon'Ble.
It will be 9/8, my lords.
Para 2 দেখন্তু Donkari Blackstone query 9/9/8
9/8.
Videsh Hayrat case number
Let's Videsh Hayrat case number. Let's My lord, the Sairat case number is not mentioned, my lord.
Okay, sir, काटिदे.
My lord.
Sir, case number काटिदे. यदि देखिले पाइबे तो
आप रफ कर दे देना ऊपर है ना आप सेटअप कर दियंतु आई चेक इट
हां फिर भी सर कुछ नहीं पेज आनेक्सर 2 रे नहीं सर
छाड़ दे मोर सर सेट कर दे सर डाउनलोड करी सर
केस नंबर काटिदे
रफ पठी दे करेक्ट मेक इट करेक्शन
then come to the next page
छाड़ दे सर
तो आ गोटे करेक्शन अछि आपनकर
सिमिलर गुडा करिछु सेरम कर हां
and regarding personal hearing was conducted on 12/8/25 all those are same page 43 page 43
My lord, in this case it will be 30/12/25.
43 personal hearing was conducted on 30/12/25
Right.
Blackstone query number 9/8
9/8.
then everything remains same.
And my lord, in para 2, my lord,
Yes.
the lease deed portion will be deleted, my lord. That will be deleted after statutory clearance is being granted. Lease deed was executed, that portion will not remain.
Lease deed was para 2 टे कटि जो सेटा
Say part. After statutory clearance ru till rules.
para 2 रे ओटा after statutory clearance अछि after statutory clearance up to rules कटि गला
Well,
yes. So Mr. Panda disposed of.
My lord.
Yes.
But what about the status regarding that annexure 9, my lord? That is the question.
that was
Item 12, annexure 9, you are saying.
Your lordship's order will override this annexure 9, my lord. That
Annexure 9 means annexure 9
Yes.
will be
Annexure 9, what my esteemed brother is saying that similar orders were there earlier also.
Yes.
So, can you observe that we are setting aside annexure 9?
Yes, setting aside or it supersets that, whatever your lordship will feel like. Then
annexure 9 टा आज लिखी दियो तो गोटे लाइन था जो ये आता है जो लगा in view of the above order passed, the annexure 9 shall not be given effect.
deeply
Annexure
obliged.
So and so shall not be given.
Yes, fellows. Deeply obliged.
Yes.
May it please your lordship.
Yes, please.
Petitioner, am I audible to your lordship?
Yes, please.
Yes, draw like Miller. Petitioner before lordship is an extreme old man, Miller, and being a landless person, Miller, since 1975 had annexure 1, that is pursuant to a lease case, Miller. Your lordship may kindly come to annexure 1, that is at page 15, Miller. That is
yes.
And this
yes.
This lease case was initiated in the year 1975, and
Yes.
very small parcel of homestead land to the extent of 1 decimal. It was settled under the provision of the OGLS Act, Miller. In the name of the petitioner. Your lordship may kindly come to next page of that very lease order 66. The name of the petitioner is also mentioned. I'm just reading out. That is the middle portion, the middle para, the first penalty para. I'm just reading out for your lordship convenience, Miller. However, public objection notice was duly served and that no objection has been filed during the stipulated period. As such, they applied for land to the extent of 1 decimal, acre soon 0.1 decimal, decimal for homestead purpose out of plot number 429, that is the Sabing Miller. Under Khata number 390 Miller, that is also Sabing in Maujak Pujang.
Mr. Das, before you place that, you just kindly go through your prayer at page 11. Page 11, your prayer.
Miller, my prayer is direction given to the revenue authority.
So basically, we cannot direct. You have to move the authority. If you have to move the authority, then show that when did you move the authority for the recording.
Consolidation ROR is published by law. The commission authority to file a revision to correction the ROR of the consultation authority.
Consultation authority has no jurisdiction. My specific prayer, that is a case which is covered by the Narottam Ratha case, Miller. That is a comprehensive judgment And my
You
lord,
want then you take notice. Then you take notice. There will be a file come.
But
okay.
Yes, Miller, I will take notice, Miller.
The writ application is filed by the petitioner seeking direction to the opposite parties to record the consolidation plot number 574, area A0.010 decimal Kisam Ghoravari under consolidation khata number 589, देखिए 589 Mauja Kujang, Tahsil PS Kujang, District Jagatsinghpur, corresponding to Sabiq khata number 390, plot number 429 of the same Mauja. It is submitted by the learned counsel for the petitioner. Acha, appearance hai. So Devi Prasad Das for the petitioner. Mr. Aravind Tripathi, additional government advocate. Additional government advocate for the opposite parties. Sentence complete. Corresponding to Sabiq khata number petitioner that the petitioner is an applicant since 1975 for settlement of the land under the OGLS Act.
Miller, under the OGLS Act.
Under the OGLS Act. And it was settled in his name of the petitioner, as would be evident. From Annexure 2, that is order dated 30/11/1975, passed by the Tahsildar in lease case number 332 of 1975.
That is Annexure 1, Miller. I am sorry to intervene, Miller. Annexure 1. Body of the writ application, Annexure 1, Miller.
Annexure 1, order dated 30/11/75,
Miller.
passed by the additional Tahsildar. Chhatrapur.
Miller.
Chhatrapur is Jagatsinghpur.
No, that is not Chhatrapur. That is Annexure 1. Your Lordship may kindly come to document, Miller, that index is not, that is a typographical mistake. But everything is as per the Miller?
We or you, who has made the mistake?
Miller, your Lordship has not, that index is a typographical mistake, but body is correct.
Chhatrapur Jagatsinghpur.
Jagatsinghpur. That is Kujang, Miller. Kujang.
Additional Tahsildar Kujanga.
Yes, Miller.
Document ঠিক আছে Kujang আছে আমরা এটা ভুল আছে
সে ভুল করছে
আমার সিপিসি তাଙ୍କର ভুল
সেটা ভুল
my typist Miller, it was pointed out in the morning, Miller.
Your typist must be from Chhatrapur. Wherever he writes Chhatrapur.
Might be as copied from the index, Miller.
Annexure 1. Annexure 1. Passed by the additional Tahsildar Kujanga. In lease case number 332 of 1975. Stop. Issue notice along with this order. The Lorded AG upon advance copies of appears and waives notice. It is submitted by the Lorded AG that the consolidation records can be corrected by way of revision, and petitioner should approach the appropriate authority for revision. Stop. Counter affidavit on behalf of the opposite party shall be filed. The Tripathi, how much time?
1 month, Miller.
Shall be filed by 3/7/2026. The matter shall be listed for admission before the assigned bench in the week commencing 27/7/2026.
Miller, my apprehension is page 20, annexure 4, that is last annexure, Miller. That is the OPLE proceeding in a OPLE notice is there, Miller. My apprehension is my dwelling house may be demolished at any moment. That is my apprehension.
The IA has been filed by the petitioner seeking as he apprehends demolition of his dwelling house, which has been constructed in the
over the leasehold
over the plots according to the petitioner correspond to the leasehold property, leased out land.
My lord.
Stop. The learned counsel or the petitioner refers to the notice annexed to the writ petition marked as Annex 4, that is PR number 2032. Date 9.
Milord, date is not mentioned, but the date is there, Milord.
Okay,
In the body.
mentioning therein to directing therein the petitioner to vacate the concerned plot by 20/5/2026.
My lord, my lord.
Alright. Hard learned counsel for the petitioner, he reiterates his submissions as noted above. In the interim, it is directed that status quo as on date regarding nature, character, possession, ownership of the lots mentioned in Annex 4 shall be maintained till the next date of hearing. To be maintained by the parties. Listing data to Item 40. Issue notice correct? I hear what the issue notice is about. Issue notice. Yes, okay.
Urgent copy may be granted. Urgent
certified copy be issued as per rules. Parties shall have liberty to act upon the copy of this order obtained from the official website of this court. Item 40.
14, Lordship. In fact, Lordship, can you come to state of Annexure 1?
Yes.
I have limited grievance in respect of only, Lordship, item number 2 of the tender call notice. Lordship, it appears page 21 of the brief, Lordship, kindly see page 21.
Yes.
21 says, Lordship, construction of vending zone in bracket the 20 number subs at Guyana Chak in one number 48. Lordship, this particular item is under challenge. Reason being, Lordship, we are the inhabitants of the particular Chak, Lordship. And Lordship, we are staying there over the property of this Lord Jagannath, Lordship. And the same property was earlier recorded in the name of municipality. As subsequently, Lordship, on our grievance, Lordship, on our petition, now it has been changed to original owners, Lordship, to Lord Jagannath. And Lordship, kindly state I come to page 6 of the brief, para 7. In considering
the subsequent record where it is recorded in the name of Jagannath Mahaprabhu Vijay Puri. So you have those records annexed?
Lordship, I have ROR, I have annexed, Lordship. Lordship, kindly come to page
25.
But it is not without, it is without any date.
Lordship, kindly come to page 52. 52, Lordship.
52 re ROR achi?
ROR page 52, Lordship. 52.
Publication date lekha hai?
Publication, Lordship, it is publication of a recent age publication, the High Court direction for it. During pendence of the writ application, they took a decision, Lordship, to correct the ROR, and this is the corrected ROR, Lordship. That proceeding I have, Lordship, but I have not annexed
when,
to my...
When it was corrected?
But Lordship, kindly come to page 6. So,
Date,
Lordship, just prior to Lordship 2023.
Sir, you be kind to tell the date, sir. Because you are stopped there. Whenever you are asking the date of publication of ROR...
That exact date, Lordship, in RP proceeding before the Constitutional Authority, Lordship, Joint Commissioner, and considering that their statement...
ଆପଣ ଜାଣିନାହାନ୍ତି ନା ସେକେଣ୍ଡ ଗେସ୍ କରୁଛନ୍ତି ନା କଣ? You do not know the date.
No, ମୁଁ ଜାଣିଛି that exact date ଆପଣଙ୍କୁ କହିପାରିବିନି exactly. I am not in mind.
So that becomes a problem because you are saying that it is after subsequent. But ଆପଣଙ୍କର ଗୋଟେ date ଅଛି. ଆପଣଙ୍କର ଗୋଟେ date ଅଛି. ସେଟା ଦେଖନ୍ତୁ page 52 ରେ. ଲାଷ୍ଟ ରେ ଦେଖିବେ ତଳେ ରାଷ୍ଟ୍ରୀୟ ସୂଚନା ବିଜ୍ଞାନ କେନ୍ଦ୍ର 15/9/23 15/9/23 ରେ ଆପଣ डाउनलोड କରିଛନ୍ତି सो ଆପଣଙ୍କର
Download
अंतिम प्रकाशन तारीख खजरा धार्य तारीखटा ता पूर्वରୁ ଆସିବ
हाँ तो ता पूर्वରୁ से रही तुमको सीधे पूछ पर जस्ट prior to 14/11/23 and order la पूर्वରୁ they have made a statement before court that land now already we have corrected the ROR loss
प्लॉट नंबर गुडा जो अछि पेज 54 रे जो प्लॉट नंबर अछि
प्लॉट नंबर सब अछि
हां से प्लॉट गुडा देखि परिबे खाता नंबर प्लॉट नंबर देखि परिबे से आरआर रे
हाँ ROR रे अछि लॉर्डशिप
देखा
ROR फर्स्ट पेज रे अछि प्लॉट नंबर लाको जोरा के हमें देइछो
खाता नंबर 958 हाल खाता नंबर कटि हिची
लॉर्डशिप हमें शेड्यूल ऑफ लैंड देइछो जो प्लॉट में अछि
हाल खाता होछि 772/44/75
लॉर्डशिप शेड्यूल ऑफ लैंड
से जो प्लॉट रे आपण रहउछंती बोली कोड देखउछंती
लॉर्डशिप
सेही प्लॉट रे दुकान घर होछि बोली जो आपण कहउछंती
नो लॉर्डशिप काइंडली कम टू माय para 4 and 5 I made a statement lordship para 4 and 5 lordship kindly may I read lordship para 4 that it is also
खाली कौन केले हला पढिया भी दरकार नहीं
no very small para
खाता नंबर 772/44/75
no ha lordship para 5 lordship para 5 रे 4 रे कहू we don't have any grievance against all rest of the contract para 5 रे we given the specific plot numbers lordship
आपण कहउछन जे आपन जागा रे घर तयारी होछि
they will do two things lordship either they will demolish us and they will make that construction or they will make their construction in front of our house so that is our apprehension lordship and that is the fact remains because there is no other space
but if they can make construction in front of your house you will occupy those places or what
no lordship it is
you do not want anything to be
not possible to stay there because if they are going to create a vending zone lordship vending zone if they because there is no other space except this Jagannath temple property there is no other space and now pursuant to course direction and in the interim order status order there lordship and lordship kindly see for a moment there
status order ta copy page
lordship
status order page ta
page 6 lordship starts from page 6 and operative part of page 8 para 8 lordship
page 6 of the brief
sorry page 8 lordship page 8 para 8 page 8 lordship
आपण माने कोट करछन
कोट करते लordship
माने अनेक्शन नो कोर्ट रे कोटेशन
ना एंटर ऑर्डर टा कोट कर दे
अच्छा देन यू टेक नोटिस
lordship there status order there still then lordship there lordship another lordship thing lordship they are going to
petitioners who are
who
are inhabitants of an area called Nimpur we in the police station area of Jagatpur in the district of Cuttack are before this court challenging the initiation process of construction of shop rooms, public vending zone. Into
by
bracket
the municipality man. By the municipality man.
आगे से पॉइंट जाइन से ऑर्डर से जाए पहुंचो बाय स्टेट बाय म्युनिसिपैलिटी बाय मिस्टर दळई मिस्टर त्रिपाठी पहुंचियो और तो गोटे थर ब्रेक कले देन vending zone into bracket 20 number of shop आपण जोटा हमें कहू छिडे देखो 20 number of shop at ज्ञानो नना गया नना चौक गया नना छक within court रहबो वार्ड नंबर 48 stop it is submitted by the learned counsel for the petitioner that tender notice has already been issued. Annexed to the writ application marked as Annexure 1 at serial number
2 lordship serial 2
tender notice जो लिखे नहीं tender notice dated 21/5/2024 at serial number 2 is the proposal for construction serial number 2 is the tender for construction of vending zones into bracket 20 shops at Goya Nana Chokko in ward number -48. Stop. The learned counsel refers to the copy of ROR obtained from the NIC. marked as Annexure 2 upon reply करछन दिया
lordship annexure
2 ना 3
lordship annexure 1
one टा होचे टेंडर कॉल नोटिस आरओआर आपण को
आरओआर लॉर्डशिप एनेक्स 2 सीरीज लॉर्डशिप
एनेक्स 2 सीरीज
एनेक्स 3 लॉर्डशिप 2 लॉर्डशिप
एनेक्स 2 सीरीज
नहीं एनेक्स 2 लॉर्डशिप
खतियान क्रमिक नंबर 772 बाय 4475
yes
which indicates the recorded owner to be Sri Jagannath Mahaprabhu BJ Puri. It is further submitted that the said plots have been आपण पाइले केमती अलॉट हैला ना किणिले
no lords we are in possession since long lordships
the said plots are in possession of the petitioners. They have constructed their dwelling houses
lordship
their dwelling houses over the said plots
and as per direction of this court lordship under informed policy to settle them that process is on already I have annexed all documents
and the process for settling the land with them is already
started lordship under annex 3 series
is already under process
in view of uniform policy of the
uniform
government.
policy of lordship grateful lordship
in view of the uniform policy of the government.
Yes.
The Learned Council further refers to the annexer जोड़ा जगन्नाथ महाप्रभु को देखिले सेटा वो पेज रे थिला पर थोड़ा सीरीज कर देले अपन तरवरे
पेज 25 लॉर्डशिप जगन्नाथ पेज 25 टा क्लियर annex 2
सेटा दिला तापर आउट 36 आउट अपन अछि
आउट 52 देखोतिल
page 36
he further refers to an application form for purchase of land belonging to Sri Jagannath Mahaprabhu BJ Puri, which finds copy of which is at page 36 of the writ application. Referring to the said application, भाग्यधर होचंदी एथिरे आपनकर applicant petitioner.
चारजन अप्लाई करचंदी भाग्यधर आपण your lordship
he referring to the said application. The Learned Council points out that Sri Bhagyadhara Swami, who is the applicant who purchased the land, is also a petitioner in the writ application. Stop. It is submitted that construction of the vending zone will completely damage the prospect of the dwelling house of the petitioners, which they have been allotted, and accordingly, 6 intervention of the court. Stop. Issue notice along with this order. Requisites for issuance of notice Agonikiwe, Mr. Tripathi, Learned AG, on advance copy served appears on behalf of the opposite parties 1, 4, 6, 1, 4 and 6. Notice be issued to the OP number 2, 3, 2, 5 and 7. 2, 3 and 5 and 7. By speed post with registration and proof of delivery. Requisites for issuance of notice be filed within 5 working days. Apart from taking notice as directed above, the petitioner will have liberty to serve extra copy on the Learned Council appearing for the Cuttack Municipal Corporation for opposite parties 2, 3 and 5. टेम्पल एडमिनिस्ट्रेशन को कॉपी देबे
लॉर्डशिप कॉपी सब कर दो लॉर्डशिप नोटिस दे बेटर
आज ने नोटिस छडा नोटिस संगरे आपण
कॉपी
नोटिस तो नाउ पडिबा आपण
लॉर्डशिप आई विल टेक नोटिस
as well as the Learned Council appearing for the Sri Jagannath temple. आइए लिखंतु कोन एथिरे खाता प्लॉट जणा पडुची जो आईए रे लिखि छथि शेड्यूल अछि
आईए शेड्यूल दे दिछि मेन प्रे
ऑडियो जन बना दे
सी आइटम नंबर 2 अनुसार
शेड्यूल लिखि 48 गया चौक Not clear. What means? IN equal to had not a counsel for the petitioner. He reiterates his submissions as noted above. Issue notice as above. Accept one set of process fee as well as postal requisites along with the writ application. In the interim, it is directed that the status quo regarding status quo as on date regarding nature, character, possession, and ownership of the property that is pertaining to construction of vending zone into bracket 20 number of shop at Goyanana Chowk, ward number 48 at serial number 2 of the advertisement. Serial number 2 of the tender call notice. Tender call notice.
DTC.
It's been a page tender call notice.
Tender call notice will be proper, Lordship. Tender call notice will be proper.
Dated 21.05.2026 shall be maintained till the next date of hearing. The matter shall be listed for admission in the week commencing 27/7/2026 for the assigned bench. Reported to mention.
Lordship, grateful, Lordship.
May I please, Your Lordship, my Lord?
Yes, please.
May I please, my Lord?
So, Parsuram Ponda for the petitioner.
My Lord. The writ petition is nature of habeas corpus.
Yanaloko Mohanty, standing counsel for the opposite party. The petitioner is before this court alleging inaction of the police in seeking reaction of in tracing the minor daughter of the petitioner, who is alleged to be missing since
4/5/2026, Your Lordship.
4/5/2026. It is stated and submitted that the petitioner has lodged FIR in Naikon police station in the district of Baleswar,
Bhadrak, Your Lordship.
in the district of Bhadrak. VD, PS case number 121 of 5/5/26. Stop. The learned standing counsel upon advance copy served appears and waives notice on
I have already grievance before the SP, Your Lordship, Annexure 3.
parties 1 to 1 3. या 5 तारिख रे ले क्यों एटा एते जल्दी हे परियो
से थ्रेटनिंग दउची मो आईवी फाइल करची ता ब्रदर
थ्रेटनिंग टा जोटा थ्रेटनिंग टा सेरा पुलिस को दे दे
ଗୋଟେ ଏଫଆଇଆର
पुलिस को दिया हलानी पुलिस को
एफआईआर कर देबे ते तबन कोन लोन लीगल डॉक्यूमेंट्स भी petition 123 he shall obtain instruction and the status report shall be filed regarding the investigation undertaken. All efforts shall be made to trace out the minor girl.
My submission is that
upon tracing out the minor girl, she shall be produced before the magistrate immediately, and her statement shall be recorded in accordance with law.
one line, Your Lordship. One line. Family member threatened to the petitioner's family, that may be recorded.
Threaten kale police high court cannot
police वाला FIR कौन सी वजह कहला पर भी फोन थरे लिखि देलु न नान से
अपन registered post रे पठी देबे FIR रो अपन you are too
second time
FIR पे किसी क्या को खुशामत करे दरकार नहीं
second time भी दिया हला
second time अपन registered नहीं speed post रे पठाई देबे अपन SP को पठाई दियंतु
तने मु मेंशन करछि आयर भी त ब्रदर नाम मेंशन करछि आसी थ्रेटनिंग दउची केस विथड्रॉ करो
हाई कोर्ट आगे डाकी कि तापर अपन कहबे जे हमें बाहर को जाके गेट पाकर ताको रिसीव करबो ताको निस्तुक माड मार आई तो तुम कहलो सेंती कोन यू मस्ट आर्ग्यू सेंस सर आर्ग्यू लॉ अपन को जहां से क्लाइंट कहले तुम कहला अपन ताको पचारले कि जे एफआईआर देले कोन हला एफआईआर काई पठेलेनी तापर ज्ञान लोक मानती को कहबे जे अपन जान तो धरि के आनंतु जे धमकेला सेंती को ऑनलाइन
माय सबमिशन ऑनलाइन से लिखि
जानिबे जे emotive submissions let us be confined to
Your Lordship decide.
लिखिबे that it is submitted by the learned counsel for the petitioner that complainant before the police has threat perceptions as he is receiving threat from unknown persons or brother of the
family members of the OP number 4.
From the family members of the OP number 4.
Copy number 4, Your Lordship.
Issue notice to open number 4 by speed post with registration and proof of delivery. से तो जानी ना से कोटी अछन ताको केमते नोटिस नेबे
OP number 4 the
से तो मिसिंग थिवे
victim girl along with OP number 4 both are along with it. They are searching while just in the morning.
Notice to open number 4 is not issued after the time being. In
the morning I have already talked with the IAC.
केबे Mr. Mahanti केबे
एबे तो ताकर मोबाइल रो ट्रैकिंग गुडा पक्की चंदी within very small at a very serious matter. Minor daughter kidnapped and a very serious matter. We are also very serious.
The matters will be listed for orders in the week commencing.
Sir, just reopening for sir.
Immediate. ठीक है week commencing 22/6.
Again.
Hey, please, Your Lords.
Yes, please. Item 16.
Wait, please, Your Lordships.
Yes, please. Mr. Vasudev Pujari for the petitioner. Mr. Gyanaloko Mahanti, standing counsel for the opposite party. Yes, Mr. Pujari.
My Lord, minor daughter.
Same order.
My Lord.
It's for Gobindpur PS, man.
Can I change it? Same order मैंने कौन करे पहले? PS ना लोग party ना. अब इतने अपन alleged जी alleged kidnapper को party कर चंदी?
नहीं नहीं.
सी भी माइनर है तो. Both are minor.
नहीं से minor नो है.
Major. Okay, okay. ठीक है. ताले इतने कोर्ट कथा लिखी Same Mr. Standing Counsel for all 1 to 4 1 to 2. Yes. Same Antaricha, Mr. Mahanti.
Again.
These are heaviest matters, so please take it.
Yes.
I'm sorry. YC the comments shall be listed before the assignment. In the week commencing, YC 48 choice. Yes.
Lordship, item 17. In fact, Lordship, I may permitted to plead this matter on behalf of Mr. Das. Lordship, he is oddly placed, Lordship. Kindly permit me. Lordship, here is the writ appeal is pending and already on the ground of a limitation notice has been issued. And Lordship, kindly state have come to miscase, Lordship. Miscase, Lordship, that is annexer I had pursuant to the court's direction, Lordship. They have already, Lordship, that is within that knowledge that High Court has taken judicial notice and notice has already been served. And now they have issued, Lordship, eviction notice for eviction of 83 inhabitants, Lordship, can I see page? That is last.
Mr. Sakshadas,
My Lord,
are you appearing in this?
I don't know, I'm appearing for RDA, my Lord. This complies to the Honorable High Court's order. Your Lordship can advance.
Mr. Barik, Mr. Sakshadas, on the last occasion when on 23rd March, we have made observation that it relates to some street vendors.
Slum dwellers, Lordship.
Slum dwellers.
Slum dwellers, Lordship.
But they do not come under the definition either of the slum dwellers or the slum area. As described under the statute, I can explain that.
We have.
Mr. Das, perhaps the issue could be as it appears. Yes. Most likely, I think it is state is not evicting, RDA is evicting.
Lordship.
It is coming under the RDA area, my Lord.
So if the court is in session of the matter, court is in session. So there is a interim order or
no interim.
No interim order, Lordship.
Please wait till the court takes up the matter.
Mr. Barik, have you filed a response?
My Lord, they have till date. My Lord, they have till date not supplied me copy, my Lord. Till now also.
Mr. Barik.
May I submit? Your Lordship can have. May I submit? My Lord, only limitation notice has been served on us, and we file our counter affidavit after vacation. Now the question is, my Lord, in pursuance to the Honorable Court's compliance direction, we have issued them eviction notice. Your Lordship kindly grant the WPC number.
Actually, in fact,
they were hard.
Mr. as we are listening to you, you also listen to us. So once the matter is writ appeal may be dismissed. So, but what is the tearing hurry?
But writ appeal is not admitted, my lord. Only limitation notice gone.
So if the writ appeal will be admitted, it will be frustrated.
My lord, my humble submission.
How the answer can be, my lord? If the writ appeal is admitted by condoning the delay and on merits it is admitted, what would be your answer? That we are
There is no stay also. There is no stay also.
That we are asking you. It's obvious. We are asking you the same thing. You have to answer that, not ask us.
This matter was had at length in the last election.
Today we will admit the writ appeal.
Yes, my lord.
Then your argument will that you will demolish it or what? So we are only saying that what is the tearing hurry in doing it? Can you not be more patient on this?
Yes. We are not hurried. The question is, my lord.
So don't be in a hurry. Don't be in a hurry. Allow the court to take up the matter.
My lord.
They may not have a case. The writ appeal will be dismissed. The writ petition was dismissed.
Yes, my lord.
39 days delay.
And let him serve the copy of writ appeal, my lord. And this I also. They are not serving.
Mr. Barik.
Se notice ଦେଇଛନ୍ତି sir. ଆପଣ Mr. Barik ବିଷୟରେ ବୋଧେ ସେ ଶୁଭୁନି।
Mr. Barik.
ସେ notice ବୋଧେ ଆପଣ ପାର୍ଟି ଅଛନ୍ତି ଦେଇଥିବେ notice. ଆପଣ OP2 R2 ଅଛନ୍ତି।
Only limitation notice I have received.
ठीक ଅଛି।
Yes, Mr. Barik. Let us condone the delay. 39 days.
Whatever it may be, Your Lordship, I have objection to that because Your Lordship may.
Talent file କରନ୍ତୁ. Let us not spend time. କହିବେ ନା ଆପଣ? The matter is listed for orders. Notices were issued on the question of limitation by the coordinate bench by order dated 23/2026 in IA number 773 of 2026. Mr. Sukanta Kumar Dolai, on behalf of Pratik Das for the petitioner, Mr. Sashwat Das, additional government advocate for the respondents 1, 3, and 4. Mr. Navin Kumar Barik for R2. तापर औरत लिखी और तक कौन लिखी लास्ट वर्ड notice having been sufficient, Mr. Barik has entered appearance. He submits that he shall file his objection to the IE seeking condonation of delay of 39 days in filing the appeal before this 42 days. Condonation of delay, reported delay of 42 days in filing the appeal. It is submitted by Mr. Dolai, Lord Counsel, appearing on behalf of the Lord Counsel for the petitioners. Hey, I टा कौन आगुरु थिले ना फाइल करछन्ते आपण?
एबे रिसेंट फाइल करछि लॉर्डशिप। नंबर लॉर्डशिप है नंबर लॉर्डशिप 1930
तापर लिखिबे आईए नंबर 1930 of 2026 आईए 1930 1930 of 2026 आपण जोटा रेफर करछन्ती जो नोटिस उडा का अनेक्सर गोवा फाइल करछन्ती
लॉर्डशिप रिसेंट नोटिस लॉर्डशिप
counsel for the
25/5
refer to annexer 10
lordship
next to the IA when notices have been issued
25/5 2026 lordship
notices have been issued on 25/5/2026 to one of the petitioners
collectively this common notice lordship
yes collectively to the 83 petitioners directing them to evict directing to vacate the place as well as the dwelling houses by 12/6/2026. The notice refers to the order dated 3/12/2025 in WPC number 11346 of 2020 which is appealed against in the present writ appeal. Say writ petition tha?
Lordship.
The appellant petitioners seek interim order protecting their dwelling houses for the present. The learned additional government advocate in opposing the prayer, interim prayer, submits that the appellant petitioners are not coming within the definition of Mr. Das. Can you repeat? Slum dweller. Can Mr. Das?
Slum dwellers.
Slum dwellers.
He's saying slum
They
dweller.
do not come within the definition of slum dweller.
And the area doesn't come under the slum area.
And the area does not come under the definition of slum area.
Well,
Statutory so and so. Mr. Parikh, learned counsel, appearing for the OP number 2 RD, Red Outcry Development Authority, vehemently opposes the prayer. And he submits that after losing in the writ application, the petitioners cannot make such interim prayer. Having had learned counsel for the petitioners, as well as the learned AGA and the learned counsel for the R2, in our considered opinion, till the matter is finally heard, till the appeal is finally heard and decided by this court. Since the appeal is pending for admission before this court, in the interest of justice and fair play, status quo as on date shall be maintained.
Yes.
The status quo should be maintained. The opposite parties shall file their objection to the delay coordination application if any. In the interim, it is directed that status quo as on date regarding the nature, character, ownership, and possession of the properties, which are subject matter of the writ appeal and where subject matter of the writ petition, WPC number 11346 of 2020, disposed of on 3/12/2025, shall be maintained by the parties. So, Dole, you have to also maintain.
Grateful, grateful.
Till the next date of hearing, the matter shall be listed for orders for admission in the week, data orders, condemnation. Orders in the week commencing. Kodia Sate.
Lordship, as Lordship wishes.
Mr. Parikh, Kodia Sate.
No, 1 week after. 1 week after.
6 sir.
Next.
29 the week commencing 29. Is listed in the week commencing 29.
Lordship. Grateful.
Liberty to mention.
Grateful. Lordship.
May it please, my lord.
Yes.
My lords, herein I filed an application for release on interim bail of the appellant, my lords. There were 2 appellants before my lords who have challenged the said conviction. One of the appellant number 2, has been released on bail by order dated 30/4/2026 with regard to her age and other ailments, my lords. Herein, in this present application, I have prayed for interim bail with regard to the disability of my son as well as the ill health of my wife, my lords. Because of which, my lords,
So let them respond. Let a co-IA, please tell the specific
IA number 1440.
Sayusi Mehta for the appellant petitioner. IA ta hoche kete 1440.
1440. Yes, my lords.
144 IA lekho to 1440226. The IA has been fined for interim bail under section 430 into bracket 1 of BNSS in the pending criminal appeal. In the pending appeal, the ये होचंती केते appellant 2.
First appellant, appellant number 1.
The petitioner is the appellant number 1. They submitted that appellant number 2 has been released on bail pending adjudication of the appeal by order of the ordinate bench. Order ta ki regular appeal bench rahi thi wo.
Yes, my lord.
By order of the regular bench taking up the criminal appeals. Copy of the IA has been served on the standing counsel, who shall obtain instruction and file his response to the prayer made in the application. The matter shall be listed for orders in the week commencing on 30th.
My lords,
First week of July. First week.
My lords, I pray within the vacation, my lords, because the
No, we cannot because these are to be taken up by the regular bench.
Volume dash medical
I
documents.
completely
This has not been assigned to, because criminal appeal, the bail matters have to be, and this is regarding ill health and other thing.
Yes, my lords.
Usually in case of a bereavement and something like, so there's a possibility that other bench will take up.
My lords,
But
I've
this is
also fixed the
so this is a
documents,
regular prayer made before the regular bench. But anyway, let them respond.
my lords, my only difficulty is because there is nobody else in the family, my lords. The his wife also has been suffering. My lords, miss, turn to page number.
But that has to be considered. That has
Yes,
to be
my lords.
considered by the bench taking up of the appeal.
I completely bow down, my lords. But
Yes,
if
yes.
it may be called for before any other bench during the vacation, my lords.
No. That we cannot direct. That is not the notification. If you insist, we have to reject that prayer. I don't think that is in your interest. The matter shall be listed before the assigned bench taking up of the criminal appeals in the week commencing on 30/6/2026. The learned standing counsel shall obtain instruction and file his response and serve copy thereof by 25/6/2026.
Deeply obliged, my lords.
Yes.
19.
May plots.
The Pratap Kumar Mahapatra for the appellant.
Petitioner
Yes, sir.
challenge. Man, petitioner challenge Annexure 11 judgment dated 9/3/2026 regarding dissolution of my
You are
marriage.
the husband. You are the husband, sir.
My lord. On
So
the
the
ground,
wife's application has been allowed.
my lord. On the ground of cruelty, what that without based on evidence and
Anyway, the delay, no, 1 day delay. Let notice.
one day delay, mal.
आइए Mr. Nikhil appearance.
Well.
IA 335 of 2026 along with MATA 149 of 2026. The petitioner, the appellant before this court is the husband in the marriage. Stop. He challenges the judgment
Dated 9/3/2026.
Judgment dated 9/3/2026 passed by the Learned Judge Family Court Bhubaneswar
Well.
in CP number 222 of 2022. Stop. The said CP was filed by the wife in the marriage under Section 27 of the Special Marriage Act 1954. Seeking dissolution of the marriage between the parties and grant of decree of divorce. The marriage having been registered on 09.02.2021. The CP has been favored, hence the appeal. Hard runner counsel for the petitioner. Appellant as petitioner issue notice in the IA as well as the appeal. Along with this order. To issue notice likely, issue notice to the opposite party, the respondent as opposite party. Right. Requisites for issuance of notice by speed post with AD, speed post with registration and proof of delivery shall be filed within 3 working days.
By 3 days.
Within 3 working days. Interim stay तो इतने कौन होगा इतने तो अपना ठीक है जी IA 242 IA 242 of 2026
335 regarding status quo petitioner going to marry on 11/6/2026. That is why I filed this miss case, my lord. Before final disposal of the case.
ଆପଣଙ୍କର ତ delay ରେ ହେଲେ ଏଟା ହେଇପାରିବନି.
One day, my lord.
1 day or 1 second delay is delay. That order is not tellable.
Still then,
IA 242, IA 242, IA 335 ଆଉ ଗୋଟେ କେତେ ଆପଣ କେତେଟା IA ଫାଇଲ କରିଛନ୍ତି? ଆପଣ ସବୁ ଦିନ ପାଇଁ ସବୁ ତିଥିରେ ଗୋଟେ ଗୋଟେ କରିଦେଇଛନ୍ତି?
ନାଇଁ initially one day
ଥାନ୍ତେ ଆପଣ ବିଭିନ୍ନ IA କରିଛନ୍ତି ମାନେ କଣ ଯୋଉ ଦିନ ବାହାଘର ତିଥି ସେଇଦିନ ଗୋଟେ IA. ଆପଣଙ୍କର ସେକ୍ସନ 13 ଯୋଉ ଅଛି ତାର ବାର ହଉଛି ଫର ड्यूरिंग द अपील पीरियड.
1 month. 1 month. Date of issue copy ରୁ 1 month ରେ ଫାଇଲ ହେଇଛି ଗୋଟେ ଦିନ ଗୋଟେ ଦିନ ଫାଇଲ ହେଇଛି ଆଉ.
Just discuss and talk law, sir.
Well.
ये फुल छोटा है. जो बार अच्छी when a marriage has been dissolved by a decree of divorce and either there is no right of appeal against the decree or if there is any such special marriage act.
Well.
Either there is no right of appeal against the decree or if there is such a right of appeal, the time for appealing has expired without an appeal having been presented. So one day becomes fatal.
Copy receipt petition receipt from 16/3/2026. So
notice दियंतु बुझिले notice दियंतु speed post notice टाइम दा जाउ.
Till then protection to my lord जो petition opinion of respondent going to marry on 11.
Sir, before condoning the delay, don't we pass any order?
My lord, your mind knows my rest predicament for
से सेम parameter provision अच्छी देते हैं.
माल.
This divorce.
Next माल next
सेटा अपन नीचे देखिवा कथा अपन सेटा को section 29 सेम.
Coming date लोग आपन बेंच रखन.
Sir 30 and 30. अगेन
आपन coming date रखन आपन बेंच
माने
coming division bench रखन बेंच bench.
Notice आसी नथिबो सर.
सुने केमति हो?
अपन नोटिस देई नथिबे हबो के.
Where a marriage has been dissolved by decree of divorce and either there is no right of appeal against the decree or if there is such right of appeal, the time of appealing has expired. Pura same language, section 30. So since you are insisting for interim order, and in fact what you are saying is right, but law has to prevail. We got your point, but says section 30 is very specific. Then notice notice date.
Till then
242 कोटा delay टा कोटा था.
Status को till reopen demand.
242 होची आपनकर स्टे तापरे 264 होची नहीं 264 टा condonation. देखले ठीक अछि. 335 again status quo. 294 होची status quo. तले आइए लिखंतु 242 335 and 294. Issue notice as above. ऊपर लिखले condonation of delay रे 1 day delay. राखिची. The IA has been filed for डैकिंग. The IA has been filed for seeking condonation of delay of 1 day in filing the appeal. एक होता sentence वाला. Issue notice in the IA as well as the appeal status. Issue notice as above. Accept one set of process fee as well as postal requisites along with the appeal and the other IA. Returnable date be fixed to It's to 25 list before the assigned bench in the week commencing 29. Yes.
Till then mal protection.
Sir, এটা demolition রে হবো কি? এটা পরে demolish ହେଇଗଲା ବାହାଘର demolition ବାହାଘର decree grant ହେଇଗଲା ପରେ within that period section 30 ଆପଣଙ୍କ କେସ୍ ରେ section 30 Hindu Marriage Act ରେ section 15 Don't create a situation where the order will be vulnerable, because you should have a order, strong order in your favor. At least notice this way that sends a message. Let them answer. What we are discussing, they may not answer like that. So you must understand that.
Situation on the ground of that is honorable judge did not prove, my lord. Even that no ground was given.
You argue on merits after when the matter is listed for admission. Yes.
Item 20. May I please, Lordship? The DT before
the outcry for the petitioner, Mr. Surya Narayan Das, Additional Standing Counsel.
I have instruction to appear on behalf of the additional commissioner.
The matter is taken up in virtual court, so would I understand.
For opposite party number 2, that assistant commissioner. Here is the case, my lord.
Mr. Surya Narayan Das for Additional Standing Counsel for OP number 1, 3. 1 and 3. Mr. Lalit Marana for OP number 2.
Yes. Here is the case, my lord. The DT before this honorable court, in order to protect its property, and admittedly the DT has filed on 41 application before the assistant commissioner for declaration that property is the DT's property. The lordship kindly turned to annexure 1, the Sabi Karwar, which has been, the land has been recorded in the name of Gopinath Dev.
So 41, what happened in the 41 proceeding?
41 application is pending, my lord. During pendency of the 41 application, the land has been acquired.
Kindly show that the land, the khata plot, everything.
Yes, 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 your lordship. Lordship, kindly turn to annexure 4, page 16.
Religious endowment. Annexure?
Annexure 4, page 16, your lordship. Annexure 4, page 16.
Yes.
Khata number 309. The page 17. I'm concerned about 888. That serial number 5. Next page, page 17.
Yes.
Yes, lordship, kindly turn to annexure 5. The schedule is at page 23. Your lordship got it.
Same.
Yes, your lordship. Yes. That next page, the schedule is at 309,888. 24, page 24, the first line.
So you showed that ROR is of Hal or Sabik?
I had showed that ROR, Hal ROR.
Hal ROR, okay.
My claim is since 1931 that the Sabik ROR, it has been recorded in my name. And since the perpetual minor, they could not take any steps for record his name, the private parties are recorded in their name in the during Hal settlement, Hal records. And I have filed this application before this. Yes, sir.
And what is the present cause of action?
Well, cause of action that
because when 41 is pending,
yes,
the endowment commissioner can protect you.
Yes, my lord, admittedly, my lord, I have made a reference to the land action officer, so also before the assistant. Only I pray before this honorable court till disposal of the 41 application, I may protect it. My lord, they are the DTs. Admittedly, they are the DTs, the perpetual minor lordship knows, and they are dependent by the certain persons.
The DT Sri Gopinath Dev Vijay, Damona, at Chandrasekharpur, Bhubaneswar, represented through managing trustee, is before this court. Right. Challenging the decision of the land acquisition officer, Collectorate Khorda, dispersing, challenging the action of the decision of the OP number 3, Khorda, taking steps for disburse the compensation amount for acquisition of land, which according to the DT, who is a perpetual minor, is DT's property. So it is submitted there. Application has been filed by the DT on behalf of the DT under section 41 of the Odisha Hindu Religious Endowments Act 1951. Seeking relief of settlement of property in name of the DT. The said application before the appropriate authority is pending since application.
Pending since 2023. OA number 11 of 2023, which was filed.
2023, that is OA number 2023. Annexer kete?
Annexer, let's see that annexer
3C.
5, Your Lordship. Annexer 5. Page 80.
Annexer 5. Annexer 5. Annexer 5 to the writ application. It is submitted that submitted that the DT's property could not be protected. Some private individuals have recorded their name in the HAL ROR, HAL record of right, into bracket recent record of right. And accordingly, they are in the process of receiving the land acquisition compensation, which is the legitimate the compensation, the DT being the legitimate beneficiary. So, you should notice along with this order, you should notice to the opposite parties along with this order, the learned AC, appearance like the learned AC, upon advance copy served appears and waives notice on behalf of the OP number 1 and 3. No further notice be issued. The learned the learned AC shall obtain instruction and file counter on behalf of the OP number 1 and 3. Mr. Lalit Kumar Maharana, learned counsel, who usually appears for the OP number 2, being present in virtual court, accepts notice, let 2 extra copies of the petition be served on Mr. Maharana within 2 working days.
Yes, already by this week, my lord. By Friday, Lordship may say.
Within 3 working days. Within
yes,
3 working days. The Lord, Mr. Maharana shall obtain instruction and file his counter. Notice to the opposite parties 4, 5, and 6 be issued by speed post with registration and proof of delivery. Requisites for issuance of notice we find within 3 working days.
Yes, sir.
Why there are two IAs?
My lord, urgency is that, my lord, during vacation I filed an application for stay, my lord, that offer. That is
IA 10425 of 2026. Had learned counsel for the petitioner, he reiterates his submissions as noted above. It is submitted that unless the disbursal of the amount for acquisition of land as mentioned in the schedule, so schedule the quote.
My lord, schedule I am not given in the miscase, but in the para 3.
Para 3 of the petition. Para 3 take lecture Mr. Rautre?
My lord, para 3 of the writ petition, but Lordship may say that the acquisition I have given that the acquisition, item number 84, page 27.
Para 3 of the writ petition reproduce karte ROR of the during khata number 312, ROR of 1931, khata number 312, plot ekte so much. HAL and further corresponding to notification at page
6, annexure 6, page 26, your lordship.
Annexure 6, page 26.
Page 27, serial number 84.
Page 27, serial number 84. Khata number 309, plot number 888, Kisam Daru area 10, area 1060.
Acquired land, a 0.
Out of which acquired land acres 0.46 decimals.
Yes, sir.
So, it is not stayed. The DT being a perpetual minor shall suffer irreparable injury. In view of the pendency of the application under section 41 of the Wage-Charity Act 1951, and also pendency of the writ application, in the interim it is stated that no disbursement shall be made pursuant to the acquisition of खाता number 309, plot number 888, विषम डालुआ एक, total area 1060, out of which acquired land occur 0.465 decimals. To any of the parties without leave of this court, as well as without leave of the endowment authority. So, this order shall continue, interim order to continue till the next date of hearing. I issue notice টা লিখে রাখলেন। I issue notice যাব করবে। I issue notice যাব accept one set of process fee as well as portal fees. তারপরে দেখুন তো এটা তো interim order করে দেবে। Then returnable date be fixed to or যেহেতু 3/7 the matter shall be listed before the assigned bench for orders in the week commencing 13/7.
Obliged.
So, Mr. Maharana, here you also protect the interest of the property.
My lords, my lords.
Because usually this is a problem with DT property. Somebody
lords,
claiming to be the owner, then obviously otherwise if it is once disbursed, then the DT has to fight a litigation.
My lords, I've come across a notification whereby it has been stated that the amount, if disputed, will stay with the authorized person by the commissioner till 41 is decided. I'll bring that notification on record.
Correct. So that is the point. In fact, we have also passed the order in those lines.
My lords.
Yes. Thank you. Item 21.
Lord, I am audible and visible, my lord.
Yes, please.
Lord, appearing for the
Mr. Ask of the petitioner, Mr.
Satyanarayan Patnaik, CGC, along with the learning DSG.
K. Padi, senior advocate and senior advocate DSJ, along with Satyanarayan Patnaik, CGC, for the opposite party. Yes, Mr. Das.
Lord, your lordships may kindly turn to the page number 208 and 9. This is a garnish notice.
Anybody from income tax department?
My lords. My lord.
Anybody is appearing?
Copies are many.
My lord, yes.
Income tax department.
It's served, my lords, to them.
So where is he? He is to answer.
My lord, I am appearing for OP number 1 and 3.
Correct.
My lords, that is the income tax department, my lord.
No, one is union.
Yes, my lords.
Yes, my
Income
lord.
tax, who is the counsel usually appearing for income tax? Standing in the court. Is he in the courtroom? Actually, the Lorded Counsel can just shift to your left. We cannot see you.
My lord, in this case, I have received instruction and I will file the counter affidavit.
Oh, you are appearing for the income tax?
Yes, my lord.
Mr. Padi.
I have sought for the instruction and I
Mr. Padi is appearing or you are appearing?
I am appearing along with Mr. Padi.
Okay. Then all opposite parties.
Yes, my lord.
1, 2, and 3. Commissioner.
Chief Commissioner Income Tax also you are appearing.
I will file counter on behalf of opposite number 3, my lord. I have received instruction from the principal chief commissioner of income tax also.
But Mr. Patnaik, what my brother is asking that 2 and 3 have to be represented together. Today, if you say that you are only appearing for 3, then what about 2?
I am appearing all the opposite parties. Because I have received instruction.
You are saying that you are appearing for assistant commissioner.
Yes.
So who is representing commissioner?
Chief Commissioner.
And to be fair to the petitioner also, he should argue in presence of all. Today you say that I am not appearing. Then what is his answer?
Lord, my answer would be that even in the absence.
So, Mr. Patnaik.
Yes, ma'am.
So what you do, that be clear in your stand that you are also. You may not appear, but at least someone should represent to them.
The standing counsel.
Standing counsel should be there.
Standing counsel income tax is somebody appears usually. Mr. Subhas Mohanty, senior standing counsel, and
he was
Mr. Kedia also.
He appears. He was present on the last day. So let it come on next date division bench. So day after jo achi setare asu.
No, request your lordships.
Mr. Biswajit, you also make
what you
a statement. You can make a statement.
You can serve a copy on the Mr. Mahanti, senior standing counsel.
My junior is there. My junior is there before in the court.
Yes.
Mr. He's standing, I think.
Mr. Biswajit Das.
Yeah. Please.
What I suggest you make it easier for us.
Okay.
For the petitioner also.
What is the demand for the assessment year 2018-19? That is the whole substance of your claim. So what was the demand? And when was the rectification of error was filed? Or appeal is pending? What is the status of appeal? And during that period, Section 220 application, what was its fate? And how much amount has already been recovered by the department? And how much balance is left out in your bank account so that you can maintain that amount to defreeze the rest?
Maloj, I may.
That is the.
No, Maloj, that's
you have to secure that demand.
Mr. Das, this is only to facilitate you. By the next date, if you get these instructions, they will be also represented. Of course, we will not adjourn it again and again. That's another.
Make a chart.
So
it will be easier
I understand. I understand your lordships is actually talking about the protection of the revenue. My lords, my case is actually I'm an exempted entity.
No, I'm balancing, sir. I'm not protecting the interest of revenue only. I'm balancing what is possible.
At the stage of interim order, the balancing act has to be done.
Lord, your lordship should be, and therefore, my lord, let me be very, very fair to your lordships. My case is not that. My case is their assessment order is premised on the original return where I have filed the revised return, which is zero.
No, Mr. Das, we are not.
I'll explain that.
We are not passing any order today. As you have understood, but since we are thinking it aloud, it will be making it easier for you as well as for the revenue also. Of course, revenue is not represented.
Keep it tomorrow or day after tomorrow, whatever your lordship suits.
So the next day is actually 5th. Even the immediate next day.
Next day. So much obliged, lords. I'll come back. Actually, the problem is the dominoes effect. There are 9 projects of the government of India is actually stalled because I'm not entitled to pay even a single penny. I'm entitled to get a refund of the TDS, 54 lakh. I'm entitled to get it, Lords. I'll demonstrate that on that day. Obliged, Lords.
Next date,
on 5th.
Next day of next court day is 5th.
5th of
next day is court. Yes, Friday.
5th of
By then you may serve a copy on Mr. Subhas Mahanti or Mr. Kedia.
Those who appear for the principal commissioner, chief commissioner. देखो तो Mr. Biswajit Das लिख ले, जो लिख ले Mr. DSCI, senior counsel, Mr. Padi, K. Padi, along with Mr. CGC, 1 and 2.
Actually, the copy submitted, Mr. Kedia and the council, other councils.
Okay, just talk to them. Just inform them over phone. It is submitted by the Lord CGC that he has been instructed along with the DSGI to appear on behalf of topic number 1 and 3. It is submitted by Mr. Das for the petitioner that the copy has been served on Mr. Kedia, who is the standing counsel. He is
senior standing counsel.
Mr. Kedia is junior standing. Mr. Kedia, junior standing counsel appearing for the income tax department. The matter shall be listed for fresh admission on the next date, that is 5/6/2024.
Kindly indicate about the consideration of my interim application. That's very important. Just kindly.
It is there, already there. We can't say. I mean, even if we say that, we will not consider, that cannot be.
My Lord's bench will be there on 5th?
Yes. The next date is 5th.
My Lord, so much obliged.
Item 22. Lord, in item 22, I prayed for time to file the instruction.
This is my case. I have filed an interim application. How can they will take time? 22 is mine.
No, where praying for a reply.
Yes, that
Yeah,
is
you
asking
have
for
already
reply, but we have filed an interim application.
Yes, when that will be
Lordship
extended.
kindly, yeah, Lordship kindly,
22,
I can address.
Mr. S.K. Dalai for the petitioner.
Lordship, may I allow to, Lordship kindly allow me only 2 minutes,
22,
Lordship.
Yes. Mr. Dalai, you are along with Mr. Jena, Mr. Vijay Jena.
Jena, Lordship.
Mr. Sukanta Kumar Dalai, on behalf of Vijay Jena for the petitioner. Mr. Suryanarayan Das, additional standing counsel for the opposite parties. State. Khali state petition now kya
No, state, Lordship, state now,
State,
Lordship,
only
I file
state.
amendment petition. Now, for the state, Lordship, for the state there. Lordship,
for opposite parties, plural.
Parties, Lordship.
Upon amendment file kurchanti?
No, Lordship, kindly I'm just giving little background, Lordship, only 2 minutes, Lordship. Kindly allow me only 2 minutes. Because it's unheard, Lordship, in the earth, Lordship. Such type of, Lordship, illegality cannot be done by any person in the world, Lordship. Lordship, kindly, I am just, Lordship, addressing Honorable Justice Raman. Lordship, I remember this matter, Lordship. Your Lordship, state and Lordship come to order date 13/5/2026. By way of a demand notice, Lordship, the mining officer, while issuing me notice, Lordship, he passed order of interim suspension of the operation of the mines, Lordship. And Lordship, kindly state come to order date 13/5/2026. In this order, Lordship, kindly state Lordship come to last part, para 8, Lordship. That I had para 8 of the order, Lordship. Lordship, may I read, Lordship? We thus find a prima facie case having made out of an interim measure, we therefore stay the operation of the person of the so cause notice by which the interim order for debarment and or suspension of quarry and transporting activities is passed against the petitioner. The duration of the said interim order shall be till next date for listing matters you had on to 14 July, Lordship. And Lordship, here, Lordship, I have the city, Lordship, consent to operate. I have mining clearance. I have environment clearance, Lordship. I have consent to operate also, Lordship. And it is an existing mining, Lordship. That's why, because in absence of any provision of law, the competent authority had passed that order restraining for interim suspension. Your Lordship state that matter. Lordship, this Lordship happened on 13/5/2026, Lordship. Lordship, I served the copy on the officers on 16/5/2026 through email. And Lordship, I have sought personally to copy of the IIC and the person concerned, Lordship, for operation of order. And I started mining, Lordship. And Lordship, kindly on 21/5/26, one police SI came with his police force, Lordship, and entered to my premises and has seized, Lordship, 38 number of highways and 2 proclaimer and highways, Lordship. And by that time, he stopped the entire mining. So, Lordship, kindly state, the people of the case, Lordship, kindly come to my interim application. That is, Lordship, interim application bearing number 1054544, Lordship, of 2026. And state, Lordship, kindly come to page 8 of that interim application. Lordship, just bring you, Lordship's kind attention to the page 8, the front page of the FIR. Lordship, he has taken offense, Lordship, rest of the FIR under section 3032, Lordship, which is amounts to theft. And Lordship, kindly come to next offense 3 and 5, that is common intention, that is, Lordship. Then, Lordship, kindly come to serial number 368 of the Orissa.
Mr. Just give us a moment.
Lordship.
So, additional standing counsel. So, you are a party.
We have already intimated the authorities and not received any reply. So I sorted.
You don't have to request the authority regarding High Court orders. The question you first appreciate the kindly read 13.5 order.
I have gone through the order. And it is
another writ application.
So who are you to intimate or not to intimate the High Court order?
Your Lordship,
by the coordinate bench.
Your Lordship, with Lordship's permission, my Lord. So far as seizure of those highways, and your Lordship might have remembered on the last occasion when your Justice Sahoo was sitting.
Mr. Mahanti, if you are arguing, then argue, no problem. But kindly go through the order dated.
Yes, sir. That I am not disputing. Here
so
the
kindly
question.
read, sir. You
Here the question. For that purpose, he has already filed another writ application, my Lord. That
No,
is
Mr.
WPC number 16,900.
Mr. Mahanti, kindly listen, then you understand. Then by speaking, you cannot understand.
Yes.
You are struggling because you are not listening.
Obviously.
Read paragraph 8.
Yes.
Paragraph 8, order dated 13/5.
Yes.
Mr. Swami was there. He should have been here today also. Sanjeev Kumar Swami, additional government.
First paragraph also you have to read along with that.
My lord, here, 1 minute intervention, my lord. Here, why I have intervened, my lord? On the last occasion,
Mr. Mahanti, instead of continuing speaking, kindly read the order.
Yes, that file is not
So
with me since I was allocated. With another.
So you ask your learned colleague to read the order, whoever is having the file, because it is already order passed in that bench.
Mr. Da, it is with the.
So let him read the order.
Miller, we just find a prima facie case having made out for an interim measure with
So the challenge, first you read the paragraph 1, challenge.
Yes, Miller.
Not yes, my lord, it is written the challenge. Paragraph 1 is yes, my lord, kon lekha hai.
No. Case.
The Paunandi.
This one already with me.
Lamu pode podibo. The challenge is made to
challenge. Yes, the challenge is made to. No, sorry, I am reading. The challenge is made to show. Showcase notice added 26 issued by the mining officer of minerals Khorda, intimating the petitioner the various default and a violation of provision of content in the Odisha Mining and Mineral Rule 16 and as to why the order.
So that notice, that so-called notice 26/4/26.
Yes,
so that has been considered by this court. Then paragraph 5 is the rules and sub-rules. Then paragraph 7 and 8. Read paragraph 7 also.
Yes, well, I'm ready. Now I got it. We do not find from the above said provision that any interim order of debarment and or suspension to the query operation is conferred upon the authority. The authority cannot usurp the power to do a thing not provided in the statutory provision, nor can it issue any direction without any conferment of power in the statute. The rules and or regulation applicable in this regard. We thus find a prima facie case having made out for an interim measure. We therefore stay operation of the portion of the so-called notice by which the interim order for debarment and suspension of query and transporting activities is passed against the petitioner. The duration of the said interim order shall be till the next date of listing. That is the order.
So Mr. Mahanti,
yes, ma'am.
You or your authority cannot reinterpret the order.
No. There is no question of reinterpretation. Yes, I am trying to explain. I'm trying to explain.
Mr. Mahanti,
kindly bear with 1 minute.
So we are bearing with you. Rather, we are bearing with you too much because you are defending the undependable.
No, my lord. I am defending
You should have filed an application before the court for any variation. Have you filed it?
No, that here I am not on that, my lord. Your lordship is absolutely correct.
You may not be on that. You may not be on that or whatever. We are watching your activity, Mr.
Ganalok, now you come to
perhaps I am not able to. Perhaps I am not able to make your lordship.
No. You are so clear. You are so clear that is how we are responding.
Please come to IE.
This order has been passed. Have you sought for any variation before acting?
No, my no.
So that's it. So by which order you are acting on this?
Yes, my lord. That I am coming. That I am coming. Your lordship.
No, you need not come. You straight away come to the page. We are not expecting you to give any speech on that.
Yes,
by which order you have acted upon by seizing that, violated that interim order?
No, there is no question of violation. Here the police has read this authority. Your lordship, I am just trying to explain. On the last occasion,
you informed us.
On the last occasion, your lordship directed in another application to obtain instruction, my lord. That I am trying to explain.
Mr. Mahanti, the police is not aware of the High Court order. Is it your submission? Will record that?
No, my lord. Police under what?
So be careful.
No.
Your person is recorded.
No.
You must understand that.
Yes, my lord.
Mr. Ganalok,
I may be forgiven.
By folding hand, it doesn't improve, Mr. Mahanti. If you are saying
I'm not.
Police is not aware of the High Court order. By pretending that, we'll record that, no problem.
No.
But you have to be bold enough to say that.
My lord, here, your lordship, I am just explaining, my lord. One thing, just 2 minutes, my lord. Your lordship.
Mr. Mahanti, whatever you will say, we'll record it.
Yes.
Please don't say that not to be recorded.
Then your lordship may.
No, not then. You are not showing any charity.
No, charity is on. Then their lordship.
The order was issued to mining authority. Seizure is by the police
then
authority.
Seizure, under what circumstance it was seized? That your lordship has already asked for instruction. On the last occasion, well, your lordship was sitting with Justice K.R. Mahapatra. On last occasion.
Mr. Mohanty, you are speaking to a microphone. You don't have to raise your voice or don't be so animated.
No question.
So, court,
is it not
we
my?
have,
It is not my
the
personal.
prerogative to shout, but we are not shouting.
No, not shouting.
So you are not making out arguing Kesavananda Bharati that you have made the point that they should file a writ application challenging the illegal action of the
They
police.
They have filed already.
That is not the question. So,
yes,
that
in that case, your lordship has already
asked
me to
Mr.
take
Mohanty, if you listen, then you will understand. By speaking, you cannot understand. Don't get tired and nod your head. They should challenge that illegal action that is in their favor. But your question is not asked whether they have challenged that or not. After this order, who has passed this? Whether the authority who has done this is aware of this order or not? That you are answering.
No doubt, everybody, the authorities are very much aware about this order. There is no dispute. Therefore, the instruction has been sought for and it has been adjourned.
So we were recording the contempt.
No. Here the question is, my lord. Here the question is, on the last occasion, your lordship has asked for instruction under what circumstance that was seized.
Mr. Mohanty, actually, unwittingly, you have stated the truth. They should have challenged the second action.
No, not challenged. They have already challenged. Should have no. They have already challenged.
Exactly. They have challenged it.
And in that case, your lordship has.
Your
lordship, 1 minute. Your lordship on that writ application.
Mr. Mohanty, instead of continuing speaking, because we are in VC, it becomes difficult. You complete your submission, then we will record. After you say that you have completed, you go on saying.
Your lordship, 1 minute I am saying, my lord. On the last occasion, this matter was listed where the police personnel has seized 38 number of highwas, 2 number of other mercenaries. When it was the police, and the allegation is that in spite of the interim order that was seized. Here the police raided the query not for the purpose violating the order of this honorable court, but on getting an information that illegal mining is going on, illegal sand mining is going on. Therefore, the police raided, and that was done under 106 of BNSS. And subsequently, when they saw the police, they fled away from the spot. Therefore, nobody was there to explain.
Are you justifying, Mr. Mohanty? Are you justifying the action of police or not?
No, I'm not. Just the instruction
Sir, your instruction is very sacrosanct. We have got over that. But your problem is that you are not listening. That is how you are unable to understand anything. Your point is well taken that police has done this. The question to you is that after the High Court's order, police has done it being aware of the High Court order or not?
No, as per instruction, they have not aware. What they have said that we have not done it.
We'll record them.
We will record that.
But that matter may be listed along with this so that this instruction may be.
We are not seeking your advice how to list. We are asking.
No, man. This is my prayer. You are mine to advise your lordship. I am only praying.
You are appearing for the police to say that they are not aware of the High Court order. Is it your case?
Your lordship, the instruction which they have submitted, I will file in affidavit. Your lordship may take this matter along with.
Sir, now don't withdraw. You have already said that you are not aware. So we'll record that.
What instruction I have that must be come in the affidavit, man.
So that is
you file it, but that doesn't mean that you have to detain us.
No.
So now you are satisfied.
Why your lordship? Why your lordship is saying pretend? Other things. I'm only submitting.
Unless, Mr. Mohanty, if you go on speaking, you cannot understand. That is a major roadblock. Now, have you completed your submission, Mr. Mohanty, or anything else?
Yes, everything has been completed.
Okay. Yes, Mr. Das. Mr. Surendra Das, your submission?
Mr. Mahadevan says I agree.
Okay. Yes. The appearance like. So Das ka sir, Mr. Gyanalok Mohanty, standing counsel village. The IA has been filed. IA is 10546. 10544 of 2026. The IA has been filed, bringing on record the lodging of PS case number 234 of 2026, dated 22/5/2026. And the action of the police and the action of the authority.
They are not sure ki kar. Action of the authority in seizing.
Specific.
Action of the authority is conducting raid in the petitioner's leasehold query area, seizing 38 Haiwa vehicles. Haiwa the back at this trucks, earth moving trucks, 2 proclaim machines and 1 JCB machine. Apna a brand name no leki ki apna taku tar machine ta lekhi dele bhalo ta. Kon ta authority buja jabe.
FIR jaha likhne se quote kar deji lordship.
JCB machine deployed in the query operation. Paragraph 4 and 5 of the application are reproduced here.
Sir, proclaim machine what?
Jada lecture diyo. It is seek lek.
Proclaim.
Machine ta ki apna tar achi gote. Ta generic name gote achi. Loader, tipper.
Lordship.
The Learned Counsel refers to the earlier order passed by this coordinate bench of this court, dated 13/5/2026. In WPC number 14479 of 2026, which was passed in the presence of the Learned AGA for the state. And after hearing the Learned AG, the relevant paragraphs of the said order dated 13/5/2026 are reproduced here. 1, 2, 4, 5, 6, 6 to 9, brother. 6 to 9. It is submitted that despite the state being party before this court, submitted by the Learned Counsel for the petitioner that despite state being party in the writ application and interim order having been passed, fixing the next date to 14/7/2026 in flagrant violation of the said order, the authorities have acted as indicated in the IA number 10544 of 2026. The Learned Additional Standing Counsel submits that he has sought for instructions and he shall apprise this court. On being pointedly asked whether the authorities have acted, being aware of the court's order dictated the order dated 13/5/2026 passed by the coordinate bench, the Learned Standing Counsel, who is also present, submits that the action as alleged in the IA is by the police authority, inter alia suggesting that the police authority has acted against illegal sand mining and he shall obtain further instruction in the matter. It is submitted that WPC number
16,900 of 2000.
16900.
16900 of
2026.
2026.
Again.
2026 has been filed challenging the action
of the police
as indicated in the IA that was listed before the before another coordinate bench on
vacation bench on 26/5/2026.
26/5.
BC 5/2026. Before the vacation bench on 2026, 5/2026, and state has has been granted time to obtain instruction. By both the matters shall be listed together before the assigned bench in the week commencing 29/6/2026.
Lordship, can it be next sitting, Lordship? Next sitting, Lordship, because entire 40 vehicles are with them. And very peculiarly, the ASI has seized. No law has.
Mr. Dole, you have to, this amendment petition has to be allowed.
Yes,
and you have to include those.
And you have to be patient also.
And
you have to be patient also.
Then consolidated petition has.
Though we are conscious of the fact that the matter is adjourned to 14/7/2026. We are of the prima facie view that the interim order passed by the coordinate bench dated 13/5/2026 has been violated by the state authorities. Though as stated by the learned standing council, it is by the police authority and not the who are not parties in the said proceeding. Be that as it may, the authority initiating the action that has related in seizing of the vehicle and other action taken as indicated in paragraph 4 and 5 of the interim application shall file affidavit stating the circumstances in which the matter was proceeded with. It has also to be specifically stated in the said affidavit whether the authorities were aware of the order dated 13/5/2026 passed by the coordinate bench. Stop. Since a stand has been taken by the learned standing council that both the proceedings leading to seizure and other coercive action is attributable to the police authority proceeding parallelly, it shall also be clearly indicated in the affidavit under which provisions the authorities have acted.
Correct.
Amendment application. See,
amendment application na kete.
Lordship, second, I would amendment Lordship, this case. Now police stopped mining. Now Lordship, peculiar police stopped mining. He is not allowing to operate also.
Se karantu. Se takarantu. Se to agitated be also. By 1 week, 1 month they pulled up.
Lordship, amendment petition, Lordship, that is.
Mr. Dole. Mr. Dole. 10546.
Amendment, Lordship. Lordship, get
0546 of 2026. Application has been filed seeking amendment of the writ application. Copy of the amendment application shall be served on the opposite parties.
Already served, Lordship.
Already, sir. The copy of the application. It is stated by the learned counsel for the petitioner that the amendment application has been served. Amendment allow hoga na objection debe.
Mr. Gyanalok.
I'm not on that. Mr. Das is that.
Mr. Suryanarayan Das.
Yes, Miller.
Amendment.
10546. IA number 10546.
Amendment copy is not with me.
The learned AAC submits that he shall find out the copy of the IA and make his submissions on the next date. Yes.
Lordship, can it be reopening, Lordship? 22 better upon this topic. 22 better.
Sabu jaka pile up kar dele, there is a problem. Our listing mechanism will fail. Kon sabu jinsa setbeta immediate kara hoche.
Lordship.
Item 23.
Lordship, grateful, Lordship.
After item number 23, I will just take one line for item number 7 minutes. After item number 20.
23, sorry, Joe.
Yes, ma'am. Item 23, I am permitted to withdraw this writ petition. I filed an
urgency.
My lord, here what happened? I have gone through a judgment of this honorable court.
Actually, urgent matters which cannot wait till you please.
It will be public interest.
Actually, it is
sir, eta jehetu more home district auchi, they have discussed all these things, and in view of judgment of this honorable court, nothing survives. So I may permitted to withdraw this writ petition. So outsourcing.
How do you justify urgency and listing? Explain, Mr. Moon. It is a matter of record.
My lord,
It's a matter of record. So it is better it should come in the reopening week.
My lord, one thing, my lord, as because the district administration also requested, yet this is a hospital matter. So outsource is required for them to maintain the day-to-day activities of the hospital. So they requested, and accordingly we have discussed, and I have also gone through the judgment of this Honorable Court in WPC number 24882 of 2025.
No, I understand, Mr. Since this is a special bench taking up only Vic.
My lord, I do consider, my lord, as because this is a medical urgency.
So it has to go before the assigned bench in the week. Maybe
my lord,
make it 29
because this is a medical urgency matter, that's why I pray before your chief may consider and allow me to. Nahi kintu se karu nahanti se rahi jaichi jinsota, as because this case is pending. That's why on request of all parties concerned, so including administration.
So have you filed a joint memo?
Joint memo thei paribo na eta jetu notice ta other side
How we will take it up in
my lord, state ku jetu notice heichi, other side ku notice heini, joint memo also not possible.
State be koi thante, state could have made that prayer also.
I know state ta kariben.
Yes, so what do you say, Mr. State, Mr. Government?
I am appealing for the statement.
Yes, Mr. Kora.
Simple withdrawal.
Mr. Kora, so what do you say? He says that state has instructed him to withdraw it. I mean,
on that account, I have no instruction, my lord.
Now, do you have any objection?
No objection. If you want to withdraw.
Okay. The matter has been listed for orders under the heading for withdrawal. Apparent that Mr. Dhananjay moved for the petitioner. Mr. K.C. Kora, government advocate. The matter is listed having been mentioned by the learned, mentioned on behalf of the petitioner. The matter was earlier taken up before the assigned bench, for the assigned coordinate bench on several dates. On being asked the learned counsel for on being asked regarding the urgency of the matter being listed for withdrawal, the learned counsel for the petitioner submits that the petitioner does not want to prosecute the litigation. Second, successful bidder na kono se.
Na eta je process se kon 3.85 jo service tax ta jota hutila. Others have quoted 1 paisa less and I have quoted 1 paisa more. But they have assessed it at 3.8.
Status kono.
Final tender is going on.
He's a participant in a tender process, which is yet to be finalized, and he does not want to pursue the litigation. Though we have our reservations regarding taking up of the matter during vacation being urgent, but in view of the innocuous prayer made by the petitioner, we have also asked the learned government advocate who submits that he has no objection if the matter is disposed of as withdrawn. Mr. Ramdas Achari appearing for?
There for formal party OP number.
National Health.
Appearance like Mr. Ramdas Achari for
yes.
What party? Kitna number party?
Four.
State Mission Director. 4 no hai.
OP not 4. Chief District Medical and Public Health Officer.
State Mission Director NHM hochandi 2. CDM and PHO Mr. Kora. Tale mu dakicho thile kunti. Appearance likhiwe Mr. Dhananjay Mood, Mr. K.C. Kora AGA, the AGA government advocate. 1, 3, 4.
So two times.
Mr. Ramdas Achari for 52. Upon a 4 pai.
4 be say NHM.
Only for two, my lord.
2. CDM PHO, Mr. Hello. This matter relates to health. We have asked the Learned GA who submits that he has review of he has no objection if the matter is permitted to be withdrawn. Mr. Ramdas Achari, also the Learned Counsel for Appellate Court 2, also takes a similar stand that he has no objection if the matter is permitted to be withdrawn. Accordingly, the matter stands disposed of as withdrawn. So this matter relates to also.
Outsourcing of housekeeping services at government health institutions.
The matter relates to outsourcing of housekeeping services at government health institutions. With a request for proposal, RFP reference number, cost letter, yes.
Item 7, I want to array
Yes,
one
Mr.
more.
Nanda.
Yes,
Mr.
item
Nanda.
7, I wanted to array one more party which is at serial number 12 under annexure 4.
ଆପଣ ଯାହା କରିବେ ଆଉ ଆପଣଙ୍କର 1 2 ଥିଲା 3 କଲେ 4 କଲେ ବର୍ତ୍ତମାନ 5 6 ଯେତେ କରିବେ ସାର୍ ଲେଖିକି ଦିଅନ୍ତୁ
Lordship, this is
ସେ ନୋଟିସ ଟା ଚେଞ୍ଜ ହବ ସେଟା ଆଜି ଆଉ ଟାଇପ ହେଇ ପାରିବନି ଆପଣ କାଲି ସୁଦ୍ଧା ମାଇଣ୍ଡ ମେକଅପ କରନ୍ତୁ କେତେ ଜଣଙ୍କୁ ନେବେ ନୋଟିସ
ନାଇଁ ନାଇଁ ତିନି ଜଣଙ୍କ ଭିତରେ ଲଟରି ହେଇଛି ତେଣୁ ଇଏ ବି ଥିଲା
ସମସ୍ତଙ୍କୁ କରନ୍ତୁ ପାର୍ଟି କରନ୍ତୁ
ନାଇଁ ସେ
ମୋର ଦ
12
ମେରିୟର sir can we object to you making a party ठीक ଅଛି
serial number 12 under annexure 4 और सही सेम पार्टी होची serial number 5 under annexure 7
ଆପଣ ଲେଖି ଦେବା ଏଟା ରିମୋଟ ଲୋକେସନ ଏ ପ୍ରୋବ୍ଲେମ ଟା ହବ ଆପଣ ଦିଅନ୍ତୁ
sir I'll write
sir amendment is allowed notice will be issued
yes
already we have allowed that na
yes I'll add this party
yes,
serial
yes,
number
yes
Nischint services
yes
allowed deeply open
so that's it the single benches will resume at staff has to go for lunch and all that. We will resume around 3 to 3:15.
Sir, actually also print up for study.
Recording stopped.
With the Lordship's kind permission, may I make a small request, Lordship?
Audio task.
My lord, may I mention, my lord?
Make a mention, my lord.
My lord, I may be permitted to make a mention. My lord,
the court regulations.
your lordship may
just give us few minutes. We'll get through. There is some issue. I hope you are listening to me.
Yes, your lordship is audible.
Voice is not coming.
Your lordship is audible. The staff here.
Yes. So yes. Give it to Silpa madam is there. She can take it.
Yes, I'm giving the memos, my lord. Your fifth, if your lordship.
But don't create, confusion. Write it that it is already mentioned on Monday.
Yes, I'm writing, but.
Yes. So already mentioned on Monday. Just simply mention that. That will help in tracing the file.
All right, man.
Pardon to make
Pardon to make a mention, my lord.
Any learned counsel who has mentioned the matter on Monday and it has not today in the list, this could not be accommodated. Please be patient till Friday.
Yes, yes. I have given memo. Yes, my lord. Yesterday I have mentioned.
And only help I will be seeking just upon jodi author seta gote mention kare out slip dei debe mentioned on Monday has a file khojibare problem habani.
Mention it was mentioned on Monday. My matter also mentioned on Monday.
I have also mentioned it on Monday. I have some urgency.
ठीक अछि सुनंतु Monday जोटा Friday दिन सुधा हे जिवो. We are trying to do that.
आगे
आपनकर जेतु ए वीक रे कोन हेछि ना सेम डिवीजन बेंच and same single bench after division bench.
My lord, one eviction matter can be taken up on Monday, my lord. Eviction matter.
Monday sir, Monday तो sir नहीं मोर Friday हे अछि sir.
Friday can be taken up.
काली दियंतु sir. आपण sir मु oral mention नहुनी. Please appreciate what Mr. Bose and Madam Mahapatra they are saying that their matter they had dropped it in the Dropbox on Monday but not listed.
Can we take
that is the reason my lord mentioned before your lordship.
Mr. Panda काली दियंतु.
काली sir my lord
आपनकर जेंति normal procedure रे
eviction
memo रे खाली लिखा हुआ it is mentioned on Monday.
आगे
my lord today
डेट टा पकि देबे मंडे थिला होची 1 तारिख
eviction matter my lord
today misplace हबनी.
my lord
most of the eviction matters are like
eviction matter माने
so I think it could be
5/6/2026 रे माने भंगा हे जो तेनु म आज चाहू आज नै परि
अरे 5/6 रे भंगा हो जे आपण तो सर आपण मेंशन मेमो दे
फाइल कर दै फाइल कर दै
अरे मेमो देइथिले कि कोन कोइटा आलोचना होची मेमो 1 तारिख दिया हितला कि
हां मु मेमोटा तो देबेनी आज
फाइल केबे कले
आज फाइल कली
आज फाइल कले काई ताले दियंतु काली दियंतु
ते 5 तारिख भांगी दे
सेटा आपण गोटे काम करि परिबे मेमोर कॉपीटा देई परिबे अथॉरिटी जदि अपियर करथिबे. एज ए लॉयर आई हैव टू एडवाइस यू मेमोटा जेतबेले फाइल करा जाय ताले आपण देई परिबे गवर्नमेंट को देबे जदि गवर्नमेंट भांगुथिबे म्युनिसिपालिटी भांगुथले ताको वकील को देबे बुझ पड़छन्ती कि डेवलपमेंट अथॉरिटी ले ताको वकील को देबे. आज आपण जोटा एबे एक्चुअली मेंशन करछन्ती जेटा मंडे रो मेमो से कहउछन्ती प्लीज एप्रिशिएट दैट. हां आपण आज जोटा फाइल कली त से नॉर्मल प्रोसेस दिया होची आपण गटे तो ओरल मेंशनिंग टू ए बेटर मेथड एथरे सब जाका मेमो ड्रॉप बॉक्स रे अलाउ करा गला. कोर्ट रे ओरल मेंशनिंग दरकार नहीं सर नोटिफाइड भी नो
चाहूली आज नवा पई जे आज आ टाइम तो
आज आ ये करंतुनी आज गले देखंतु मंडे रे मेमो बाकी रही यू शुड बी फेयर टू एवरीवन.
यस
my lord sir I may be pardon my lords my lord item number 20 my lords
again
if before rising can it be taken off if not earlier
because yes I am trying to tell you
from tomorrow I am not be there sir that is the my petition.
Yes I noted your mention is noted. You told in the morning that you will be absent. Yes
item 32 your lordships. Item 32 demolition date is fixed to tomorrow. Anyway your lordship may take this matter today. Item 32.
Thank you. Let us see. Let us proceed fast with the list.
Mine.
Yes, Mr. Lenka.
Yes, madam. May I please?
Kumar Lenka for the petitioner. Mr. Dayanidhi Lenka for the AGA for the
all the opposite
party. Yes.
May I please, lordship?
Yes, Lenka versus Lenka. Yes.
Well, in this case, my lord, I have challenged the eviction notice by annexure 10 page 64, my lord. Issued by
one uniform order, Mr. Lenka, Mr.
My lord, in this case,
information of not an AGA, Mr. Poda, Mr. Mahanti, Mr. Lenka. So status quo as in date.
My lord.
The petitioner is before this court challenging the eviction notice annexed to the writ application marked as annexure 10. Date टा जाना पड़ुची
आगे 23/4/2026
डेटेड 23/4/2026 proclamation that 23/4/2026 the hearing date being fixed to 11/5/2026 stop आपण 11/5 पर eviction हे नहीं कहउछथि
नहीं हे नहीं
issued by the तहसीलदार तुमुडी बंध हैला
It is submitted that though the matter was fixed for hearing on 11/5/2026, the proceeding has not been taken up. Proceeding has not been taken up. The petitioner is yet to be evicted. Stop. Issue notice along with this order. The learned AG, upon advance copy served, appeals and waives notice on behalf of opposite parties 1 TOB 4. जोटा मैं जल्दी ही जो मतलब कहना स्लो डाउन, डोंट बी एप्रिहेंसिव, ना आराम से ये करो. He submits that he will obtain instruction in the matter. इधर revision pending अछि.
Revision pending. Revision is pending.
Okay, it is submitted by the learned counsel for that. ठीक है आसिले सी कौन मिलिट्री मोटर देलेनी.
नहीं रिविजन एपर्यंत एडमिट ही पालनी रिविजन ला. So that
there is a delay, man.
So that petition approach before this honorable court.
Commission that petitioner ko lekhantu, the revision against the order of the Tahsildar is pending before the sub-collector Kandhamala.
Against the order of sub-collector before the collector.
Okay, sorry. I stand correct. Thank you. The order directing eviction by sub-collector is challenged in revision and is pending before the collector. Kandhamala. Stop. Sita ta pore likhibe dejiye. Issue notice along with this to the AGS shall obtain instruction and file counter by the opening.
For issue.
Okay, as you get the counter shall be filed by TDC and 2/7/2026.
Yes.
The matter shall be listed for admission in the week commencing 6/7/2026 before the assigned bench. তারপর লেখুন তো IE the hard learned counsel for the petitioner, he reiterates his submissions as noted above. Issue notice as above. Learned AG appears and gives notice. We shall file his response along with the CORAM. In the interim, it is directed that till the next date of hearing, status quo as on date regarding nature, character, possession, and ownership of lot number 2142, Atta number 381, Rokoba, area, hectare HC 0.156R. Coercive actions shall be taken without leave of this court. The interim order shall continue till the next date of hearing. So, ऊपर आपके जो date अच्छी से repeat कर दो.
My lord, one thing I pray. Downloaded copy may be accepted.
अच्छा, urgent certified copy as per rules. The parties shall have liberty to act upon the copy of this order obtained from the official website of this court.
Obliged, my lord. In this matter, my lord, the petitioner has challenged the Annexure 1, that is the order issued by the Tahsildar to demolish a portion of the house. In fact, your lordship, Annexure 2 is that
same order for them.
Here, no. Sorry, man. Your lordship may kindly see order data 29/5.
Yes.
I'm placing my lord.
Status quo. Deeply obliged, my lord.
29/5/2000. No status.
अच्छा, आपको एक modification file करना है?
No modification, no. Kindly have a glance to the last order. That para 2 of the last order. That has
your lordship may kindly
Mr. Raj Singh, आपको para photo टिके पढ़ो तो.
Mr. Das Learned, Additional Standing Counsel on Inspection, submits that the part of construction has already been demolished, but the rest of the encroachment could not be cleared.
Para 4 hochi since the eviction notice.
Under Annexure 1 has been issued pursuant to the direction of this court. In WPC number so and so, I am not inclined to grant any interim order.
So, apanakara detailed modification darkar. The order in WPC 24289 and order of the court bench in 29/5/2026.
As because the regular bench is not there, for that reason I have filed an.
Regular bench कौन आपण जो रीट टा फाइल कले
आज्ञा
17125 की फाइल करछन आपण फाइल करछन
आज्ञा
सो हैव यू सॉट फॉर मॉडिफिकेशन ऑफ ऑर्डर इन WPC 24289
I could not get the chance, your lordship, because the notice has been issued.
Sir, when you are challenging that in a read petition कोन कहउचंती
ए नोटिस टा मु चैलेंज करछ
अरे आपण WPC 24289 रे आपण तो सेटा मेंशन हेछि आपण कर
सेटा मु पूरा एडिशनल एफिडेविट रे लिखिछि दैट ऑर्डर वाज राइटली पास बाय दिस ऑनरेबल
आपण WPC टा फाइल करिसंती
नहीं WPC टा हम अपर पक्ष फाइल करछ सेथिरे ऑर्डर अछि पारा 2 रे नो नोटिस
एक रे पढिबेनी तरबर हेबे बुझी भी पारना आपण को नाम जे शशिभूषण प्रताप
आज्ञा
आपण फाइल करना तो अपर पक्ष फाइल करछि
रीटा पूर्व
नो आज्ञा 17125 तीन थर कहले
आज्ञा
जो दिन आपण 17125 फाइल कले से दिन आपण फाइल करथिले मॉडिफिकेशन ऑफ द ऑर्डर इन द बाय द कोऑर्डिनेट बेंच
नो
अदर केन दियो आपण सेटा आइदर अपील चैलेंज करिवे नहले मॉडिफिकेशन चाहिए दी बाड़ी की नहले फाइल करिवे जा करिवे
रीजन इज दैट मिलर द नोटिस वाज इश्यूड upon me after vacation मिलर आफ्टर
You have not understood the point.
हाँ मु सेटार मो
आपण टिके पढिबे Annexure 1 टा
आज्ञा
ओडिया रे लिखा है ओडिया पढि आपण तो ओडिया मीडियम ओडिया पढ
आज्ञा उपरोक्त विषय प्रति दृष्टि आकर्षण पूर्वक आपण मानक अवगति निमंत्रण जणाउछि कि माननीय उच्च न्यायालय ओडिशा कॉन्टेक्ट नंबर सो एंड सो अराइजिंग आउट ऑफ WPC नंबर सो एंड सो संख्या आदेश संख्या डेटेड सो एंड सो अनुसार मौजा मुकुंदपुर स्थितिवान खाता नंबर सो एंड सो प्लॉट नंबर जो
रही जान सो पढले बर्तन तो बुझी पारले
आज्ञा
आपण ए रीड टा फाइल कले 25/5 रे
आज्ञा
सो सेतिर ऑर्डर हैला
सेतिर जो ऑर्डर हैला
25/5 रे फाइल कले यू शुड हैव फाइल्ड मॉडिफिकेशन ऑफ दैट
but no regular bench is
one bench will pass order then there is a order in contempt thereafter another bench will go pull in the another direction.
Yes, your lordship, that I am clarifying. The order is very clear. Order रे से जो पूर्व रीट order is very clear. No notice needs to be issued to private opposite parties as the matter is disposed of at the stage of admission. Then in paragraph 8,
when I saw you last time, you were disoriented. Today also you are disoriented. Have you challenged that order passed in the writ petition earlier or not? Or you are challenging in this writ petition?
In that writ petition, no notice was served upon me. That when this
so what you will do? So when no notice is issued, I will modify the order.
When the notice was issued, then only it came to knowledge.
When the notice is not issued, another bench will modify the coordinate bench's order.
Because if I will file modification and if that will come on regular bench, your lordship, by that time they will demolish my house.
You have not marked the dates. आपण 25 रे रीट रे फाइल करे टेक अप हेची
25 रे जो टेक अप हेची सेतिरे स्टेट कहले मु इंस्ट्रक्शन आनी
25 रे you have specifically annexed that order only.
25 रे जो मु इंटरिम ऑर्डर मागिली स्टेट कहले आगे हमें डिमोलिश कर देइछु एडिशनल स्टैंडिंग काउंसिल ले
से डिमोलिश कले कि तयारी करे
इंस्ट्रक्शन देबे कहले
the way you are moving you are not seeking modification, you are not seeking any leave to challenge that order or whatever.
No, I will modify that order, but later
that jurisdiction is not there with a vacation bench or a single bench in regular matter to modify a coordinate bench's order.
But what I'm after this order was passed, my lord, after 2 years they have
you do whatever. So if you insist, I'll reject your prayer.
May I pray one thing, your lordship? May I pray one thing, your lordship? Let the matter be taken up after vacation. After vacation, I will file a modification order of the previous writ petition.
For that, I am not the counsel. I am the judge.
I pray only
you are saying
status quo to be.
I will file a modification. You have not filed a modification. You are coming here.
status quo to be maintained till the next day.
Who should grant you status quo in the contempt of the writ? Who will grant you status quo? Another bench.
I am nowhere concerned with that. Nowhere.
So if you are not concerned, so I'll record that. You must understand what you are submitting.
Yes, your lordship,
if you are
that-
saying that you are not concerned with the other High Court order, your writ has to be dismissed.
ଆଜ୍ଞା ଗୋଟେ ଖାଲି ପେଜ 17ଟା ଆମ ଆଡିସନାଲ ଆଫିଡେଭିଟ ଦେଖି ଦିଅନ୍ତୁ ତାପରେ ଇଓର ଲସିପ
ଆପଣ ବୁଝିବା ଅବସ୍ଥାରେ ନାହାନ୍ତି।
ସାର୍ ଗୋଟେ ମିନିଟ ଗୋଟେ ଖାଲି ଗୋଟେ ମିନିଟ
ଶୁଣନ୍ତୁ ଆପଣ ବି ଗୋଟେ ମିନିଟ ମୋ ଅର୍ଡରଟା ଶୁଣି ଦିଅନ୍ତୁ ତାପରେ ଯାହା ସମୟ ନାହିଁ କାହିଁକି ଆମେ ରନିଂ ବିହାଇଣ୍ଡ ଦ ସେଡ୍ୟୁଲ।
ସାର୍ ସେଥିରେ କହିଛନ୍ତି ତହସିଲଦାରକୁ ଅପରଚ୍ୟୁନିଟି ଅଫ ହିୟରିଂ ଦବାକୁ ସେ ଅପରଚ୍ୟୁନିଟି ଅଫ ହିୟରିଂ ଟା ଆମକୁ ନ ଦେଇକି
ଏକ୍ସାକ୍ଟଲି ସୋ ସେଇଟା ନାଉ ଆଟଲିଷ୍ଟ ୟୁ ହାଭ୍ ଟିକେ ବୁଝିଲେ ସେଇଟା ଆପଣ ସେ କୋର୍ଟରେ ସେଇଠି ସେ ରିଟରେ ଅର୍ଡର କରିବାର ଥିଲା।
ବାଇ ଦ୍ୟାଟ ଟାଇମ ଦେ ୱିଲ୍ ଡିମୋଲିଶ ମାଇ ହାଉସ ୟୋର ଲସ୍।
ଆପଣ ଡିମୋଲିଶ ହବା କଥା ତ ଦୁର୍ଭାଗ୍ୟ ଆପଣ ବୁଝି ବି ପାରୁନାହାନ୍ତି। ଆଉ କାହାର ଡିମୋଲିଶ ହବ? ହାଇକୋର୍ଟ ଯୋଉଠି ଅର୍ଡର କରିବ ରିଟ୍ କମ୍ପ୍ଲାଇ ହବନି?
ଆଜ୍ଞା
ହାଇକୋର୍ଟ ଡିସିସନ ଭଙ୍ଗା ହବ।
The order is very clear, which says that opportunity of hearing shall be given, but they have not given me that opportunity.
Haikort direction रे भंगा हवा कथा हबो contempt हैला contempt order हैला comply करो।
Consider the representation order हैला opportunity of hearing दिया हैला opportunity of hearing टा न देई कि ना से माने vacation time रे notice करके vacation को
ए जो स्पीच टा आपण दोचंती ए स्पीच टा न देखि आपण सिंपल गोटे आईए फाइल करथाते से ऑर्डर से ये रे आपण 25 रे फाइल कले 29 रे ऑर्डर हैला बर्तन वेकेशन रे गोटे स्पीच देले आपण 25 और 29 रे should have moved that done that
modification file
and you know I have received
I cannot modify. Yes, Mr. Ling.
Yes, I have received instruction, my lord. What happened, my lord? On 29/5, this was demolished. Again, he has constructed, again reconstructed. Now he is coming for status quo. I have received the instruction, my lord.
So that could be the reason Mr. Raj Singh is unable to understand. Because his client has instructed that after demolition and order by the High Court and contempt, it has been demolished. So now he's trying to get a status quo order. Could be. That could be the reason. I was thinking that a lawyer with Mr. Raj Singh's experience is unable to understand that there is a High Court order. I will pass the order not to comply with the High Court order.
Sir, I am not getting a scope to say submit my submission.
Sir, you take your time. How much time will take? How much time will take? How much your time? आपण केते समय दरकार कहू ना? No difficulty. A pretension रे काम दबनी. This pretension of not getting time is not is only आपण कहू ना कहंतु. Carry on.
The only thing I will submit.
Again, law रे राग रुषा करंतुनी जा कहवा कथा कहंतु.
More during the pendency of my RC case, the notice has been issued, which is illegal, and the writ petition filed by the opposite party. That order was very clear, wherein it was mentioned that no notice to be issued and opportunity of hearing shall be given. That has not been. That's all. That is my case, your lordship.
The petitioner had noted counsel for the petitioner. The petitioner has approached this court by filing the writ application on 25/5/2025, which was taken up by the coordinate bench, coordinate assigned bench. After hearing the learned counsel for the petitioner, since joining, and the learned counsel, additional standing counsel for the state, the following order was passed. Today, the matter is re-argued by the another counsel, Mr. Raj Singh. He is apprised of the he is apprised of the situation that already the matter was taken up by the assigned bench, and there is an order dated 29/5/2026, wherein the assigned bench had noted the order of this court disposing of WPC number 24289 of 2023. On being asked, the petitioner should have moved the bench that has passed the order dated WPC, the order dated dash in WPC number 24289 of 2023. By order dated 16/1/2026, almost 5 months back, the learned counsel for the petitioner submits that he has filed RC case, the petitioner has filed RC case, the RC case is pending. And
the order of demolition has been passed without hearing him. On being asked how this court can alter an order passed by the coordinate bench dated 16/1/2026 in WPC number 24289 of 2023 and the order passed in CUNTC number 4147 of 2024 arising out of the said writ application. It is submitted by the learned counsel for the petitioner. He has nothing to submit. It is submitted by the learned AGA refers to the earlier order passed by the assigned bench, appropriate assigned bench regarding denying interim order by order dated 29/5/2026 in view of the order passed by the coordinate bench in WPC number 24289 of 2023. So he further submits that as per his instruction, the construction paid by the petitioner, which was directed to be removed by the order dated dash passed in WPC number 24289 of 2023 and CUNTC 4147 of 2024. Has already been demolished
on 29/5.
On 29/5/2026.
A part of.
This court is of considered view that this court is of the considered view that it cannot modify the earlier orders passed by the earlier order dated 16/1/2026 disposing of WPC number 24289 of 2023 and the order passed in CUNTC number 4147 of 2024. The petitioner was well within his the petitioner could have very well challenged those orders or would have filed application for modification, which admittedly has not been done. The notice dated 19/5/2026 also indicates that pursuant to the order passed earlier, the demarcation has been made on 27/2/2025 and 9/4/2026. Stop. In such view of the matter, this court is not inclined to pass any order in the IA. IA ta kete? IA file karna thiyo. In the IA 10283 of 2026 that was taken up by the coordinate bench on 29/5/2024. The petition is adjourned. Shall be listed before the assigned bench in the week commencing 29/6/2024. Reporting to bench. Yes. Yes, next.
Item 3.
May I please, Your Lordship? Your
Yes.
Lordship, I am appearing for the petitioner. I am in VC. Your Lordship, in this instant
Yes,
matter.
Senapati for the petitioner.
Yes, Your Lordship.
Yes.
Your Lordship, in this instant matter, the petitioner has a shop near Bulla, Sambalpur. He had received a demolition notice. The same has been annexed by Annexure 4, Your Lordship. Your Lordship, if Your Lordship will see the demolition notice, there has been no mention of date on which it has been issued. And it is not a show cause notice as well, Your Lordship. A clear dates has been mentioned that within 4 days.
Whatever status quo only order can be passed, status quo as on date.
Indeed, Your Lordship, that is all I can
If it is there or not there.
No, my lord, there is a problem. Your Lordship may kindly see that notice itself. That notice itself, the impugned notice, Your Lordship may kindly see. The unauthorized.
page.
My lord.
Mr. Saroj Kumar Ji for
I am appealing for 3-4.
3-4. In item number 3-4, Mr. Bal is appearing, but in that impugned order, it is a common batch of cases filed. My lord, it is for unauthorized construction of road above and drain. Jabardakal Sambandh.
Yes, yes.
My lord, they have obstructed, encroached the road as well as drain. My lord, rain is coming. If the drains will not be cleared, if the roads were not expanded,
so when did you plan to clean the drain?
My lord, it is a notice. It was a reminder notice.
When did you reminder for cleaning the drain? I'm asking you, when did you plan to clean the drain?
It was earlier, probably.
So if you do not know, then say that I do not know. You are saying that you want to clean the drain. When did you plan?
That instruction I do not have. It was
because your argument it cuts both the ways. You are waiting the rain to happen, then to demolish and clean the drain.
Yes, my lord.
So I'll record
for cleaning the drain.
I'll record that you are waiting the rain to happen, then to clean the drain.
No. Before rain, it will be done.
So
what
prevented you from earlier? And so it is only Mr. G. It is only till the reopening.
Yes, then it is.
It's only till the reopening. Because if I record that you are now planning to clean it, then actually it speaks volumes about you.
No. It was.
I have to record. You have stated.
No. It was a planned earlier. It is a reminder.
Sir, when you planned, you should have removed and cleaned it.
Well, the municipality, as per the Municipality Act, my lord, 2003, my lord, the section 444, my lord, 404, the administration has full power. The statute provides the full power to demolish the unauthorized structure over the drain, my lord. That is the notice, my lord.
The problem is that the apart from municipality, there are other laws which say that they have to be given opportunity. The act and reasonable opportunity.
No, my lord, the act itself says that the entire municipality.
So you have to tell the court. You have to tell the court by filing counter that you have measured. They are
no interim order, my lord. My prayer there no interim order, my lord.
So interim order status quo as on date. If it is already demolished,
that is the purpose of the government will all be acted upon, my lord.
So you achieve the purpose by reopening in the next 4 weeks. You achieve the purpose after the 4 weeks. The same thing what Mr. G is saying that you want to clean it today.
That is my lord. If that will not be evicted, my lord, the people will be suffer.
They will be evicted. But you tell the court that they are because you are saying that whatever you are saying has to be accepted, and the petitioner says that he has not been heard, not to be accepted.
The municipality does say. So 8 and 9, the municipality corporation they have not appeared.
They have to respond to the court. They have to respond to the court. They have to. They must.
Let there be an interim order. We shall file this case.
No interim order, not protecting anyone. Status quo as on date.
We shall file this case.
They have to abide with the status quo order also. They will abide. If it is demolished, it is demolished.
My lord, your lordship may, my lord, I'm submitting, my lord. Your lordship may allow liberty to file the vacation of stay order, my lord.
That liberty I cannot curtail. That liberty I cannot curtail.
My lord.
Which provision allows that I will grant liberty, then can only you file.
My lord, oblige, my lord.
A order after granting that no coercive action, they have seized everything. This is the way you are dealing with High Court order.
Vacation court.
So where is the material for me to observe that they are encroachers, they are unauthorized, everything? That is the material before me. That is the issue.
Lordship may pass order, say vacation court we do not want to.
No, not only that. The plea of rain is for them also. ଆପଣ monsoon break kale safa karibe semane monsoon break kale ବର୍ଷା ରେ ଭିଜିବେ. That you must. So that is how I say that you take.
Yes, Lordship may pass orders.
And if it is illegal, it has to go. It has to go. They know that.
Don't keep lecture.
The petitioner before this court has approached
by filing the writ application challenges the notices issued by the opposite parties number case 7 and 8. 7 and 8. And Mr. Bodo, you find the perimeter provision in Corporation Act. Don't refer to Municipal Act.
And that is a Corporation Act 2003.
Okay.
That Orissa Municipal Corporation Act 2003.
Okay. Because Municipal Act, actually, there is another definition.
And that is the Municipal Corporation, my lord.
So they will fight. They will fight.
My lord.
Yes. Okay. 8. Under sections 406 and 408 of the Orissa Municipal Corporation Act 2003. Directing the petitioner for removal of soft structure situated at Burla, Sambalpur within the municipal corporation area of Sambalpur.
Burla, Sambalpur, Your Lordship.
The Burla is not a corporation.
Sambalpur, Your Lordship.
Sambalpur within the area of Sambalpur Municipal Corporation. It is submitted by the Honorable Counsel for the petitioner in support of the petition that the area does not belong to the municipal corporation, it belongs to the irrigation department. Opposite parties. Irrigation department, Government of Odisha County. Referring to the demolition notice, it is submitted that details of the occupation alleged against the petitioner has not been mentioned. जो notice है Annexure 3.
Annexure 4, Your Lordship.
Annexure 4.
Yes, Your Lordship. Your Lordship, in one item.
ଆପଣଙ୍କର 17187 ରେ 3 ସେଟା.
Yes, Your Lordship. Yes, Your Lordship.
4 also something else. Annexure 3. The petitioner, the Honorable Counsel for the petitioner further refers to the continuation of the settlement operation in Burla under the Burla area under Odisha Survey and Settlement Act, for which she refers to the Government of Odisha Revenue and Disaster Management Department, notice dated 03.07.2015 into bracket Annexure 4. The learned AGA, Mr. Jayanta Kumar Bolo and Mr. Saroj Kumar G vehemently opposed prayer for any interim order to be passed by this court. They submitted that the petitioners have encroached government land, they have made constructions over drain, obstructing the free flow of water, which requires to be removed before the ensuing monsoon. It is submitted by Mr. Bodal on a DG that the government is making all-out effort for cleaning of, for removal of encroachment and cleaning of drains. The पूर्व लिखी में जो issue notice टा लिखा है petitioner का submission तापर लिखा तो issue notice along with this order the learned AGA इथरे
it is from 1 to 7.
1 to 7 आपण हमने Mr. 1 to 7 Mr. नहीं Mr. लेग्गा थिले ना
No.
तीन आपण
opposite party number 1 रो
नहीं आपण को आइटम रा अपेयर करछो
मु 5-6 रे
मु 3-4
अच्छा Mr. Jayanta Kumar Bolo AG item 3-4
1 to 7 we are appearing on this
5-6
more
5-6 Mr.
जी
सरोज कुमार जी AG 7-8 नहीं 7 रे क्या अपेयर करछो
Lordship, I am for 7, item 7. Lord,
Sir, kindly tell your name, sir.
M.R. Mohan.
Mr. M.R. Mohanty.
My lord.
Mohanty AG.
My lord, AG.
AG. M.R. Mohanty साथ M.R. Mohanty AG. वो पार्टी इटा appearance अपन लॉयर को ना लिखी दियो तो ओपी हेले 1 2 7 हेले Lorded AG appears and waives notice. तापर लिखो तो notice to OP 8 and 9 by speed post with registration and proof of delivery. Requisites for issuance of notice be filed within 3 working days. ଆପଣ आइए जोटा तापर लिखिबे 10355 of 2026 लिखिबे hard noted counsel for the petitioner. She reiterates her submissions as quoted above. तापर लिखिबे Mr. Bora, Mr. G and Mr. Mohanty. Paymently of जोटा से according to correct. तापर interim order टा लिखिबे in the interim having hard noted counsel for the petitioner and the learned AG appearing for the opposite parties 1 to 7. In the interim, it is directed that status quo as on date regarding the property involved in the notice annexed to the writ application issued by the Sambalpur Municipal Corporation nature, character, ownership, and possession shall be maintained by the parties. Like Mr. Lenka was arguing that you have reconstructed. Ms. Senapati, you must know that you have to leave it.
Indeed, Your Lordship.
You should advise them that this is a time, this is a breathing time.
Indeed, Your Lordship. Indeed, we are completely aware, Your Lordship. We just needed the breathing time.
You need the breathing time like Bhuvaneshwar, then everything will be broken together.
Indeed, Your Lordship.
Shall be maintained till the next date of hearing. The matter shall be returnable date be fixed to 25/6 नहीं 25/6 छुट्टी पड़ेगी तो 2/7 the matter shall be listed for orders in the week commencing 6/7/2026 before the assigned bench. और गोटे कर देला पर बाकी सब गुडा को ताकू yes
Your Lordship, urgent.
अच्छा urgent
Please, Your Lordship.
urgent certified copy से लिखिए urgent certified copy be issued as per rules तापर लिखिए the parties shall have liberty to act upon the copy of this order obtained from the official website of this court.
Much obliged, Your Lordship.
Yes, please.
May I please, Your Lordship? Your Lordship, in this read petition, we have challenged the notice under Annexure 3, Your Lordship, that has been issued by the Tahsildar and additional Tahsildar, Your Lordship, regarding demolition, Your Lordship. But now the matter is that the petitioner is the possessor of the land. He has purchased them from the year of 2022, Your Lordship. Now they have constructed a boundary wall, Your Lordship, but there are some Basti area peoples are there in the side of their land. Now they are trying to encroach the said land by using their inner powers and other persons who were in political. Then they are trying to do this, and on 22nd May, Your Lordship.
Kindly read the
yes,
notice. Kindly read the notice.
Yes, Your Lordship.
You can read only, please read.
Yes, Your Lordship.
Yes,
एतद्वारा सर्वसाधारणଙ୍କର ଅବଗତି ନିମନ୍ତେ ଜଣାଇ ଦିଆଯାଉଛି ଯେ ବିଧିବଦ୍ଧ ଅନୁସନ୍ଧାନ ପରେ ନିମ୍ନ ସ୍ୱାକ୍ଷରକାରୀଙ୍କର ଏହା ପ୍ରତୀତ ହୋଇଅଛି ନିମ୍ନ ତଫସିଲରେ ଉଲ୍ଲେଖ ଥିବା ଶ୍ରୀ ରଘୁନାଥ ଜୀଉ ଜମିକୁ ବିନା ଅନୁମତିରେ ବେଆଇନ
Raghunath Jew is a DT, is a listed entity. You have to make the endowment commissioner and the managing trustee as a party. Without hearing them, this matter cannot be taken up. I hope you understand. You see, the encroachment is removed from the DT's property. You would have marked Mr. Raj Singh was arguing. A writ petition is there. The encroacher is not a party, but the court order passes an order for eviction. Then the encroacher comes and says that another writ petition. So similar problem will be here. Unless you make them a party, they are not heard. This cannot be taken up.
Your Lordship, I will
and most likely this sub-collector is part of this. He is in charge of that endowment. Could be.
Your Lordship.
So you make them party, then you come.
Your Lordship, I will do that. But meanwhile, IFA status quo is there, Your Lordship, and already demarcation has been demolition is on, Your Lordship.
Whose property you are encroaching? He is not there. In their absence, I cannot pass the status quo order. The same problem will be there. The property you are encroaching of, you should say that how. I mean, they must be noticed.
Your Lordship. But Your Lordship, meanwhile, they will proceed with the demolition without hearing and giving us opportunity to hear, Your Lordship. That is the reason why we have approached.
You please appreciate. They have heard. There must be some order, some direction of the removal of encroachment of endowment property. These proceedings cannot be taken up parallelly.
Your Lordship, I understand, but Your Lordship may come to annexure number 2, Your Lordship, in the ROR, Your Lordship.
Correct. What is the date of publication?
22nd May, Your Lordship. Within 7 days, they have told us that they will proceed with demolition.
ROR date, ROR publication date.
ROR publication date. 25/5/2026, Your Lordship.
No, which page you are reading?
34 page.
34 ରେ କଣ ଲେଖା ହେଇଛି କଣ ତ ପଢୁଛନ୍ତି ସେଟା ଲେଖା ହେଇଛି ରାଷ୍ଟ୍ରୀୟ ସୂଚନା ବିଜ୍ଞାନ କେନ୍ଦ୍ର.
Oh, Your
so
Lordship.
that is the date of downloading the ROR.
Your Lordship, Your Lordship.
So read column 6 of ROR.
Yes, Your Lord. दाखल खारिज केस नंबर 4288/2022 हुकुम मुताबिक प्लॉट नंबर 106.
So how is it that in 2022 suddenly Raghunath Jew's property has become your property?
No, it has been Your Lordship private. The same has been sent it there, Your Lordship, in annexure 1, Your Lordship.
You have stepped into the shoes of your vendor. You cannot have a better right than your vendor. The vendor has sold you Raghunath Jew's property. Even those properties in Sabak Khata will be referred as Raghunath Jew's property.
Your Lordship, it was previously possessed by one K. Manoranjan Patra, Your Lordship.
Even if you look at the sale deed, there is a clause always, default clause in the sale deed, that if it is endowment property, it shall not abide by this sale deed will not abide by that. These things, this kind of litigation has to fail.
Your Lordship may give us
compensation from your vendor at best. Or anyway, you have to make the party. At least you have to make the proper and necessary party.
I will do that.
Nothing can be done. You have to make your vendor a party.
Lordship, no
now you have to make your vendor a party. The whose property you have occupied, he has to be noticed.
Your Lordship.
So if you can modify, you can if you can make those amendments, you can take a chance again. Simply adjourn for that.
My Lord, item 10 probably the same, Raghunath Jew.
10, 14 and 22, Your Lordship.
I'm for 10.
Raghunath Jew property किए बिक्री कले, Mr. Tripathi? आपण थाउ तो property बिक्री
he has not been made a party, neither the endowment. department, endowment commission of Bhubaneswar has not been
Cell deed, my lord. They
The
have
endowment
annexed the cell
authority.
deed.
Sorry, Mr. Mahathi?
My lord,
Next in this-
they have annexed that annexure, that is annexure 1. That is
Oh.
cell deed.
Yes.
That which reflects, my lord, there is no reflection of any endowment property. It is the private property and private, my lord, vendor has given some individual has given that.
Yes,
No,
Your
I-
Lordship,
but-
that is.
Sold
But
that
in item
property.
10, no cell deed has been annexed.
No, item
In
10, Your
item
Lordship, in item 10, there is only ROR is there, Your Lordship. And the notice is
cell deed has
as
been
annexure
annexed.
2, Your Lordship.
Arora
We have
ଆପଣଙ୍କ
been-
quotation ଟା 22 ରେ allow ହେଇଛି Ms. Patihari, fine,
Okay.
you have made your efforts, fine.
Only the ROR has been annexed and the notice, common notice of 22nd 5/26. That has been annexed. But in the notice, it has
Mr.
been
Mahathi.
clearly stated that the
Mr. Mahathi.
Raghunathji's property has
Please
been
page
annexed.
24 ଦେଖନ୍ତୁ. These things you should read. Page 24 ପାଇଲେ?
Yes, yes.
1732. ପଢନ୍ତୁ. Internal page 12.
Yes, my lord.
ପଢନ୍ତୁ. ଆରେ ଆପଣ ବଡ ପାଟିରେ ପଢିବେ ନା ମୁଁ
Yes, yes, my lord. But the property hereby sold is not under the management of endowment commissioner or is not acquired by Bhudan and
Act 1970 under WACF Act. Vendor sellers has not acquired ceiling surplus land. So these are the default clauses. That I wanted to tell Ms. Pratihari.
Yes,
she is arguing well. So when she is arguing, perhaps she might not have marked those things. So there is a default declaration that endowment property nobody can sell. But the notice itself says that it is Raghunathji.
Yes.
Yes, ma'am.
And in fact, just above that, Mr. Mahanti, if you kindly just take that. The property is free from all disputes and encumbrances. If so proved, the vendor seller shall be liable as per law as sets and shall be liable for damages. That I was trying to tell Ms. Pratihari. Because these even this sale deed will not confer any right because sale deed excludes Bhudan, ceiling surplus and endowment property. Because I mean, anyway, she has made an effort. Simply adjourn now. Apanakara likhibe eta kete item. Item 8 re Ms. S.S. Pratihari, Mr. M.R. Mahanti, AC for the project party. Mr. Mahanti or AG?
AG.
Mr. AG. Mr. 10 re Ms. S.S. Pratihari, Mr. Gautam Tripathi AG. After arguing for some time, the Lord Counsel for the petitioner seeks adjournment. Accordingly, the matter is adjourned. Liberty to mention.
Your Lordship, another two matters are there.
Unless
on item
the
14
court, suppose I would have missed those aspects. Otherwise, I cannot justify my order. In fact, there is no point.
Your Lordship.
You have heard Mark, Mr. Bola and Mr. How they are fighting it out. Now, Mr. Tripathi and Mr. Mahanti, they will also shout at me. The endowment property.
No.
Yes. देखो तो जा करियो.
Your Lordship, another item 14 and 22 are same also. Same notice, same problems, Your Lordship.
14 की
I am appearing, my lords. My lords, I am appearing.
अच्छा 14 मिस्टर यूसी बेव सेम 14 लिखिबे मिस एसएस प्रतिहारी एंड मिस्टर यूसी बेवरा एजी 20 रे की अछंती 20 नो 23
22
By
Mr.
your
Professor.
lordship.
सॉरी आई एम सॉरी 18
It has simply been adjourned without date, my lord.
यस यस 18 रे की अछंती गवर्नमेंट काउंसिल की 18 रे मिस्टर त्रिपाठी कैन यू टेल
May I please lordship? My lord, item number 18. I am not a government counsel in this regard.
आपन का नाम है मोहम्मद
Muhammad Shaikh Ali. It's item number 18. It's different matter, my lord.
पिटिशनर कहउछंती सेम बने आपन कहउछंती डिफरेंट
नहीं this is a 22 14 and 22 she is telling.
आपन मैडम प्रतिहारी आपन कोटा कहउछंती
8, 10, 14 and 22, your lordship.
10 14 and 22 22 रे की गवर्नमेंट
Yes, your
काउंसिल
lordship.
22 मिला पीके
22 रे गवर्नमेंट काउंसिल के
पीके पंडा मिला पीके पंडा my lord.
पीके पंडा.
तो पीके पंडा एजी
My lord. Yes.
22 रे पीके पंडा एजी तो छोड़ा को गोटे ऑर्डर करिवे आइटम 8 then 10 then 14 and 20 simply enter. Yes, next call the next matter.
Item 9.
9, may I please, my lord?
Yes.
May I please, my lord? My lord, opposite party number 3, Bhubaneswar Municipality Corporation, without any notice, my lord, evict the shop room, my lord. The land is situated in the private land, my lord. Page 19, my lord. Page 19, annexure 4 is the ROR, my lord.
Eviction तो है status was on date.
My lord.
You are Mr. अपन तो लिंगराज मानती नहोंती अपन
Tathagat Sahu.
हाँ
Tathagat Sahu.
Sahoo for the petitioner.
My lord.
I am for 1 and 2, my lord. 3 and 4.
Gautam Tripathi for 1 and 2. One, 2 and 3. 1 and 2. 3 लिखिबे notice to जो ठीक अछि. The hard nodded counsel for the petitioner. The petitioner is before this court challenging the notice for eviction and demolition.
Yeah, eviction, my lord. No notice, my lord.
No notice has been given.
No notice, my lord. The land is situated private land, my lord.
He has only taken the averment paragraph 12
My lord,
that the opposite parties are going to start eviction.
My lord, annexure 4, my lord. Page 19, this is the ROR, my lord. ROR and my lord, rent, my lord. Page 21, my lord.
The petitioner is apprehending eviction. And तो ये तो आपनकर ये तो आ बैल मुझे मार अपन जो नोटिस नहीं अपन फटाफट उठे
What happened, my lord? There is some portion of government land without demarcation. They evict the showroom, my lord. The showroom is situated by property, my lord.
बड़ा शोरूम काहे कले
My lord.
अपन इतने बड़ा होंडार जेन्युइन पार्ट शोरूम काहे की कले
My lord, this is private land, my lord. Private land, my lord.
धीरे जाकर
garage time, my lord, garage time.
तो गाड़ी पसी परनु गाड़ी पाछे रुकिबो
My lord.
आपण फोटो देखि नांदी मते पेज 23 रे देखंतु आपण दुकान रे
my this is the garage, my lord. Page 23, my lord. लिखि देछि ऑटोमोबाइल parts garage कम parts, my lord.
ओगरे पार्ट्स आइगा सामना रे कांथ अछि गछ फूलो गुंड थुआइ छि जेमति आपण हाई कोर्ट बाउंड्री थुआइ छि.
This is the private land, my lord. The private annexure 4, my lord. Page 19, my lord.
If it is a private land, how can you say that, or how can you on oath say that this is a non-government land?
No. Some portion is the government land, my lord. Not my shop room, my lord. Without, my lord, BMC without demarcation, they have evict the shop room, my lord.
Upon notice niyantu dekhantu. The petitioner is a shop owner in the name of Ramesh Auto Workshop.
My lord.
Selling Hero Honda, Hero Motor Corporation and Honda Motor spare parts also having a name as Komol Auto Parts within the area of Bhubaneswar Municipal Corporation.
My
It is submitted by the Lorded Counsel for the petitioner that though the petitioner has constructed his shop room, Komal Auto Parts and Ramesh Auto Workshop in private land, still he apprehends eviction by the BMC authority.
BMC authority, my lord. Open number 3, my lord.
By the Bhubaneswar Municipal Corporation authorities. Prima facie, this court is of the view that no public authority shall remove any person from his private land unless the said land is encroached upon and is public land. The reason of such apprehension of the petitioner is not disclosed in the writ application. Nor the petitioner has enclosed any notice to the writ application to substantiate his claim. Issue notice to the opposite parties along with this order. The learned AG appearance like Rakichi, Gautam Tripathi. Learned AG appears and waives notice on behalf of upon learned AG upon advance copy served appears and waives notice on behalf of opposite parties 1, 2, and 3.
No, 1, 2, 1, 2, 1. 3 and
Sorry,
4.
1 and 2. Notice to OP 3 and 4 by speed post with registration and proof of delivery. Requisites for issuance of notice to OP number 3 and 4 by speed post and registration and proof of delivery we filed within 3 working days.
My lord.
Clear. IA 10419 of 2026. Hard learned counsel for the petitioner. He reiterates his submissions as above. Issue notice as above. In the interim, it is observed that the authorities shall do well to follow due process of law before any eviction is carried out from any encroachment from government land, public municipal land, public premises. Yes. Matter the returnable date be fixed to 3/7/2024. The matter shall be listed for orders in the week commencing 13/7/2024. Yes.
No courtship action till date.
No courtship action कहाँ direction देवी?
OP number 3, my lord.
तो किसी नहीं आगे सेंती तो GNI से भी भागी पड़े आपण घरକୁ.
Till date no courtship action. सही पर्यंत.
Without demarcation.
General petition रे general order. ମୁଁ କେମିତି କହିବି ଯେ ଆଜ୍ଞା ସେ municipality ଭାଙ୍ଗି ଦେବେ ବୋଲି କିଛି ନାହିଁ ଆପଣଙ୍କର ଆପଣ ଘରେ municipality ଭାଙ୍ଗିବେ
without demarcation, my lord. No courtship action without demarcation, my lord.
no courtship action କଣ ହେଇ ପାରିବ କିଛି ହେଇ ପାରିବନି का against
without demarcation not to evict, my lord. Without demarcation not to.
ଆପଣଙ୍କର କୋମଲ ଅଟୋମୋବାଇଲ ସେ କି ବସି ଭାଙ୍ଗି ଦେବ ବୋଲି how can you will mark that actually no one has a right actually.
Man, yes.
ये भाଙ୍ଗିବ ସେଟା କଣ offense ହେବ ସେଟା ଅଲଗା କଥା. Yes, next.
Man, till date, my lord. Till date.
No courtship action ସେମିତି blank କରି ହବନି.
ମାନେ without demarcation ଆମେ ଖାଲି କହୁଛୁ without demarcation evict ନ କରୁ.
ସେଟା ଆପଣ ବୋଧେ ଶୁଣିଥିବେ due process of law ମୁଁ ଲେଖିଛି.
Urgent copy, my lord.
Yes, urgent certified copy as per rules. The parties shall have liberty to act upon the copy of this order obtained from the official website of this court.
Published.
Item 11. Mr. Abhijit Kal for the petitioner. Mr. Gautam Tripathi.
My lord, I am a picker.
No.
Mr. Prabir Kumar Ray.
I'm not there.
AGA for the opposite party. Yes.
Is agreed by the notice under section Kha, the form Kha of the OPLE Act.
Yes.
the notice, your lordship will see that the area of the land is only 9 decimals. Will kindly come to page annexure 3, page 15.
Yes.
9 decimals.
Yes.
Second page, page 16, annexure 4. The COR notice is also 9 decimals.
Yes.
Now, I am in possession of the property and I have given as page 20, annexure 7.
Yes.
It's only 9 decimals. Now, my lords, the question here is that if a action under section 7(1) of the OPL is to be construed to or is to be initiated, whether 7(2), which has a non-abstante clause, has to be considered first. Because 7(2)(b) says about settlement if it is 1/10, less than 1/10 of an acre. This question needs to be answered because it's no.
And you are saying that you are eligible.
I'm eligible because it is a government land. Admittedly, I'm a landless person. Third is that I'm in possession, which is admitted by them because another case was also initiated in 2019, where assessment was made. Kindly see, that is at page 13, annexure 1, same land. And annexure 2, page 14, the initiated and levied penalty did not issue 7(1).
The petitioner before this court.
My lord.
Yes.
7(2), my lord, it will be applicable for if it is used for homestead land, my lord. Whereas 20, my lord, it's used for commercial purpose, my lord, Sahoo communication Xerox. My lord.
But ସେଇଟା ବି ଆପଣଙ୍କର ଗୋଟେ double edged sword. It appears to be partly homestead and partly he is operating his Xerox. ସେ Xerox machine ବାହାରକୁ କରିଦେବେ. ଆପଣ ଯଦି Xerox machine କହିବେ ଯେ Xerox machine shows it to not to be homestead, ସେ Xerox machine କାଢିଦେବେ. So that will cut both the ways. But obviously OGLS, Mr. Bray, OGLS grants a right to encroacher for a settlement if he's a beneficiary. I mean, he's entitled.
I have also applied under OGLS.
That is something like it is something like Mr. Ray. This Podiyanathil is in Bhubaneswar. All landless, homesteadless persons have been allotted hundreds of acres of land. OGLS is a small.
But this is a notice under OPL Act.
Correct.
So appeal lies, my lord, division then.
I am questioning the jurisdiction under 7(1) jurisdiction. Alienation case ହେଇପାରିବ.
ଆପଣ ମାନେ ଆଜି ଯୋଉଡାକ orally କହୁଛନ୍ତି ସେଟା ଲିଖିତ ଆକାରରେ ଦିଅନ୍ତୁ. What material I will have unless they saying that since Mr. Ray is saying this has to be true. That I cannot record. It has to be on record. OPL ରେ ବି provision ଅଛି ଆପଣଙ୍କର.
Yes, yes, sir. 7(2)(b).
7(2)(b), my
both
lord.
OGLS, OPL, actually the settlement can be made. OPL ରେ settlement हवनी, OPL रे provision ଅଛି settlement ପାଇଁ, but the settlement in terms of OGLS.
Yes, alienation case of.
So whatever that method has to be followed.
And from that khata also same plot, one person has been settled. That also I've given.
No, Mr. Pal, actually these these provisions have been benefiting people.
My lords.
If you see in villages,
that is what I'm saying. He has to examine it first whether I'm eligible. Then proceed under
several places in villages, people are benefiting.
My lords.
ଆପଣ ସେ ये Xerox machine उठेଇ दियନ୍ତୁ. Mr. Ray doesn't like those Xerox machines.
No, my lord, that is document relied upon by
No, that's a photograph, not a document.
Their application that has been filed, it's claimed that they need it for the homestead purpose.
Of course. The petitioner before this court challenges the eviction notice dated
28/4/2026.
sorry.
28/4/26
was
Annexure
issued by the
4.
additional Tahsildar Chhatrapur, OP numbers dash.
OP2.
OP number 2 in OPL case number 404-223 of 2019. সেটা আগুতে বলতে
না না সেটা আগুতে এটা হচ্ছে 191 of 2026 191 of 2026
the notice under form KHA KHA in OPL case number 191 of 2026 dated 28/4/2026 pertaining to खाता नंबर 1800 प्लॉट नंबर 635 the total area 0.952 decimals, enclosed area 0.009. It is submitted that earlier there were encroachment cases initiated against the present petitioner, who is entitled for settlement of land as per the provisions of 72B of the 1972.
7 bracketed 2B.
7 bracketed 2, then capital B.
Small b.
Small b. It is submitted that 2 dash small b. 7 to small b. It is submitted that prior to for the eviction of the petitioner, his entitlement for settlement under 72B should be considered by the authority. Otherwise, the said provision would become odious. The Learned Council refers to the earlier orders passed in passed by the additional passed by the additional Tahsildar dated 18/3/2019 in encroachment case number 4-191
223/19
223 of 2019, and the receipts issued in favor of the petitioner collecting encroachment penalty dated 12/3/2019 into bracket annexure 2. It is submitted that the documents taken together would show that the petitioner is in possession less than 1/10 of an acre, that is 0.009 decimals, and he is entitled for settlement of the land. The additional government advocate upon advance copy served appears and waives notice on behalf of opposite parties. He vehemently opposes the prayer of the petitioner, who submits that the petitioner has constructed a soft roof and he is not entitled for settlement. It is further submitted that yes, Mr. I would have gone to
7(2)B is will be come into effect, my lord, only if it is used for homestead land. It's not.
So 7(2)B will come into play if only the enclosed area is used for homestead purpose.
And besides, appeal provision is also there. He can
submitted that the appeal provision is there. कौन तो शेड
20
on the section 12 of this OPL Act, and stop. Perusal of the provision of appeal indicates that 12(1) provides for appeal from any decision or order is made by the Tahsildar shall lie to the subdivisional officer In the present case, the petitioner challenges the initiation of the proceeding, and apparently there is no order passed by the Tahsildar. Evicting the petitioner has approached the court at the stage of issuance of notice, claiming a right under 7(2)(b). Furthermore, it has to be observed that for adjudication of the rival contentions as raised at the bar by the AG, the pleadings are necessary to be completed by the opposite parties. Issue notice along with this order. The Lord AG shall file counter by Quebec, Mr. A.
My lord.
Quebec counter file kari paribe.
Reopening.
So file counter by 29/6/2026 on serving copy thereof on the Lord Counsel for the petitioner. The petitioner shall have the liberty to file rejoinder in response to the counter if so advised. The matter shall be listed for admission in the week commencing 6/7/2026 before the assigned bench. आइए. Had learned counsel for the petitioner, he reiterates his submissions as above, as noted. The learned AG vehemently opposes the prayer for interim order. Having had the learned counsel for the petitioner and the learned AG, it is in the interim, it is directed that status quo as on date regarding the nature, character, ownership, possession of the land in question as referred to in the notice dated 28/4/2026, Annexure 4 shall be maintained by the parties in the next date of hearing. Yes.
Urgent copy.
Urgent certified copy as per rules. Parties shall have liberty to act upon the copy of this order obtained from the official website of this court.
Grateful, my lord.
Madam to Mr. Parthasarathi Das for the petitioner.
I'm
Mr. Das, just kindly shift to your left or right, so that
yes.
because instead of you, your pillar is appearing. So I can't dictate Mr. Pillar for the petitioner. So Parthasarathi Das for the petitioner, Mr. State.
I am appearing.
So Prabir Kumar Ray, on behalf of the opposite parties, 1 and 2.
Yeah.
Mr. Lalit Maharana, on behalf of OP number 3 and 4. You have not been served with copy, Mr. Maharana.
No, my lord.
Yes, Mr. Das.
The annexure 4.
They got disconnection.
Yes, my lord. No, last date is the third is the last date, my lord. Tomorrow.
Tomorrow,
annexure 3, my lord, that is a letter of mining officer, my lord, to disconnect regarding stopping of crusher operation. As per letter annexure 3, I have already stopped my crusher, my lord. Though annexure 1 is the consent letter is still, my lord, 31st March 2031, my lord. Therefore, annexure 4 was issued for disconnection.
So if you have stopped your crossing, then why should you have electricity connection?
Because their person are for looking after the unit, my lord. The machinery is there.
For that, you need to have a domestic connection.
No, only for my lord. Because
এটা ডাইজেস্টেবল ফর্মରେ ଆଣନ୍ତୁ এটা ডাইজେସନ কোন হবো কি ଆପଣ ଗୋଟେ ଇଣ୍ଡଷ୍ଟ୍ରିଆଲ କ୍ରସର ପାଇଁ କନେକ୍ସନ ରେ ଡୋମେଷ୍ଟିକ କନେକ୍ସନ ଲଗେଇବେ
my prayer is, my lord, there is
even if you have not prayed, I will direct that if any domestic connection is required, they will be giving.
No, because I am already, my lord, because I have there is consent is there, my lord. Only pray without any opportunity they have issue notice for disconnection.
Kindly read that order, then you will get the point.
Yes.
Photo 16 ta पढ़ो page 60.
Direction for stoppage of crossing operation. It has been
observed
that your crosser unit is operating without valid compliance of mandatory statutory requirement as the expiry of consent to operate, my lord. But here I am stop, my lord. Annexure 1 is my consent.
Who is asking you, sir? I will anyhow. I am not granting you.
I'm
not granting you. Please complete reading so that you make a sense out of it.
Non-registration of in the I4MS portal, my lord. In view of the above non-compliance, you are hereby directed to stop all operation of the crosser unit with immediate effect and remain closed until further orders for the competent authority, my lord. You are the
so this order is not banning you. This order is that you comply and operate.
Yes, my lord.
So then kindly read further.
That you are further instructed to obtain, renew the valid CTO and complete registration in the I4MS portal at the earliest for consideration of permission of resumption of the operation.
So you must have annexed your valid CTO and I4MS to the writ application. Have you annexed that?
My lord, annexure 1 is the consent order that is valid up to 31st/3/2031, my lord.
So you saw so where you have written to the authority? Enclosing this, show your representation or compliance of the you have to comply before the authority, not before High Court.
No, that is there, my lord.
So how you have approached the authority?
But annexure 4 thereafter they issued annexure 4, that is for disconnection. That is the
Mr. Das, the annexure 4 is disconnection to the electricity company.
Yes, madam.
Annexure 3 is to you to comply. If you have complied, then show before this court that you have shown to the authority that you have complied.
Then I have approached the authority within a week. Till then may not be disconnected.
So how can it be, sir? You must understand. Connection is to be disconnected at the instance of the authority between the authority and the power company.
Yes.
You are supposed to comply. You give CTO and I4MS.
Yes.
So if you have approached the authority, show that before this court.
Consent is there by annexure 1, my lord.
Sir, consent High Court दबा पे कुआ जाएनी. आपण authority को consent letter आउ जो आपण compliance सा कोटी देचन. सेठी देखंतु.
I will approach the authority, my lord.
आपण अर्जन कर दियो. आपण अर्जन कर दियो.
I will approach the
authority. एंट्री मर्डर किछि एंट्री मर्डर हवार नै. आपणकर जदि डिस्कनेक्शन होउचंती ताकर पावर सप्लाई दरकार जो लोककर रहिबे सेठी. से लोगों को कनेक्शन देबे कि नहीं, another issue again.
That person is there, my lord. They only
so whoever the person staying there cannot take a connection for running a crosser unit. He will have a connection for has his domestic purpose.
Only for a period that with for compliance. Other than, my lord, there is no.
If you have complied and informed the authority by properly intimating, so that which you do not have right now, you are not having in your writ application. For that you want adjournment, and beyond that nothing can be done. And suppose, let us assume that you have complied. Unless you ask the court that yes, I have complied and so to the authority, then how the authority will be asked to consider that also. That is another problem.
I'll approach the authority.
So you approach the authority. For that you do not require any interim order. Appearance like children. After arguing for some time, the petitioner, the learned counsel for the petitioner seeks adjournment to obtain further instruction. Accordingly, the matter is adjourned. After vacation.
During vacation.
Liberty to mention. Date correct. Simple adjournment, liberty to mention. Yes.
May I please your lordship?
आपण कॉपी दे दियो. कॉपी देचंती.
आगे कॉपी दिए.
Copy of the petition shall be served on Mr. L.K. Marana, who has instructions to appear on behalf of OP number इत्ते. Within how much time?
Within
3 working days.
2 working days.
2 working days. ठीक.
Obliged.
Mr. Prasanto Kumar Nanda for the petitioner. Yes.
Yes, this is against STM law that petitioner has availed the tourist permit, which is valid till Milord 28 March 2027. Annexure 2 at page 13, Milord.
Similar orders have been passed, Mr. Nanda. You are relying on any similar order passed by coordinate bench. So,
Milord, in other cases, this Honorable Court direct to deposit the tax for release of vehicle. So here, Milord, Annexure 6.
undertaking, ଆପଣ କୋର୍ଟ ଲେଖିଛନ୍ତି ଦେବେ ବୋଲି tax deposit କରିବେ ବୋଲି? So, Nanda, Mr. Prashant Kumar Nanda.
I have already deposited the Orissa tax, Milord.
Mr. Umesh Chandra Behera, Additional Government Advocate for OP1, Mr. Prabhakar Behera, Standing Counsel, OP 2, 3 and 4.
3 to, Milord,
2 to 4.
2 to 4.
2, 2, 3, 4 ହେଲା କି?
My lord.
ସେ ଦିଥର 2 କହିଲେ ଭୁଲ ହେଇଯାଉଛି ତ ସେଥିପାଇଁ।
ଆଜ୍ଞା
2, 3 and 4. Second ଟା TO2 actually. ଆପଣ ଦେବେ ପଇସା ଦେବେ Mr. Nanda?
No, they have imposed, Milord, 1 lakh rupees, Milord, on 28. But they have charged from the date of registration, Milord. But before that, Milord, I have already deposited the Orissa tax. That is there, Milord, in annexure, Milord, page 18, Milord.
If that is a valid point to be adjudicated, he has to obtain instruction. Say interim order to ହେଇପାରିବନି.
Only limited, Milord, that vehicle may be released, Milord, unless the vehicle is
without deposit of the tax. ଆପଣ ବର୍ତ୍ତମାନ tax amount ଟା dispute କରୁଛନ୍ତି Mr. Nanda. ଆପଣ ଯଦି without prejudice deposit କରିବେ it's a different thing.
Yes, without prejudice, I will deposit, Milord, 20,000. I am undertaking to deposit.
Mr. Prabhakar Behera ରାଜି ହେବା ଦରକାର. Mr. Behera and Behura ରାଜି ହେବା ଦରକାର.
2 ମାସର ଆଜ୍ଞା deposit ହେବା ପାଇଁ ଥିଲା। See, that has been deposited because due to it was not uploaded, for which, Milord, it has been deposited.
The tax needs to be calculated, but for 1 month, Lordship may find at page 18 for 1 month, he has deposited rupees 22,287. So, Milord, entire period of permit, that is from April and May, he is required to pay. So, Lordship may direct.
So, what Mr. Nanda is saying, that he has already paid, but it could not be uploaded. So,
that period he has not paid.
So, that I cannot adjudicate now. Upon instruction nele ja habo na.
Yes, instruction. So, they are saying that, Milord, 2 months, I will deposit without prejudice, Milord, I will deposit for 2 months tax, Milord.
Mr. Behera, 22,000 ଲେଖାଏଁ କେତେ ମାସ ଆପଣ ଦେବା ପାଇଁ କହୁଛନ୍ତି? ମାର୍ଚ୍ଚ ଏପ୍ରିଲ ମେ?
My lord.
ନାଇଁ ଦେଇ ଦେଇଛି ଆଜ୍ଞା।
The tax has been paid for the month of June. That is from Milord 28/5/2026 to 27/6/2026. Current period. Milord, page 18.
Page 18 में जो ब्रैकेट रे अछि 28/5/26
in the bottom.
ଆଜ୍ଞା। ତ Mr. Nanda, he is saying that up to 28/5/26 आप 27/5/26 ଯାଏ ଦିଅନ୍ତୁ।
ଆଜ୍ଞା 2 ମାସ।
ଆଜ୍ଞା ଏପ୍ରିଲ
ମାର୍ଚ୍ଚ ଆଉ ଏପ୍ରିଲ ଆଜ୍ଞା 2 ମାସର ଦେବି।
Let them pay.
ମାର୍ଚ୍ଚ ରୁ ଏପ୍ରିଲ, ଏପ୍ରିଲ ରୁ ମେ ନା ମାର୍ଚ୍ଚ ଏପ୍ରିଲ 2 ମାସ କେମିତି?
ଏପ୍ରିଲ ମେ।
ମାର୍ଚ୍ଚ ରୁ ଏପ୍ରିଲ, ଏପ୍ରିଲ ରୁ ମେ ତାହେଲେ 2 ମାସ ହବ।
ଆଜ୍ଞା 2 ମାସର ପା।
Without prejudice, I will file counter, Milord.
The petitioner is owner of a vehicle, is registered owner of a vehicle, bearing registration number so and so, which has been seized by the motor vehicle inspector in the regional transport office Bhubaneswar for violation of section 192 into bracket capital A of Motor Vehicles Act and non-payment of motor vehicle tax under section 3 of OMVT Act. The petitioner belongs to the petitioner is a permanent resident of district Vijayawada in the state of Andhra Pradesh. However, his vehicle has been seized in Odisha. within the jurisdiction of Regional Transport Officer, Bhubaneswar, dash, English 1. Third Learned Counsel for the petitioner, he challenges the seizure of the vehicle on various grounds. Inter alia stating that the vehicle which has been seized has complied with all the requirements and the seizure and detention is illegal. So issue notice along with this order. The Honorable DG put an advance copy served appears and waives notice on behalf of UP number 1, Sri Prabhakar Behera, Lord Standing Counsel for the Transport Authority. Upon advance copy served appears and waives notice on behalf of opposite parties 2, 3, and 4. The learned standing counsel shall file response of the opposite parties 2, 3, and 4 within a period of 4 weeks. Para. IE 10451 of 453 टा कौन पे?
ଆଜ୍ଞା ସେଟା ଆଉ ଗୋଟେ ଅଛି no coercive action.
तर सेटा छाड़ दियो तू IE 10453 of 2026. The IE has been filed for interim release of the vehicle. Detained by the authority. The learned counsel for the petitioner refers to the receipt dated 27/5/2026 issued by the Government of Odisha Department of Transport. Quote, check post tax small e dash receipt, which indicates that motor vehicle tax of rupees 22,287 22,287 for the period 28/5/2026 up to 27/6/2026, 28/5/2026 up to 27/6/2026 has been paid. Without prejudice to the rights and contentions of the petitioner, if the petitioner pays the amount for the period from March-April and April-May.
नहीं again खाली April में again March से deposit है जाइए
कोड देखे ले
page 14 मिलो road tax paid up to 31/3/2026 मिलो
पेज ले को पेज पढ़ो चलो
page 14 मिलो
14 हो जाएगा
yes last column third column मिलो road tax paid up to 31/3/2026 एबे कल देबी आज्ञा April और May रो
for the period for the period from yes Mr. Behera कौन कहउछन
But that is for in the state of Nagaland, not in Odisha.
हां it was
नागालैंड Mr. नंदो एटा नागालैंड हाई कोर्ट ना ओडिशा हाई कोर्ट का कहले
ना ना एटा ओडिशा हाई कोर्ट आज्ञा जे ओडिशा हाई कोर्ट
सेटा आपण सेठी आपण जो बिसिरा सगळे को नागालैंड आपण पारा 2 रे भी लिखिछन जे मो नागालैंड रजिस्ट्रेशन अछि बोले NL 05B 3535.
So, on the basis of permit, he entered Odisha, and the permit has been issued in the month of March 29th, 2026. So, when the vehicle has been detected, it has been operating as a stage carriage. So, it presumes that the entire period of permit has been used unauthorizedly. That is why tax has been imposed. So, any tax can be imposed for the period of April and May, and for June he has paid.
For April and May, the vehicle shall be released However, the such payment shall be without prejudice to any of the rights and contentions of the petitioner. The payment, the authority shall act upon the payment of such amount and release the vehicle immediately. Yes. Urgent certificate copy as per rules. Urgent certificate copy as per rules. The parties shall have liberty to act upon the copy of this order obtained from the official website of this court.
I would no coercive because by taking advantage of such illegal seizure, my lord, the authority will not issue any public.
Predictive what nahi 39 order 39 rule 1 and 2 ho ki ଆପଣଙ୍କର ଯୋଉ CPC ରେ ନାହିଁ predictive କୋଉଠି କିଛି seizure ହବ ନାହିଁ ସେମିତି कोन ହେଇ परियो
ନା seizure ନାହିଁ ଆଜ୍ଞା by taking advantage of such seizure
action against what ଚାହୁଁଛନ୍ତି ତ କହିବେ ନା
ମାନେ ଭାଇ
ଆପଣ କୋଣ ଖରାପ କାମ କରିବେ ଆପଣ ଲାଗେ ଆପଣ ଖାଲି ଆଉ ଗୋଟେ କୋन କରିବେ ସେଟା କୋन କହିହବ नो कोर्सिव एक्शन ବ୍ଲାଙ୍କେଟ नो कोर्सिव एक्शन କେମିତି ହବ
ନା ସେଟା ଗୋଟେ ଡକ୍ୟୁମେଣ୍ଟ ଅଛି ପା ସିଜର ଟା ଇଲିଗାଲ ଅଛି ସେଟ ପାଇଁ ସେଟା ଆଡଭାন্টেଜ ନେଇ ସେମାନେ
ସେଟା ଡିସାଇଡ ହେଲା ପରେ ସେମିତି ହେଲେ ତ ସେ ଆଟଲିଷ୍ଟ ତ କନସିଡ୍ କଲେଜ ଆପଣ ନେଇକି ଛାଡିବେ ବୋଲି 2 ମାସର
ଆଜ୍ଞା
ଆପଣ actually it is a fact ki Nagaland since it is connecting our national highway, so many of the vehicles are registered in Nagaland for other purpose.
And now it is common phenomenon, Lord. All the tourist vehicle has been entered in Odisha and operating a stage carriage.
Yes. केबे आसियो मिस्टर जेना मिस्टर नंद मिस्टर सॉरी बेहर
Lordship may reopen.
The matter shall be listed for admission before the assigned bench in the week commencing 13/7/2024.
Okay.
Aye.
Item 15.
May I please, Lord?
Yes, please.
This matter is relating eviction, Lordship.
Yes.
We are, I am all the 5 matters, eviction matters, Lordship. These petitioners residing over the land 20 years above, Lordship, and also some of them, Lordship, benefited under PMI scheme, Lordship. Now there are under section 7, a proceeding has to be initiated by the opposite Tahsildar, Lordship, but no notice has been issued. Also, now I today got a notice that I Lordship make I permitted to screen sharing, Lordship, that is issued by Tahsildar. Common notice.
Solve karantu.
That is also file, Lordship. Screen sharing file. I am supplying a copy. I may permit to screen sharing, Lordship.
Application of work order achi au kichi nahi ta je
No, then application for a Lordship representation regarding settlement, Lordship. That work order regarding PMA wise scheme, Lordship. 1,00,000 Lordship sanction, Lordship.
So
the house has been made construction.
ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି eviction apprehension ସେଟା କୋଉଠୁ ଆଣିଲେ
ସେଟା ଆଜ୍ଞା ଆଜି ନୋଟିସ ଟା ପାଇଲେ ସେ ନୋଟିସ କିଛି ଇଣ୍ଡିଭିଜୁଆଲ ଦେଇନାହାନ୍ତି ସର୍ବସାଧାରଣ ନୋଟିସ ଆଜ୍ଞା ଦେଇଛନ୍ତି
ସେଟା ଆପଣ ଫାଇଲ କରନ୍ତୁ
ଆଜ୍ଞା 30 ସ୍ଥାନ ଏଭିକ୍ସନ ପାଇଁ ଦେଇଥିଲା ଆମେ ତାକୁ କୌଣସି ଦ୍ୱାରା ଅଟକାଉଟ କରିଦେଇ ସେ କହିଛି 2 ଦିନ ଭିତରେ ଉଠେଇ ଦେବୁ we may be protected Lordship that file may be permitted screen sharing Lordship on memo I already filed Lordship today I make I am permitted screen sharing Lordship for my Lordship's acknowledgement.
ଆପଣ ମିଷ୍ଟର ମହାନ୍ତି କୁ ଦେଲେ କି ସେଟା
yes I am supplied
just now he has given me Lord
ସେଟା କୋନ ସେଟା ନୋଟିସ ଟା କୋନ ସେଟା
ନୋଟିସ ଟା ଗୋଟେ କୋନ ଦେଇଛି ସବୁ ମ୍ୟାଟର ଟା
ଗୋଟାକେ ସବୁ ସୟା
notice no name has been there Lord.
Yes my lord no name ସେତେଲେ ପଢୁନାହାନ୍ତି ନୋଟିସ ପୁରା
କୋଉଠି ଅଛି କହିଲେ
ନା ନା କିଛି ନାହାନ୍ତି ସର୍ବସାଧାରଣ ନୋଟିସ ଆଜ୍ଞା ଦେଲେ
ସର୍ବସାଧାରଣ
ନୋଟିସ ମୌଜା ମନୁନଗର ମୌଜାରେ ଯୋଉ ମାନେ ସର୍ବସାଧାରଣ ଜାଗାରେ ବାସ
you Lordship see that annexure 1 there is no plot no khata number mentioned Lordship next page my lord page 10 second condition ଆପଣ କାର୍ଯ୍ୟ ଆରମ୍ଭ କରିବା ପୂର୍ବରୁ ଗୃହ ତିଆରି କରୁଥିବା ସ୍ଥାନଟି ଖାତା ନମ୍ବର ପ୍ଲଟ ନମ୍ବର ଦବ there is not mentioned in the not single paper has been annexed that they have constructed house over that plot and khata number.
I admitted here Lordship my depends in there they have
see that Lord see that page 20.
Mr. Jena what has happened most likely actually
Page 11, your lordship, see that.
They are thinking. I don't know what has happened, but there is no correlation.
Yes, my lord.
Yeah, correct, your lordship. In the work order, your lordship, there is no plot number has been mentioned, your lordship. But is a admitted fact. I made a representation on Annex 11, page 2, your lordship, that I am residing over that land, your lordship, by constructing a puka house under the beneficiary PMS scheme. And instead of instituting proceeding under Section 7 of the OPL Act, the threatening for eviction is illegal. Accordingly, I requested that land may kindly settle my family as per Section 7A of the OPL Act, your lordship. That has to be considered, your lordship. Now, your lordship, they have no proceeding, individual proceeding, your lordship. Then, your lordship, recently got a notice of publish friend को supply कली. से लेखिले कहा ना आगे लेखिले नहीं.
Both of you are Odia medium ना आपण भी पढ़ंतु.
मिलर
page 10 रे अछि सेडा अछि. आपण कार्य आरंभ करिबा पूर्वरु गृह तयारी करूथिबा स्थानटीर खाता नंबर प्लॉट नंबर देबे किंबा निज जगह रे गृह तयारी करूछंती बोली एक घोषणानामा दाखल करिवे
सेटा का देइला पर
ओन लैंड मिलर
सेटा काई
सेटा देइ साला पर हमकु वर्कर टंका मिलला तापर हम घर तयारी करलो ना घर तयारी करि परिबे सरकारी सरकार हमर लैंडलेस पर्सन हमर किछि जागा नाही
सेटा both of you are not arguing but Mr. Mohanty your money will be wasted
my lord
the money you have invested
एजेंट ऑडियो लॉर्डशिप मेंशन एजेंट
जेना आपण तो देखंतु खाता प्लॉट जानि ना ठीक है रोहंतु आपण तो निजे भी केस आपणकर किछि जानि ना
वो खाता प्लॉट आगे देइ म रीट पिटिशन लिखि जाय एंटायर रीट खाता प्लॉट मेंशन हे जाय
रीट नो आगे आपण जोटा अथॉरिटी को देले अथॉरिटी जोटा पेज 10 रे कहचंती आपण दाखल करिवे
President this is simple work order, your lordship. That work order is issued for PMI house construction, lordship. But so by regarding myself in the land is concerned, I mentioned the entire petition.
Mr. Jena, मु जोटा पढुदिले आपण पढंतु आपण कार्य आरंभ करिबा पूर्वरु आपण आर्गुमेंट करिया पूर्वरु सेटा पढु नांती
that correct, your lordship. I gone through the details. कार्य आरंभ करिबा पूर्वरु आपण से जागार खाता नंबर प्लॉट नंबर ता सबमिट करिबा आज्ञा आगे सेटा हम सबमिट कला परे घर तयारी की टका नै
Just a moment, Mr. Mohanty, if you have invested this 1,20,000, and you are breaking it, then it will be wasted.
No, that is.
So you have to verify.
Another thing, your lordship, see that Annex 2, in last paragraph, they have said that Monare settle kara jao. It's a status of land is gochar. It cannot be settled under the OPL.
Seita Mr. Mohanty, semane te educated Mohanty. Apon jo kotha kahuchanti, kintu what I have seen, in fact I can tell you from my that people are constructing house and they are staying there. But what you are saying is correct. Se joti karya katha seti न करके आगोटे कोठी करछंती.
निज जागा रे, that is the condition, Millers. निज जागा रे.
निज जागा रे no. निज जागा रे. एटा अछि
टू रे जब पूर्व गृह तयारी करथि स्थिति प्लॉट नक्शा स्केच मैप किंबा निज जागा रे तयारी कर
और किंबा माने आपण निज जागा रे करि परिबे नले कोठी करि परिबे
आया
इट्स a Millers it's a status of land is a gochar Millers it cannot be settled under the OPL
status
it's on the land only provision is that Millers 3 of the ठीक है रुहंतु आपण कहले कोन
ना मो घरटा भांगी जो आगे हम निश्चित कहबी
ठीक अछि
आया
आपण किंतु यू हैव टू गिव योर डिटेल्स आपण वर्तमान जोटी घर करचंदी जदी देबेनी तले हाउ दे विल नो
भाई रे लॉर्डशिप मते रीओपनिंग पर्यंत प्रोटेक्शन होजर दियो तो आई विल फाइल एवरीथिंग इज रिक्वायर्ड लॉर्डशिप रीओपनिंग पर्यंत प्रोटेक्शन होजर घरटा भांगी दे खरा दिने कुआड जी
प्रोटेक्शन दिए जिबो एति पय जे पैसाटा ताकर पैसाटा आपण कर नो किंतु आपण को घर रिटेल दियंतु आपण धरंतु पैसा नेले गोटे घर कले आ गोटे एनक्रोचमेंट कले सेटा केमति हबो
ना ऐसे हेई नेडी मोर मते लैंडलेस पर्सन आगे मा कोडी एनक्रोचमेंट करबी
समस्त तो आगे लैंडलेस कहउचंती समस्त लैंडलेस समस्त एनक्रोचर
दैट टाइम वेरीफाई लॉर्डशिप जदी मोर अछि जागा मो आगे पाइबी
सेटा आगे सेटा रीड फाइल कला पूर्व आपण सेटिंग तो लिखि थानते
मु लेखि जे लैंडलेस
कंडीशन दीटा अछि जे आपण निजे
जागा लेखि अनफॉर्चूनेट आई एम नॉट रिटेन इट्स अनफॉर्चूनेट आई एम नॉट रिटेन
फॉर्चूनेट कोन आपण तो इंस्ट्रक्शन नाही आपण कोन रहले आपण कहि थानते you should have asked these questions at least to tell the court where you have constructed your house. Mr. Prabhas Chandra Jena for the petitioner. सबुडाक से एका नोटिस
सबु जाका गुटिए नोटिस सर्वसाधारण आउ इंडिविजुअल किछ नै बाकी लास्ट ईयर लॉर्डशिप
मुझे नोटिस टा पढी दउछ
हां पढनंत
ଏତେ ଦ୍ୱାରା ଆହୃତ ଏକ ମନୁନଗର ମୌଜାର ସରକାରୀ ସରି ଆରୁଆ ବୃତ୍ତି ଏକ ହଁ ବେଆଇନ ଭାବରେ ଅବରୋଧ କରିଥିବା ଜବରଦଖଲକାରୀମାନଙ୍କୁ ଅବଗତ ନିମନ୍ତେ ଜଣାଇ ଦିଆଯାଉଛି ଆସନ୍ତା 30/5/2026 ଦିନ ଉଚ୍ଛେଦ ନିମନ୍ତେ ଦିନ ଧାର୍ଯ୍ୟ କରାଯାଇଛି। ଏଣୁ ଆପଣଙ୍କୁ ଅନୁରୋଧ ଉକ୍ତ ତାରିଖରେ ପୂର୍ବରୁ ଦଖଲ ମୁକ୍ତ କରିଦିଅନ୍ତୁ ନଚେତ ଆଇନ ଅନୁଯାୟୀ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ଗ୍ରହଣ କରାଯିବ।
କିଏ ଦେଇଛନ୍ତି
ନୋଟିସ ତହସିଲଦାର
କୋଉ ଜାଗା
ଭୋଗରାଇ
ଭୋଗରାଇ
yes
25/5 ଆଜ୍ଞା।
The petitioner in the writ application has prayed for a direction not to evict him from his dwelling house constructed. This is 17272. 17272, Mr. Mahanti and Mr. Jain.
yes
So, not to evict him from his dwelling house constructed as per grant of Pradhan Mantri Awas Yojana by order dated 6170, order number 6170 dated 20/12/2016 in village Aruha Brutti.
Aruha Brutti 1 years.
So village Aruha Brutti 1. Copy of the said sanction of said sanction on the Pradhan Mantri Awas Yojana into bracket PMSY of rupees 1,20,000 has been annexed, marked as Annexure 1 to the writ application issued by Panchayat Samiti Bhogarai in the district of Balasore. In the representation to the Tahsildar Bhogarai, the petitioner has prayed for. In the representation to Tahsildar Bhogarai, marked as Annexure 2 to the writ application, the petitioner has prayed for settlement of Khata number 888, plot number 2043, area A0.03 decimal. Stating that in 2016 he has constructed Pradhan Mantri Awas Yojana house and staying there. The representation is dated 20/5/2026. Today, during course of hearing of the matter, the Learned Counsel for the petitioner files copy of the general declaration made by the Tahsildar on 25/5/2026 for directing removal of encroachment by 30/5/2026. So, copy of the said memo is served on the United AGA. The petitioner undertakes to file the details of the house constructed under PMSY, such as Khata number, plot number, as per the work order dated 20/12/2016. Stop. So notice along with this order, the Learned AG upon advance copy served appears and waives notice on behalf of opposite parties 1 to 4. The Learned AG shall obtain instruction and file counter, particularly indicating whether the house constructed by the petitioner is under the PMSY grant. Stop. Para IA 10408 of 2026. In the issue notice as above, the Learned AGA shall obtain instruction. In the interim, it is directed that status quo as on date regarding nature, character, ownership, and possession of the house, Pakka house constructed by the petitioner under PMSY Yojana as per work order dated 20/12/2016 in village Aruha Bhutti, Tahsil Bhugurai, Thana Kamarda, District Baleshwar, shall be maintained by the parties till the next date of hearing. Counter affidavit be filed by 3/7/2026. The matter shall be listed for admission in the week commencing 13/7/2026 before the assigned bench, liberty to mention. Yes.
Different matter, there is no sanction.
Same notice, your lordship, same notice for all, your lordship,
But there
regarding
is no sanction of the PMI.
17. No, there is no house, your lordship. So far the
House
other
nahi.
matter, there is
Total
no
court case.
Milord,
ତାହେଲେ ସେକେଣ୍ଡରେ ଇଣ୍ଟରିମ୍ ଅର୍ଡର କିଛି ହବନି।
ନାଇଁ ଭାଙ୍ଗି ଦେଇ ପରା ସେଇ ସେମ୍ ନୋଟିସ୍ ହଜୁର ମୁଁ ଲ୍ୟାଣ୍ଡଲେସ୍ ପର୍ସନ ଘର କରୁଛି ସେମ୍ ନୋଟିସ୍ ଗୋଟେ କମନ
ସେକେଣ୍ଡ ମ୍ୟାଟରରେ ଯଦି ଘର ନାହିଁ କେମିତି ଆପଣ ପ୍ରୋଟେକ୍ସନ ନେବେ?
ନା ନା ମୁଁ ସେଥିରେ ପିଏମଆଇ ର ଘର ପାଇଁ ନାହିଁ କିନ୍ତୁ ନିଜେ ଘର ତିଆରି କରି ରହୁଛି
ସେଇଟା କିଛି
ରିଟ୍ରେ ନିଜେ ଲେଖି ସେଥିରେ ସରକାର ଜାଗାରେ ମୁଁ 20 ବର୍ଷ ହେଲା ଘର ତିଆରି କରି ରହୁଛି ମୁଁ ଲ୍ୟାଣ୍ଡଲେସ୍ ପର୍ସନ ବୋଲି ଲେଖିଛି ରିଟ୍ରେ ସବୁ ଇଭିକ୍ସନ ନୋଟିସ୍ ସବୁ ଗୁଡା
ଗୋଟେରେ ଅଛି
ଆଉ ଲାଷ୍ଟ ୱାନ୍ ହଜୁର ଏଇଥିରେ ଅଛି ଏଲିଗେସନ ଅଛି ଗୋଟାକରେ କରିଛନ୍ତି ସେ ଯେଟା 17287 ରେ ଏଲିଗେସ କରିଛନ୍ତି
କିଛି ସାଂସନ ଅର୍ଡର ନାହିଁ।
ମିଷ୍ଟର ମହାନ୍ତି ପିଏମଏସୱାଇ ଘର କୋଉଥିରେ ଅଛି?
ପିଏମଆଇ ହାଉସ 17287 ର ଅଛି ଆଜ୍ଞା 17287 ର ଅଛି ଆଜ୍ଞା ପିଏମଆଇ ହାଉସ
ଦେଖି ଦଉଛି 172 ବିଜୁ ପକ୍କା ଘର
ସେଇଥିରେ ହଜୁର ଏଲିଗେସ କରିଛନ୍ତି
ଓ ବାକି ଚାରିଟାରେ କଣ ଅଛି?
ବାକି ଚାରିଟାରେ କିଛି ଆଜ୍ଞା ସେଇ ସର୍ବସାଧାରଣ ନୋଟିସ୍ ଗୋଟେ ଦେଇଛନ୍ତି ଜେନେରାଲ ନୋଟିସ୍ ରେ ଘର କରିକି ରହୁଛୁ ହଜୁର ଆମର ଆଉ ଜମିବାଡି କିଛି ନାହିଁ ସେଇଥିରେ ଘର ରହୁଛି ସେଥିରେ ଆମକୁ କିଛି ଅପିଲେସନ ନ ନୋଟିସ୍ ଏଟ ଅଲ୍ ଡାଇରେକ୍ଟଲି
17277 ରେ the petitioner alleges the 17277 17280 17285 ये जो तीनटा अछि लिखिबो appearance समान रहला the petitioner in the writ application submits that he has constructed a Pakka house in khata number 891 plot number 2044 over an area occur 0.04 decimals.
Let's only mention the status of land.
He is a landless person. He is entitled for settlement of government land, and by and the authorities are threatening demolition of his dwelling house. Alright. So ସବୁଥିରେ ଲେଖି ଦେଇଥିବେ that AG's submission is submitted by the learned AG that the land is of the Kishore Gochar and objectionable in nature for settlement. So the same sentence is ସବୁଥିରେ repeat again. The learned AG accepts notice, shall file counter by same date रखते same date counter by लिखते the matter shall be listed on लिखते आइए the status quo as on date regarding nature, character, ownership and possession of land on which the house of the petitioner
so far as the house is concerned
the house of the petitioner is concerned shall be maintained by the parties till the next date of hearing. Same order what say
then 17287 years
17287 is a Minoti Behra
obligers
so ତାଙ୍କର ଲସ୍ ହେଇଯିବ ସେ ତାଙ୍କ ଘର ଭାଙ୍ଗି ଦେବେ ନିଜ ଘର ନିଜେ ଭାଙ୍ଗି ଦେବେ
urgent
keeping to 73 Sorry, 3rd of July.
Counter by 3rd of July. तेरी डेटा कहले आते counter by 3/7 अपन serving copy there upon the learned counsel for the petitioner. It will come listed in the week commencing 13/7.
Lordship, urgent certified copy.
Urgent certified copy as per rules. देखो तो issue केमती होगा तो 5:15 हैला office 3टा वाले बंद हैला. Urgent certified copy as per rules. The parties shall have liberty to act upon the copy of the order obtained from the official website of this court.
Oblige.
Yes. 16.
May I please, Your Lordship?
Yes, please.
My lord, the petitioner has filed a CS number 630 of 2026, my lord.
Muhammad S. Ali for the petitioner?
My lord.
Yes.
My lord, the petitioner has filed a CS before Civil Judge Senior Division by CS number 630 of 2026, my lord. But
Yes.
soon after the filing, my lord, the summer vacation commenced. So we were not able to move an IA with regard to the said matter, my lord. My lord,
Code district rate.
My lord, it's Cuttack, my lord.
Cuttack we have made arrangements. The problem is that we are only for urgent matters we are having courts. Like vacation court they are having.
My lord, annexure 4, my lord.
See, because unless I observe that in the civil suit, so order 39 rule 1 and 2 is not taken up, or interim application is not taken up, then I have jurisdiction. I do not have jurisdiction.
My lord, it is not taken up due to the matter, my lord. It's page number 36, my lord.
You show your application. You show your application before the trial court.
My lord, I have filed an application 630, my lord.
No. You have to show that you have filed and moved, and state that you have moved the petition.
My lord, I filed it on 18th only, my lord.
Sir, it cannot be a matter of speech. It has to be a matter of document. Because you must understand, I lack jurisdiction in a CS. I am not the. I do not have original jurisdiction to entertain any suit.
My lord, I can.
And for vacation, we have verified that urgent matters are being moved.
My lord, the need.
Just like you are able to move urgent matters in High Court, though there is no urgency in many of the matters, but still you are able to move it. So why not in district court and that too in Cuttack?
My lord, the matter is actually the matter of construction is nearly of roof level, my lord. It has nearly
roof level or plinth level or lintel level. That's not the question we are discussing. The question is that when a civil suit is pending and whether you have moved the application for any interim order, that is important.
My lord, I have filed it and
the civil have a read court will pass order.
My lord, the matter is actually I'm having complete possession over the scheduled land nearly 30 to 40 years. I have attached the electric.
Whatever suit you have filed, whatever order 39 rule 1 and 2 you have filed, that you move, but not the High Court. And if you are saying that court is not available, you have to show the petition you have filed and how you have moved the court. What is the order?
Division bench
Yes, urgent.
Another thing, Millers, any petition arising out of suit is CMP, not read petitions. That is also not maintainable in other rights.
My lord, I have also filed an IA with regard to the status quo of the said land, my lord.
Status quo empty nahi habani. I am not assisting. It is civil suit re assist karchi civil judge senior division assist karibi na kon.
Yes,
we have made arrangements. We are making and verifying the arrangements. Like you are moving the High Court. Why the vacation court is there? You will find many of the matters which are not necessary to be listed are being listed also. Still that is being listed and orders are passed. So why the court is made available and there is a roster. All interim matters are possible. Yes, next.
Item 16 will same.
16 times simply adjourned. Mr. Muhammad S. Ali for the petitioner, Mr. 15, 16 or 16 re Mr.
18 well.
Mr. Devaraj Mahanti AG. 18 re Mr.
MD Shaikil, my lord.
CK Pradhan Mailor.
Mr. CK Pradhan.
AG.
ଆପଣ ନାହାନ୍ତି ଏଥିରେ ସେଣ୍ଟ୍ରାଲ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ନାହାନ୍ତି
ନାଇଁ ଏବେ ନାଇଁ ଅଫ୍ ମାଇଲର
ମିଷ୍ଟର ସିକେ ପ୍ରଧାନ ଏଜି
ମାଇଲର
ସିକେ ପ୍ରଧାନ ଏଜି 18 adjourned. After arguing for some time, the petitioner 6 learned counsels is added. So it's okay. So Harikrishna Panigrahi for the petitioner, Mr. CK Pradhan for the opposite party. Yes.
May I please, Milors?
Yes.
Here, Milors, the petitioners are continuing as Milors statistical assistants, Milors. And the Milors private opposite party number 6 and 7 are continuing as statistical investigators, Milors. Milors, both the posts are group B category, Milors. Now, Milors, by the impugned order, Milors, Annexure 17, Milors, space 94. Page 94, Milors, the impugned order. Milors, now, Milors, the grievance of the petitioner to treat the Milors SA and SI as base level posts and to prepare a common merit list have been rejected. And it has been directed to prepare a separate gradation list for SA, the post held by the petitioner, and separate gradation list for SI, the post held by the opposite party of 6 and 7. Now, Milors,
please take notice.
Milors, what has happened, Milors, in absence of any executive instruction or cadre rule, Milors, now they are going to give, Milors, they are going to demote us by giving promotion from SA to SI. So, Milors, there is no cadre rule, Milors, there is no executive instruction.
Demotion, unless there is a order, it cannot be delved into. Let them pass that order. That can be challenged. As you know, in service matters, demotion cannot be predicted. The order has to be there. You will be getting all the benefits. If the demotion is set aside, you will be getting all the benefits.
Milors, have a glance. Milors, annex, Milors.
If you are challenging you are challenging any order of demotion, so that.
Milors, now they are going to convene the DPC. Milors, where Milors, they are treating us as a Milors,
DPC, the order can be that any action taken pursuant to DPC shall abide by the result of the writ application.
Milors, what I am saying is,
any promotion given shall also abide by.
Milors, what I am saying is, Milors, now Milors, by annexure, Milors, annexure 26.
Notice nebeni, jodi notice nebeni, counter file haboni, tale adjudication kon habo?
I am more notice nebi, kintu we do not want to take promotion. But they are going to hold the DPC. We are not ready to take promotion. Because
DPC cannot be stayed.
My lordship, what I pray, Lord.
Says consequences of DPC may abide by the result. Suppose apana jodi promotion paibe, your immediate junior jodun to paibe, apana sedun to paibe.
No, it junior kotha asuni again. It junior kotha asuni. Semane amuku
apana jodi similar benefit paibe. Thik achi apana you don't agree with my stating that junior, but junior hi asibo ba similar. Apana jodi similar benefit paibe, suppose you will want to get similar benefit from the date they have got, you will be getting it. But it cannot be stayed.
What I submit, Milors.
Because you must understand, by staying a DPC, the consequences are very many, and you cannot predict the consequence of not by staying a DPC.
By staying the
DPC decision will be taken that will abide by the orders of this court.
Milors, may I submit, Milors? By staying the DPC, nobody is going to be affected, Milors. Nobody is going to be affected.
My order will be illegal. No, maybe by staying a DPC, I cannot pass an illegal order.
No, what I pray, Milors. What I pray, Milors, let the DPC go on, Milors, but the result of the DPC may not be implemented, Milors.
Nothing. So you have to be patient there. You will cross the bridge when it comes. Suppose, how do you know that everyone will be getting promotion in a DPC?
Milors, my lords, have a glance, Milors. 100 page 102. Page 102.
Mr. Panigre, upon Torovarele se problem habo.
ଆପଣଙ୍କର first prediction ହେଲା everyone will get promotion by result of DPC, which cannot be made. Even DPC may result in a situation where no one gets promotion. Nothing.
ଆଜ୍ଞା ଟିକେ ପେଜ 102 ଟା ଦେଖି ଦିଅନ୍ତୁ ତାପରେ
ପଢନ୍ତୁ. You make out the point instead of reading the page. You make out the point.
ମାଇଲର ପେଜ 102 ମିଲର୍ସ ପେଜ 102
ଆପଣ question ଟା ବୁଝିଲେ?
I got your ମାଇଲର answer question ମିଲର୍ସ
DPC ରେ ଯୋଉଟା result ବାହାରିବ ସେଟା ସମସ୍ତେ ପାଇଛି ବୋଲି promotion ହବ ସେଟା. Can we score that or predict?
Mailor, there is no post at all. How they will give promotion? Miles, that's why.
ଆପଣ predictive argument କରନ୍ତୁ ନାହିଁ.
ନାଇଁ
ଆପଣ ଯଦି ସେମାନେ post ନାହିଁ ସେମାନେ appointment ଦେବେନି.
ଆଜ୍ଞା କେମିତି ଆଜ୍ଞା ପେଜ
ଶୁଣନ୍ତୁ ଆପଣଙ୍କର problem ହେଲା ଯେ ଯଦି ଆପଣ ସେମିତି ଭାବିବେ ପଛେ ସେ ଯୋଉ ଓଡିଆରେ saying ଅଛି ପଛେ let the husband be killed and wife becomes a widow ସେଗୁଡା କରନ୍ତୁନି. So you have to be patient in service law. You have to see if DPC happens, what will be the consequence. You will be happy with the consequence, and suppose you are winning, you will get the same benefit.
Page 102 ଟା ଦେଖି ଦିଅନ୍ତୁ ଟିକେ ଦେଖୁଛି
You make out the point, sir. Straight away come to the point. Page 102 ରେ କିଛି ନାହିଁ.
ଅଛି ଦେଖୁନାହାନ୍ତି ଟିକେ ଦେଖୁନାହାନ୍ତି
You state କୁହନ୍ତୁ 102 ରେ କଣ କୁହନ୍ତୁ.
Page 102 Millers, paragraph 2 Millers. The promotional hierarchy in the cadre of statistical service under ART sector is Millers, statistical assistant or statistical investigator. That means both these posts are Millers base level post, and next promotion is field controller in group B. So Millers, now they are going to
ଆପଣଙ୍କର problem ହେଇଛି ଯେ ଯାହା ଆପଣ client ବୁଝେଇଲେ ଆପଣ ସେଟାକୁ ଗୋଟେ ଆସି argue କଲେ ସେଟା କେବେ କରିବେନି. What is the difference between your client's understanding of service law and your understanding? ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ସେଟା କିଛି nothing can be made out in page 102. ଆପଣଙ୍କର କୋଉଟା promotional post ନୁହଁ, which one you are saying?
Statistical investigator is not the promotional post.
ସେଇଟା ଆପଣ କହିଦେଲେ ହେଇଯିବ. ସେଇଟା ଯୋଉଟା ଆପଣଙ୍କର 19/3/21 ନୋଟିଫିକେଶନ ହେଇଛି ସେଟା ଆପଣ କହିଦେଲେ ନା ସେଟା ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରିବାକୁ ପଡିବ. If at all.
Next Millers have a glance Millers.
Cadre restructuring ର ଗୋଟେ ଅଲଗା impact ଥାଏ.
ନା cadre restructuring ନାହିଁ ପରା ଆଜ୍ଞା ହେଇନି.
ଅଲଗା impact ଅଛି.
ଆଜ୍ଞା ଇମ୍ପୁଲ ଅର୍ଡର ଦେଖୁନାହାନ୍ତି ଆଜ୍ଞା ଟିକେ ଇମ୍ପୁଲ ଅର୍ଡର ଦେଖନ୍ତୁ cadre restructuring ହେଇନି.
Paragraph 2 ରେ ପଢୁଛନ୍ତି that is your interpretation. That cannot be accepted without saying anything.
Millers, when the Millers cadre restructuring is pending law.
ଆପଣ ଯୋଉ ଚାହୁଁଛନ୍ତି ଯେ ଆପଣ ଯେହେତୁ ପ୍ରମୋସନ ପାଇବେନି କେହି ପ୍ରମୋସନ ପାଇବେନି ସେମିତି ଅର୍ଡର ହେଇପାରିବନି. ଦ୍ୱିତୀୟ କଥା ହେଲା ଯେ ଆପଣଙ୍କର ଯୋଉ ଚିନ୍ତା ଅଛି ଯେ ପ୍ରମୋସନ ପାଇଲେ ଚାକିରି ପାଇବେନି ସେଟା ଯେ ଚାକିରି ଦଉଛି ସିଏ ବୁଝିବ. That is not your headache.
My lord, when the director has no power at all in absence of any cadre rule
instruction. Director को power नहीं से कहिबे ना either से कहिबे मोर अछि कि नहीं आपण सेटा point रेज करछथि ना रीड पिटिशन में.
हां रेज करछि आगे
से आंसर देबे.
माइनस
सबमिशन स्टेज रे मु कहि देबी जे डायरेक्टर को पावर नहीं तेनो प्रमोशन दे परिबेनी.
No, I cannot Millers.
So you have to be patient with your approach. आपण नोटिस इश्यू करे पे जो पर आर्गुमेंट करछन तार किछि वैल्यू नहीं. Let them respond.
My lord, they are admitting that the cadre restructuring proposal is pending. So Millers,
when the आपनकर रिप्लाई फाइल करना आपण एडमिशन को चली आसलेनी कोठी एडमिशन एडमिट से कले.
96
करंतु.
No, page 96 my lord have
96 एडमिशन नो कोर्ट रे जोटा से रिप्लाई फाइल करे एडमिट करिवे.
Millers, director who is the appointing authority Millers, he himself is saying that Millers the cadre restructuring proposal is pending.
एटा फाइनल माने मेरिट रे आर्गुमेंट करछन ना नोटिस इश्यू बाय कहउछन आपण.
For issuing notice Millers.
So आपण नोटिस 10 मिनिट तले हेई सालनी 10-15 मिनिट तले. You are just wasting time at 5:30. Petitioners have stated to be working as statistical assistants in the office of the Director of Animal Husbandry and Veterinary Services. They are agreed by the gradation list circulated with a letter number 6618 dated 24/4/2024 for the post of statistical assistants. And further prayer, they have made a further prayer for publication of a unified public common gradation list of statistical assistants and statistical investigators. As per the rank position assigned in the merit public select list
dated 31/5/2017 under Annexure 4. It is further submitted by the learned counsel for the petitioner that the cadre rule is yet to be formulated and there is no executive instruction governing the services of statistical assistants and statistical investigators in the Directorate of Animal Husbandry. It is further submitted that the director doesn't have the jurisdiction, doesn't have the authority to hold any DPC. But the petitioners are also agreed by the DPC notification.
DPC Milords, page Milords, page 26, page Milords 120.
कौन पढ़ो तो 120 रे कौन लिखा है?
Milords, in inviting yes, Milords, in inviting reference to the above subject, I am to say that the power and property statement of statistical assistant group B of this directorate are essentially required to produce the same before the Department Promotion Committee.
Agreed by the letter dated 25/5/2026, seeking to 26 issued by the Director, Animal Husbandry and Veterinary Services, addressed to the Additional Secretary to Government of Odisha in G and PG Department. Which mentions regarding Departmental Promotion Committee for consideration of promotion of B, C and D of Group B, C and D employees working under the Directorate to the post of Statistical Investigator. Stop. Issue notice along with this order. ऊपर लिख देती है hard learned counsel for the issue notice along with this order. The learned appearance lecture, Chandrakanta Pradhan lecture. Appearance number लिखने दो. Mr. Hari Krishna Panigrahi for the petitioner. To Chandrakanta Pradhan for the opposite parties 1 TO2 5 AGA for opposite parties 1 TO2 5. The learned AG upon advance copy served appears and waves notice on behalf of opposite parties 1 to 5. Notice be issued to the opposite parties 6 and 7 by speed post with registration and proof of delivery. Which is for issuance of notice to file within 3 working days.
My lord, opposite party 1 to 4, 5 to notice to Odisha staffs.
1 to 4. 5 to 7, 5, 6 and 7 speed post corporation. Returnable date be fixed to 10/7/2026. Returnable date shall be fixed to 3/7/2026. The matter shall be listed for orders in the week commencing 20/7/2026. Hard learned counsel for the petitioner, he reiterates his submissions as noted above, issue notices above. The learned AG appears and shall obtain instruction and file his response. Along with the counter to the writ application. जो अपना ऊपर लिख लेने की returnable date be fixed to कितने? Yes. 3/7 counter affidavit be filed by 10/7/2026. Upon serving copy thereof on the learned counsel for the petitioner, the matter shall be listed for orders in the week commencing 20/7. in the interim, it is directed that any action taken pursuant to the letter dated 25/5/26 regarding promotion to the post of
statistical investigator.
Statistical from the posts of statistical assistant only.
No, petitioner confined to statistical investigators.
The post of statistical investigator shall abide by the result of the writ petition and shall be subject to the further orders of this court. Urgent certified copy as produced. The parties shall have liberty to act upon the copy of the order obtained from the official website of this court.
Much obliged.
Yes. Next.
May please your lordship, my lord. I am a petitioner. The petitioner occupied a 5 decimal land, dorsal land which is not objectionable for construction of the house and constructed therein. Eviction notice issued and the eviction notice has been challenged before the appellate authority. The appellate authority rejected my appeal.
Then
under Annex 1. Thereafter, Tahsildar Sabdega immediately on
then against the order of the appellate authority, what is the remedy?
Remedy of revision is there, my lord.
So file that.
But the
by what time you will file? By what time you will file?
With file within 15 days, my lord.
The petitioner is before this court against the threat of eviction and demolition. Threat of his eviction and demolition of his dwelling house. Which was subject matter of the appeal number 21 of 2026. In the appeal filed under in the appeal law, stop kar diyo. The appeal was filed under section 12 of the Orissa Prevention of Land Enforcement Act 1972, challenging the form K notice dated 29/10/2025, form K notice dated 29/10/2025, and eviction notice dated 19/1/2026 issued by the Tahsildar Sabdega. এটা আপনারা দেখি লেখা ভুলবার একটু পেজ 10 রে আছে for unauthorized occupation না কোর্ট রে over government land appertaining to মৌজা রাজপুর খাতা নম্বর 174 প্লট নম্বর 691 ইসম ধরসা area acres 0.05 decimals. It is submitted by the petitioner, learned counsel for the petitioner, that the petitioner shall avail the remedy of revision before the revisional authority.
Collector.
Till then, he should not be evicted. His dwelling house should not be demolished. Should not be demolished. Opposite party Mr. Prem Kumar Mahanti for the opposite parties. Additional standing counsel. Acha Takini, appearance Takini. Mr. Prasanto Kumar Sapati for the petition. In view of the limited nature of prayer made by the petitioner in the application, in the interest of justice and fair play, it is directed that the petitioner shall approach the revisional authority challenging the order dated 7/5/2026 passed in endorsement appeal number 21 of 2026 by sub-collector Sundargarh, by filing the revision by 19/6/2026 by 25/6/2026 along with an application for consideration of interim prayer regarding protection against removal, eviction and demolition till disposal of the revision application. Upon filing of such revision and interim application, the authority shall do well to consider the interim application at the earliest and pass appropriate orders. Till disposal of the interim application in the revision application or any such order. Status quo as on date regarding possession, ownership, nature, character, possession, ownership of Khata number 80 of the subject plot, that is, see, plot number 80 shall be maintained by the parties. Upon treaty of palace theory, palace theory shall be maintained by the parties. Yes, next.
Please, Your Lordship.
Yes, please.
My Lord, sir,
Somnath Mishra for the petitioner. Yes.
Petitioner is the outsourced agency, my lords, and is a covered establishment under the ESA Act, my lords, and is paying the ESA contribution. Now, my lords, Annexure 1 was received by the petitioner on 10/12/2025, Annexure 1, and pursuant to that, on 12/12/2025, I wrote to the authority that there is some miscalculation or some excess demand is there. So please give an opportunity so that we can solve the problem. That is paragraph 5, my lords. Then, my lords, instead of doing that, I waited that he will be sending a letter for personal hearing and all that. But he sent Annexure 3, my lords, another demand for another period. So I have approached your lordship. What I pray, I have served a copy on Mr. Ray. Your lordship may say no coercive action pursuant to Annexure 1 and 3 till any date my lord will fix.
The petitioner is a partnership.
It's a partnership on my lords and he is the managing.
Petitioner is a partnership concern represented through the managing partner, has approached this court against the notices issued as well as actions initiated by the Deputy Director Revenue, Employee State Insurance Corporation, Bhubaneswar.
Annexure 1 and 3.
That is notice dated, letter dated 24/11/2025 into bracket Annexure 1 and notice dated 7/5/2026 dated as 7/5/2026 issued by the said authority.
Annexure 3. Again.
The said Annexure 3 has been issued under the Section 40 read with Section 39 of the ESA Act as well as the relevant rules. Stop. It is submitted by the learned counsel for the petitioner that the petitioner is covered and and shall comply with the ESI requirements. The requirements of the ESI Act. Requirements of the ESI Act. However, he needs some breathing time as well as opportunity to represent before the authority regarding his stand. Stop.
Yes. Yes.
This will notice along with this order. Mr. Amrinder Prasad Ray, along with Mr. N.D. Tripathi, who usually appear for the Lord Mr. Amrinder Prasad Ray, Lord Standing Counsel, along with Mr. N.D. Tripathi, who usually appear for the opposite party corporation. Being present in court shall accept notice. Two extra copies of the writ application is served on Mr. Ray.
Only one.
Mr. Tripathi. Stop. To enable them to obtain instruction. Duly executed Wakalatnama in favor of the learned standing counsel and learned associates shall be filed within 3 weeks. Upon filing of the Wakalatnama, name of the standing counsel, Mr. Ray and learned associates shall be reflected in the cause list as well as the case brief. Stop. The learned standing counsel shall obtain instructions in the matter. Stop. The matter shall be listed for admission in the week commencing III/8/2026 stop. I 10396 of 2026 had learned counsel for the petitioner. He reiterates his submissions as noted above. Issue notice as above. And the learned standing counsel for the ESA corporation along with the learned advocate Mr. N.D. Tripathi shall obtain instruction in the matter. In the interim, it is directed that no coercive action shall be taken against the petitioner without leave of this court, pursuant to the notice at Annexure 1, letter at Annexure 1 and the notice at Annexure 3. Urgent certified copy as per rules. The parties shall have liberty to act upon the copy of the order obtained from the official website of this court. Yes,
May I
please. Yes.
Can I get it by tomorrow, my lords? If today it's not possible, by tomorrow at least.
Today, even tomorrow, I have doubts because now I don't know how. Maybe we need to have a break after 5-10 minutes. We can decide to have a break for 5 minutes or 10 minutes after 2-3 matters.
Yes,
Then
yes,
so that we can reach the end.
We are deeply obliged to your lordship because now 6 o'clock and your lordship is there. So I'm grateful.
God is kind. God is kind to all of
Yes.
us.
So wish you all a happy vacation, my lords. Before I part.
Thank you.
Item 21.
You are sitting at the lotus feet of the Lord.
Yes.
You always say he's at, above your head. So since my staff are also overburdened, we can have a 5 minutes or 10 minutes break now. You can resume at 6.
So item 21 will be taken up at 6 o'clock.
Yes, definitely.
It's only, I have no notice, madam. In that case, I am the caveat. Item number 21. I beg to appear for the private part.
We will resume. Just give us some time. Because it has been a hectic day for them also. So all of us should have some break.
Right.
Miller.
No. Okay, all the best. No. Yeah. It is so. No. Oh,
Yes.
My lord, I beg your pardon, my lord. Item 36 may be taken up after vacation, my lord.
36 after vacation.
After vacation. Obliged, my lord.
36 টাକୁ after vacation mention. adjourn କର। ଆପଣଙ୍କର ଇଏ ଦରକାର ନାହିଁ ସେଟା ସିଏ କରିବେ କମ୍ପ୍ୟୁଟରରେ କରିବେ ଅର୍ଡର ଲେଖନ୍ତୁ ଅର୍ଡର ଲେଖନ୍ତୁ ସିଏ କରୁଛୁ 21
Miller, may I please your lordship?
yes please
Miller, in item 21 there are two
36 ଟା ହଉଛି Mr.
Murthy sir.
36
Yes.
36 after yes
I filed an caveat application.
Let me complete, Mr. Murthy. Let me complete.
Okay, okay.
No, Mr. Murthy, Mr. Murthy, you are entitled for a copy. I'm sure that your senior will not deny that. But hearing is not prohibited in because the general impression is that the matter cannot be heard. I think that's not the law.
Yes.
Before passing any order, you have to be heard.
Yes, Miller.
Correct.
Miller, there are two matters, Miller.
Both are seasoned campaigners, Mr. Murthy and Mr. Bhuya.
Yes, Mr. Murthy is a very well known to me and is a seasoned campaigner, as your lordship said. Millard, he knew that there are two writ petition filed challenging the same impugned order. He lost the caveat in one.
Okay.
So the other one is to be heard, and where my learned friend Mr. Murthy has lost the caveat, I will certainly serve a copy on him.
No, even you have not served a copy. The right of pre-audience, as far as order is concerned, is there. He will be heard.
Yes,
if he is intending to pass a order, here, Mr. Murthy.
Yes,
Millard. Now, your lordship may kindly see the impugned order is Annexure 7. Millard, just I am placing the fact which may be necessary for determination in this case, Millard. Millard,
Yes.
OP number 5.
You are placing one seat 17326.
Millard, first item.
Okay.
Abhishek Vishwal, Millard. Millard, the OP number 5, claiming to be the daughter-in-law of one Chiram Sonia.
Yes. Punai Hanta. OP number 5 is Punai Hanta.
Millard, Punai Hanta, claiming to be the daughter-in-law of one Chiram Sonia, initiated OSTIP case, that is Regulation 2, case number 1 of 2022.
Yes.
Only including OP number 2 of the two persons as opposite parties. Those are the sons of the transferee, previous transferee. So there an order of eviction was passed. Since we are the persons affected by the orders and we have not been provided an opportunity of hearing, we approached this Hon'Ble Court in a previous writ petition. Lordship may come to Annexure 2. There, your lordship kindly turn to page 50. Annexure at relevant portion is paragraph 13.
Yes.
Page 49, my lord.
Yes, it starts at 49 in the result.
In the result, the writ petition filed by the petitioners are the subsequent transferee, my lord, are allowed on contest. The impugned order dated 25/10/2023 and 29/11/23 respectively passed in TIP case number 1 of 2022 by the CA and OSD LR Koraput are quashed. Your lordship may kindly emphasize the order he passed in that Regulation 2 case number 1 of 2022 was quashed. Thereafter, the matter is remitted back to the authority for deciding the safe appraise as per law after impleading the petitioners as opposite parties in the said case and to dispose of the case as per law as expeditiously as possible, providing, here also your lordship may emphasize, providing opportunity of being heard to all the parties thereof in full compliance with the principle of natural justice. That was the order passed by this Hon'Ble Court in the Annexure 2. Thereafter, we appeared, the petitioners and others appeared, and we filed our counter. The Annexure 3 is our counter, as well as a memo has been filed on behalf of the petitioner. The petitioner, my lord,
was not included as a party. His mother was included as OP number 3. You'll also may kindly turn to Annexure 1. That is after remand, these persons were implicated as parties. Only OP number 1 and 2 were parties, but after remand, the subsequent transfer were implicated, and my predecessor in interest was OP number 3.
Yes.
Notices were issued as pursuant to the direction of this Hon'Ble Court. The petitioner appeared and filed a memo indicating therein that OP number 3 is dead. While the matter was pending for hearing, the death certificate was also furnished along with a memo that in the meantime, Sunya Basi Biswal has died. It was brought specifically to the knowledge of the OP number 3 by filing a memo on 28/1/26. Milord, apart from that, you also will get there are other 3 persons who are also dead, and the notices against them also returned unserved because of the death. It was brought to the notice of the petitioners in that case, as well as the OSD, that these persons are dead, and pursuant to the direction of this Hon'Ble Court, is bound to provide an opportunity of hearing to the persons, those are affected by the order, that is the order under Annexure 2, clearly reveals, Milord. Despite it, Milord, the dead persons were not substituted. Only one of the person who has submitted the death certificate, the OSD treated that he is to be treated as substituted in place of the dead person, OP number 3. And without providing, your Lordship may kindly turn to page 80, Milord.
Yes.
The order dated 17/4/26 reveals, Milord. Time is allowed.
Page again.
Milord, page 80.
80. Okay.
74/26, Milord. Time is allowed and posted to 27/4/26 for filing of counter and hearing. I mean, correct, Milord, this is the order dated 17/4. Then the next date was 27/4. On that day, I have given the entire order sheet. Milord, you'll without spending much time, your Lordship may kindly come to the conclusion part, Milord. Page 82.
Yes, sir. And one more query, Mr. Bhuya. These 27 persons implicated as party, that excludes the dead persons and the legal heirs.
38 persons were implicated as parties, and your Lordship will see from the
27 or 38?
Milord, the Annexure 1 reveals, Milord, 30 some odd persons, Milord. It is total number of persons.
But the learned adjudicating authority says 27 persons.
Milord, your Lordship may kindly see Annexure 1.
Yes.
Annexure 1, 37 persons.
Achha.
Not the petitioner. Including some dead persons, Milord. Now, your Lordship, short point before your Lordship, kindly come to page 82, the operating part. Your Lordship has seen this Hon'Ble Court quash the order.
Yes.
The officer has the audacity to say that I restored the order. Your Lordship may kindly see that part. For that reason, the order has to go, Milord. In view of the above circumstances and documentary evidence, I am inclined to uphold the order of the OSDLR Koraput by the order dated 25/10/23 and dismiss the claim of the opposite parties. The order which has been set aside by this Hon'Ble Court in Annexure 2, he upheld it as if he is the Supreme Court.
So, has he taken note of the High Court's order?
Yes, your Lordship may kindly see the impugned order itself. It reflects
at how he has dealt with the High Court's order.
Milord, that
how he has understood that. One can say how he has understood the High Court order.
He has, in GST, your Lordship will see, he has said that the person has died. That is my OP number 3, for whom I am now, whose son I am appearing. That since the death was not reported in the High Court, I am not concerned. And thereafter, we say,
So kindly just kindly place that portion at page 75. Page 75, part of order dated 28/1/2026.
Page 75, your lordship may kindly.
Order dated 28/1. I think he has discussed the High Court's order.
Millard, prior to that also he has discussed Millard. In the story, 13,
I mean, the consequence of High Court order, how he has understood.
That your lordship may kindly see 28/1/2026. The case is taken up today. Advocate for
Continue.
There are 37 numbers of parties as incorporated cost title filed by the first party. The notices were issued to the newly added second party member. The notice issued to the newly added second party members as per the order of the Hon'Ble High Court of Orissa are back after due service on second party number so and so. 3, 5 to 8, 3 was alive then. 10 to 21, 25 to 30.
On 4/9/22,
Millard, 4, 9, 22, 23, 24, 31 and 32. So and so appears, Millard. Last paragraph, Millard, last portion of that page, Millard. The 5 lines from bottom, Millard. The certified copy of the High Court order disclosed that Sunyavasi, son, I have filed the writ petition. Sunyavasi Vishwal was the petitioner in WPC number so and so. The Hon'Ble High Court has passed the order on 21/11/25, and there is nothing on record to show that the death of Sunyavasi Vishwal was intimated to the Hon'Ble High Court. Thus, the order passed by the Hon'Ble High Court in WPC number so and so. Hon'Ble High Court has passed the order on 21.
Is in respect of a dead person.
Milord, it was brought to the notice that now this order is against a dead person. Milord, it was brought to the by filing a memo. Milord, your lordship has seen 28/1. Annexure.
So it seems, it seems that the learned, the OSD has some confusion regarding implication.
OSD is never learned. He learned, Milord. He could not have passed this type of order. Your lordship, he has again dealt with. Milord, kindly turn to page 75, last portion. The
77 also is. See,
Milord,
perhaps he has got kind of. He thinks that perhaps no further notice be issued or what.
Milord, no, on that, no, Milord, even OP number 8 was dead, it was brought to, Milord, last paragraph of page 75, your lords may kindly see. The first party is directed to supply a copy of the petition to the second party members. On perusal of the return notice of second party number 8, Madhav Khora is dead. Similarly, a memo is filed by Sri Gupteswara Panigrahi stating that second party number 3, Sunyavasi Vishwala, is dead on 24/10/25. The certified copy of the High Court order disclosed that Sunyavasi was the petitioner in WBC number so and so. The Hon'Ble High Court has passed the order on 21/11/25, and there is nothing on record to show that the death of Sunyavasi was intimated to Hon'Ble High Court. Thus, the order passed by the Hon'Ble High Court in WBC number so and so. Thereafter, he has in respect of a dead person. The said fact to be brought to the notice of the Hon'Ble High Court. Milord, 27 numbers of writ petition were filed. Those were had. The order was passed. By then, the Sunyavasi was dead. But that your lordships knows under order 22. Once the hearing commences, death is immaterial.
Yes.
So, as if the person is alive, the order will be passed.
Yes, but after the hearing has commenced and completed, so
there is no need for substitution, Milord. And once it was
even suppose assuming the High Court was not aware and Sunyavasi was dead and his legal heirs are not substituted. If they are substituted in the remanded proceeding, that is enough.
Yes, they have to substituted in the remanded proceeding. We have brought into the notice of the OSD that the petitioner may be directed to make necessary substitution. There are four or five persons; those are dead, and otherwise the proceeding cannot proceed further without any substitution. That was not had. He was very eager to conclude the hearing on the same date when
that I was telling you that perhaps he could not sustain the time taken in. He could not adjust with the time taken in sufficiency of notice, which is a usual feature in civil proceedings. Most of the civil proceedings are dragged because of sufficiency of notice to be achieved.
Millard,
it is a feature.
Millard, it is a quasi civil in nature. It is not a civil proceeding where the reverse of order 22 will be applicable. But only that a proceeding cannot continue against a dead person because the Honorable High Court in the previous order clarified that you are to provide opportunity of hearing
to anyone, whoever is being dispossessed.
Yes, whose interest is going to be affected.
Yes, Mr. Murthy, on this point, I don't think there can be any two opinions.
My lord, actually, I do not know what the type of applications they have made. Actually, until and unless.
Do you have a copy of the order? I don't think, because I don't find your name before the trial court. I mean, the CA
not because others were actually appearing, my lord. Subsequently,
yes,
it was entrusted to me. That's why I had to collect the required.
So the issue now is that the court has, though initially started in substituting the applicants, I mean the affected parties, gradually the efforts have fizzled out.
Probably, I thought that I think that actually the learned magistrate, as my learned friend has said that he cannot be termed as a learned one, but the magistrate has taken it as if the proceeding before the High Court, the order becomes final so far as the dead person is concerned, since the LRs have not been brought on record. Maybe that is the idea he might have carried with him.
No, that argument is much higher plane, Mr. Murthy. That you can argue. No, he has not gone to that extent.
Right.
Your point, I mean, it's a good point that as far as those person is concerned, but somehow he has not been able to sustain his effort to substitute all the parties, which he should have.
That's true. I have to actually seek instruction so far as my learned friend is concerned. So
you will be appearing in this matter, Mr. Murthy.
Yes, my lord. I will be appearing in both the cases.
Appearing for OP number 5, I think
only 5.
Number 5.
I don't know what is she has been arrayed as OP number 5.
OP number 5.
The first one after the Tahsildar.
Sir,
up to Tahsildar or state parties?
No, it is before the OSDL.
No, in the writ petition. The writ petition, OSDL
option on special duty land reforms.
So he has not been made a party.
Lord Sub-Collector has been authorized.
Sub-Collector is the OSDL. He is
ex officio. Yes, madam.
Tahsildar 4.
Yes, madam.
So how you will receive notice, Mr. Murthy?
My learned friend can very well send me by post also, my lord.
Okay.
So Mr. Murthy's phone number is known to me. I can send it through WhatsApp.
Oh,
so
sure.
You can send it by speed post instead of serving the copy on the petitioner, taking notice to petitioner. You will send a notice to the address of the
I will receive the note. I will receive the note on behalf of the OP.
Okay.
That's all. It is in one case. I hope it is in one case, number.
The impugned order is one in both the cases. My name, Loan and Paid, appear in one of the cases, that is sub-item number 2.
WPC 17333 of 2026. You just submitted referred Mr. Bhuya 17326.
Millard, 17326, Mr.
17326. Okay. Millard. There 17326, Mr. Murthy doesn't have instruction yet.
No, I don't have.
But he can appear for OP number 5. He is the petitioner in the trial.
No, I'm.
So Punai Hanta, you can appear. Punai.
I think the other juniors were appearing, my lord. I think.
So notice to go to Punai, or you will accept?
Yes, my lord.
You will accept or notice to go?
I will accept the notice. Okay. I will accept the notice.
Okay. Mr. Vivekananda Bhuya, senior advocate, along with Mr. Saurabh Suman Bhuya for the petitioner. Mr. Prem Kumar Mohanty, additional standing counsel for opposite parties. 1 TO2 4.
The learned senior counsel for the petitioner is heard at some length. He refers to the order passed by the coordinate bench of this court in WPC number 1798 of 2025 by judgment. He refers to the judgment dated 21/11/2025 passed by the coordinate bench in WPC number 1798 of 2025 and the connected batch of 26 matters, 27 writ petitions.
27. Yeah.
He referring to the said writ petition, it is submitted by the learned senior counsel that in the said writ petition, the present OP number 5 was Pune was
the petitioner. Was the petitioner?
No. In the she was OP number
5.
Oh, Pune. In the writ petition, Pune
In
was
the writ petition, she was 4 Miller.
OP number 4.
The present OP number 5 was OP number 4 in the said writ petition. All the 27 writ applications were taken up together by the coordinate bench as it arises out of one OSA TIP, Orissa Scheduled Areas, Purata Lekhiru. One OSA tip case number 1 of 2022 under section 3-capital A of the Odisha Regulation 2 of 1956. The orders impugned in the said writ application being 25/10/2023, being dated 25/10/2023 and 29/11/2023, passed in the OSATIP said in the said OSATIP case by the C.A. and OSD O.S.D into bracket LR Koraput. He is the sub-collector.
Yes,
sub-collector.
The sub-collector comes C. So sub-collector dash competent authority and officer on special duty into bracket LR Koraput.
Land report.
The learned senior counsel then refers to the operative portion of the order, judgment, which is reproduced here. बारह और 13 रिप्रोड्यूस करते हैं 12 पाइबे पेज 49 13 होचे पेज 58. It is submitted that after remand of the matter was again taken up by the learned taken up by the sub-collector DASCOM, CA and OSDLR Koraput. Efforts were made by issuance of notice to some of the newly added opposite parties who were not included as parties. However, some of the legal heirs of the deceased parties were not substituted. Referring to the order dated, where he has noted that
that is order dated 13/1/26. So Lord will get it. So Lordship will get starts from 13/1/26, page 74, Milord.
74.
Milord.
Referring to the order dated 13/1/2026, it is submitted by the learned senior advocate that
Milord 28/1. Lordship may see 28/1. 13/1 is the order.
28/1/2026. It is submitted that 27 number of petitioners were added as second party in the proceeding. And whereas 37 numbers of parties are incorporated in the cause title filed by the first party in the claim. It is submitted that during the proceeding, somehow on the way of adjudication, the purpose of appearance of parties for effective hearing was lost, inasmuch as some of the deceased parties were not arrayed as parties. Some of the legal heirs, some of the legal heirs of the deceased were not arrayed as parties, and some of the parties who were in the writ petitioners were simply not heard or represented. Stop. Referring to the final operative portion, final of the final order dated 27/4/2026 operative portion. The learned senior counsel refers to, they submits that the order that was set aside and quashed by the coordinate bench has been again restored. The relevant portion referred to by the learned senior counsel, page 82 the document. In view of the above circumstances, up to order pronounced in open court, this date 27th day of April 26. Issue notice along with this order to the opposite parties.
Milord, no notice we served to open number 6 to 30. Milord, they were the opposite parties in the proceeding, Milord.
Okay,
They have also
okay. Issue notice to the opposite parties 1 to 5.
Yeah.
Along with this order, Sir, the Lord, additional standing counsel upon advance copy served appears on behalf of opposite parties 1 TO to 5, 1 TO to 4. He shall obtain instruction. Mr. Narayanamurthy, Learned Counsel, appears being present in VC and submits that he has instructions to appear on behalf of the OP number 5, Hunai Huntal. No notice, no further notice be issued to the said opposite party. However, the Lord instructing counsel, Mr. S.S. Bhuya, shall send copy of the entire brief with connected papers by registered post, by speed post with registration and proof of delivery in the address of Mr. Narayanamurthy, Learned Counsel. So, upon the Learned Counsel, Mr. Murthy has shall file duly executed Wakalatnama within 21 working days. Upon filing of Wakalatnama, the same shall be taken on record, scanned copy be obtained. How there are so many IAs? Leave is leave.
Milord, I have filed one IA because previously I have before the sub-collector of the OSD, I have filed that this matter, the similar matter under section 3B was taken up previously by the OSD, and there was an inquiry. On inquiry, it was he recorded a conclusion that the transfer is valid. It is accompanied with a prior permission. That proceeding of the records of that case may be called for. That was not.
After Mr. Murthy's appearance, the records of the so and so case from the from so and so sub-collector from so and so be called for and placed for reference.
My humble submission is, sir, actually they in the 3B applications they had quoted one number. In the purchase deed, they have quoted that it is that particularly the permission order was granted in MC 10/80. Subsequently, in the 3B application, they have gone 30/80. So something like that, they could not produce the document. If they had purchased with a valid document, the permission order should have been given.
Let us see. Let us
It
see
must
that
be available with them, my lord. It must be available with them.
No, it is available with the.
It must be available with them along with the record.
That is
Tell it.
now IA, my lords, kindly see the first IA is not.
Mr. Bhuya, you are referring to which IA?
10332.
IA 10332 of 2026 record of Hard Audit Council for the Hard Audit Senior Council for the.
Not to take.
No, calling for records.
Coercive action or eviction.
Calling for records, which one you have filed?
जो डॉक्यूमेंट लेखा ହେଇଥିବ ସେ ଡॉक्यूमेंट ଆସିବ ସାର୍ ତାହେଲେ ଡॉक्यूमेंट ଯୋଉଟା ଅଛି ସେଟା ତାଙ୍କ ପାଖରେ ଥିବ ନା ସାର୍ order that they could very well produce it.
Sir, let me complete all the IA. Sir, 103, that is 1032 gala 10334, that is dispensing with filing of certified copy. Because the certified copy is filed in the connected writ petition.
IA 10334 of 2026. Hard Audit Senior Counsel for the petitioner. The IA has been filed for dispensing with filing of certified copy. Since the certified copy is available in the connected writ petition in WPC 17333 of 2026. No further. The IA is favored and disposed of. Attested photocopy of the certified copy shall be accepted.
Has been filed along with an application, that application.
Okay. Then 10336 for analogous hearing.
Analogous.
So, 10336 of 2026, the IA has been filed for analogous hearing of the writ applications 17326 and 17333 of 2026. Since both the writ petitions arise out of the same order, the prayer for analogous hearing is just and proper. And in the interest of justice, it's just and proper, and in the interest of all the parties. Stop. Prayer for analogous hearing is allowed, the IA is disposed of.
Well, 10332 is for
IA 10332 of 2026. Hard Audit Counsel for the Senior Counsel for the petitioner, Mr. Prem P.K. Mahanti, is for the opposite parties, so and so, and Mr. Narayan Murthy for the OP number 5. It is submitted by Mr. Narayan Murthy that he has not received copy of the application. It is directed along with the copy of the writ application, all the IAs shall be forwarded by the Learned Instructing Counsel, Mr. S.S. Bhuya, to the Learned Counsel. In the interim, it is directed. No further action shall be taken pursuant to the order dated impugned order dated passed by so and so.
By the annexure 7.
Without leave of the court. Stop.
This all the IA in this writ petition stand. Your Lordship has already passed the order. The other connected case is the impugned order is same.
IA 17 tapar lekhan to WPC 17333 of 2026. The matter is heard along with the writ petition 17326 of 2026, wherein the following order has been passed. The pura reproduce kar de order. Separate order karantu. Appearance saman rahe. Mr. T.N. Murthy, Learned Counsel, submits that he is in caveat. Eta caveat order karantu, caveat number 719 of 2026. He is in caveat. Since the parties, the Learned Counsel is appearing from a distant location and the court is functioning in virtual mode, the Learned Instructing Counsel, Mr. S.S. Bhuya, shall forward copy of the application petition along with all the annexes in the address of Mr. Mukti, Learned Counsel, who has instructions to appear on behalf of OP number 5.
Here
stands discharged.
The annexure 7 in the previous writ petition is the annexure 6 in the present writ.
Okay.
Because since it is already one order is there covering the order, so that I am simply clarifying. Mr. Murthy shall appear then 5. The Lorded Counsel shall file his Wakalatnama within 21 working days. Upon filing of the Wakalatnama, caveats
And
caveat ଅଛି ଓକିଲନାମା ଆଉ ଦରକାର
caveat ଅଛି ସେଟା ଚଳିବ
in
sir.
view of filing of the Wakalatnama of Mr.
Got matter file.
The caveat, no further Wakalatnama need be filed on behalf of OP number 5.
Sir.
Notice to OP number 6 to perform opposite parties is not dispensable to all the time.
My risk.
ऊपर भी से लाइन ऐड कर दो प्रोफॉर्मा का नोटिस जाऊंगा आइए 103358 of 2026 in view of the order passed today in the interim order passed in IA number
1332
1332 of 2026 arising out of WPC number 17326 of 2026. Thus, the said order is reiterated in the present time. Stop. No further action shall be taken pursuant to the impugned order dated passed by so and so in so and so so and so.
Till next date,
the matter shall be listed. Both the matters shall be listed for hearing in the week commencing. Mr. Mukti, can you suggest a date in July or August?
Any date, my lord, as your
yes,
lordship.
Mr. Bhai.
Any lord, your lordship.
For hearing in the week commencing of 3rd of August 2026.
Till next date only. The stay order may kindly be granted till next date so that anything.
जो आपण कलेनी की नो सर shall be till the next date of hearing add कर दो. Till next date of hearing. Urgent certified copy shall be issued as per rules. The parties shall have liberty to act upon the copy of the order obtained from the official website of this court. Yes. Item 23.
Much obliged, my lord.
Yes, please.
May I please, your lordship?
Yes.
My lord, I have come up with lordship with limited points. Because here, my lord, what has happened, I had filed a suit for declaration and permanent injunction. In that suit, I had filed an IA for interim injunction. That application was lied over, for which I came to before this honorable court by filing CMP.
Yes.
And this honorable court was pleased to pass an interim order status quo, directing the trial court to hear the injunction application.
Yes.
That one was heard. After hearing the same, the trial court was pleased to grant me 90 days of interim protection.
Yes.
And thereafter, my lord, I prefer to appeal before learned district judge.
Yes.
There, I challenge to the extent that 90 days will not serve my purpose because suit is pending. In the meantime, with the status quo for 90 days, if suit will not be disposed of, the purpose of filing suit will be frustrated. Thereafter, my lord, what has happened? There was status quo and the appeal was pending. The appeal was heard, my lord. The order was supposed to be delivered, but at present, it shows in the online that it is for argument. It is fixed to 27th of June. Why before lordship, my lord, here my landed property is there, where there is 228.
So it is your case is that still the FAO is pending, and
yes, my lord.
and the CS is pending.
Yes, my lord.
So you want extension of the interim order till disposal of the CS or
FAO? Because CS is there. That much only, my lord. I have limited prayer this section only.
So till disposal of the FAO, the interim order should continue.
Yes, my lord. That is only the I have prayer, my lord.
Mr. Das, you are appearing?
My lord, I am appearing for OPTCL, my lord, in this matter. What happened, my lord, is the FAO
that prayer, Mr. Das, by younger Mr. Das is not affecting you any matter.
And
because if the FAO is decided either way, whatever way it is decided.
No, my lord, what happened, my lord? It is with regard to the change of alignment. The tower is going to be constructed, already constructed in his land. Also, compensation paid in view of the Telegraph Act. So, my lord, the alignment.
Don't pay any compensation. But as far as the FAO is concerned, if the interim order is still disposal of the FAO, so how is it affecting you?
So that's why, my lord, if you get any interim order here, my lord, then what remain for adjudication before the land?
It is there, my lord. It was there by this honorable court.
obviously that interim order is there, so what can be done? And the other part is that court has not expressed any opinion. Kindly look at the order of the coordinate bench. Court has not said anything regarding your interest or no way it is prejudiced. Just look at the High Court's order, the earlier order by the coordinate bench.
I have not received also read petition copy. No problem.
So that says
Page 39.
3940, 40 টা দেখুন but Mr. Das ko pakhre seta nahi se kouchandi actually. So you can read it aloud, Mr. Das, younger Mr. Das.
Sir, may I pray one thing, my lord? May I pray one thing, my lord? My lord, it is a question of transmission line and also getting.
No. Sir, your transmission line, whether you are nobody is allowing, disrupting your transmission.
That's
There
correct.
is no such order also.
No, if you
But
get
as far as
any,
the interim order is concerned, for till disposal of the FAO, it should continue.
if at all anything is there, my lord, what interim order he wants here? Interim order and read petition is the same, so he cannot get in interim order here, my lord. That's my humble submission.
Interim order se ethi magu nahanti.
Again. ନାଇଁ ଯଦି ମାଗୁନାହାନ୍ତି ତେବେ
interim order ଏଟାକୁ dispose of କରି ଦଉଛି actually.
ହଁ ଏଟାକୁ dispose of କରିଦିଅନ୍ତୁ.
That extending the interim order till disposal of the FAO.
ନାଇଁ
Because
this
is not an adjudication.
ସାର୍ ଆପଣ
ଚାହୁଁଛନ୍ତି instruction ନେବା ପାଇଁ ନିଅନ୍ତୁ, ଠିକ ଅଛି।
ସାର୍ ଇନଷ୍ଟ୍ରକ୍ସନ ନଉଛି ଆପଣ dispose of କରିଦିଅନ୍ତୁ, କିନ୍ତୁ distress ପାଖରେ ଯୋଉଟା
ଆପଣଙ୍କର district judge ଯଦି 90 days ରେ ଦେବେ ଏବଂ FAO ରେ ଆପଣଙ୍କର ସରିବନି, ତାହେଲେ interim order କାହିଁକି ହବ?
That's
who will
correct.
answer that? That High Court cannot answer also.
Sir, ଏଇଖିନି କଣ ହେଇଛି ନା ତାଙ୍କର
suppose today, just now the matter I was hearing, I will grant interim order for 15 days.
Sure.
But I will hear the matter on August 3rd of August, like I have directed. Suppose whoever bids. So passing interim order.
Sir, ସେ ଯୋଉଟା କହୁଛନ୍ତି ଯେ 90 days ପର୍ଯ୍ୟନ୍ତ status quo ଅଛି, that is also disputed question of fact. Sir, ମୁଁ କହିବା କଥା ଯେ
dispute କରୁଛନ୍ତି ଆପଣ?
That I have annexed. The status quo I have annexed.
Court order କେମିତି disputed ହବ? You may disbelieve it. That's a different thing. But court order, how can I say that it's a disputed question?
Sir, ମୋ ପାଖରେ ତ ନାହିଁ.
ସେଠି ଆପଣ କପି ଦେବେ ସେ।
Sir, more submission.
Mr. Sangat Das for the petitioner, Mr. Vijay Kumar Das, senior advocate, along with Mr. B. Das for the opposite party.
S.R. Das, Mr.
S.R. Das, Mr. S.R. Das for the opposite party. The petitioner before this court makes a limited prayer to the extent that the status quo order passed by the learned district judge Kedujar in FAO number 09 of 2025 dated kete Mr. Das, younger Mr. Das?
By the learned civil judge senior division. That interim order was passed by the learned civil judge senior division.
The interim order passed by the order of status quo.
Status quo, my lord.
Order of status quo passed by the learned civil judge senior division.
Annex 5, my lord.
Sorry, sir. Sir, see etra ko order.
Annex 6, sorry. Sorry, pardon, my lord.
See ko order against sir ethi ke ashchanti. He has come on which order?
Because court is not functioning. That is why I have come, because date has been fixed. Deliberately they have taken steps, my lord.
The civil judge senior division Kedujar in IA number 13 of 2023.
Yes, my lord.
Order dated 20/5/2025 लिखले.
Yes, my lord.
Directing status quo to be maintained.
Yes.
Will expire in 90 days.
Yes.
I mean, dispose of representation.
Whereas the matter is posted for arguments. FAO against FAO आपण फाइल करले ना से फाइल करथली.
We have filed, my lord. Because that was we have filed, my lord. 90 days पे देथिले तो सेते लेके we challenge that.
The challenging the tenor of order granting for status quo for 90 days during pendency of the matter. The FAO number 09 of 2025 has been filed before the learned district and the session learned district judge on the number set that?
My lord, FAO number
which is still pending.
Yes, please.
09 पर.
And date of hearing has been fixed to 27/6/2026.
9/6/26.
ठीक है ठीक देखियो 27/2024 it is submitted that in the internal if the interim order is not extended, interim order as continuing is not extended, the FAO shall be rendered infructuous.
Yes, sir. First it.
Also, the order, the adjudication before the Lord Civil Judge Senior Division will be frustrated.
Yes, sir.
So, in view of the limited nature of the Lord Counsel for the Lord Senior Counsel submits that he shall obtain instruction. The matter shall be listed in the for orders in the week commencing. It is 26/7 ରେ ଅଛି 27/6 ରେ ଅଛି ବହୁତ ଆଗକୁ ଅଛି
sir এটা 27/6 ରେ ଆସୁ sir ତାର ରିପ୍ରେଜେଣ୍ଟେସନ
the matter shall be listed in the week commencing 29/6/2024 before the assigned bench. The order of status quo shall continue till 6/7/2024.
କମିଶନ ସାର୍ ଅଛି ଆଉ ଟିକେ ସେଥିରେ ସାର୍ ସେ ଯୋଉଟା ଲର୍ନେଡ୍ ସିଭିଲ ଜଜ୍ ସିନିୟର ଡିଭିଜନ ଯୋଉ ଅର୍ଡରଟା ଦେଇଥିଲେ ସାର୍ ସେଥିରେ ରିପ୍ରେଜେଣ୍ଟେସନ ଟା ଡିସ୍ପୋଜ କରିବାକୁ ଦେଇଥିଲା ଆମେ ସାର୍ 18/6/2025 ରେ ସେ ରିପ୍ରେଜେଣ୍ଟେସନ ଟା ଅଲରେଡି ଡିସ୍ପୋଜ କରି ଯାଇଛି ସୋ ସେ ଇଣ୍ଟ୍ରିମ ଅର୍ଡର ଟା ଅଲରେଡି ମର୍ଜ କରିବ ସାର୍ ସେଇଟା ସେ ଆନେକ୍ସ କରିନାହାନ୍ତି
କରିଛି annex right that we have annex consciously we have annex my lord.
I don't know.
Mr. Das actually they have to brief nahi se bujhi na mu to brief
Yes, I will hand over within 2 days.
The both the cases are pending. Both the cases are
no, that's correct. No, both cases are pending.
So that is the short point I was trying to tell you that since it is pending, so no point in keeping this matter. Copy of the writ application along with annexes shall be served on the Instructing Counsel Mr. Isar Das within 2 working days.
Sir, a read the dispose of sir hela na royal sir eta puni.
Eta roya podibo nole apanଙ୍କର ମୁଁ ତ ଭାବୁଥିଲି ଡିସ୍ପୋଜ ଅଫ୍ କରିଦେବି ବୋଲି ଏଟା ରହୁ ଆପଣଙ୍କର ଏବଂ ମିଷ୍ଟର ଦାସଙ୍କର କିଛି
ନାଇଁ କିଛି ମୋର କିଛି ନାହିଁ ସାର୍ ଡିସ୍ପୋଜ ଅଫ୍ କରିଦିଅନ୍ତୁ ସାର୍
ଥାଉ ସତା ଆସିବ ସେ ଫାର୍ଷ୍ଟ ୱିକରେ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଯିବ ସାର୍ ଫାର୍ଷ୍ଟ ୱିକରେ ଆସିବ ରିଓପନିଂ ୱିକରେ ଆସିବ yes next item 24
urgent copy my lord website
copy issued as per rules
hello please
the parties shall have the liberty to act upon the copy of the order obtained from the official website of this court.
Much obliged.
जोटा प्रेयर करछन दैट हैज ऑलरेडी बीन इफेक्टेड कंस्ट्रक्शन विथ टावर हबा कता सरी जाई छै
सर स्टेटस कोड इज इन योर फेवर आल्सो exactly अपन झा करछन से रहिला सो दैट आई वाज नॉट टेलिंग मिस्टर दास अपन भाई ऑब्जेक्ट करछन स्टेटस को मु बुझी पाले से तो स्टेटस को
सर ट्रांसफर सर लाइन
पावर ड्रॉ करछंती सब करछन चालछि सेटा स्टेटस को हेगला यस मिस विश्वास
लाइन टा आस परिबन तो सिटे प्रॉब्लम होची सर
24 टाकू सिंपली अर्जन को पोस्टिंग अर्जन करबो तो मेमो देबे स्टेट करो पर ऑर्डर करो नांती ना यस 25 देखंतु
25 मे प्रेजलर
कृष्णचंद्र रथ फॉर द पिटिशनर
25 27 28 29 पांचटा सेम
आउथरे कोंतु 25
30
25 27 देन
25 27 my lord 28 29
हां
and 30 same similar my lord
okay 25 कोंतु प्लीज
my lord
we are now taking up WPC 17396 hella 25 Mr. Sachidananda Naik is there or Mr.
my lord
Sachidananda Naik Krishnachandra Ratha for the petitioner Mr. Sachidananda Naik additional standing counsel for the opposite party yes
मैलड माने छोट छोट दुकान करछन 150 स्क्वायर फुट रे तांकर सब दुकान छोट छोट हेची वर्तमान कथा होची रिवीजन केस रे हम रिवीजन फाइल करथुलु कलेक्टर पाखरे कलेक्टर लर्न कलेक्टर हमर रिवीजन कथा सुनिलेनी एक्चुअली हमर टेंडर रास्ता बढ़ा हले से फ्यूचर प्रोजेक्ट में रखि जंती फ्यूचर प्रोजेक्ट हेले से माने हमर घरडा भांगिया कथा हम दुकान सब आ बर्तमान आमे भी सेया चाहूँ जदि से फ्यूचर प्रोजेक्ट हुए आमे पळे जो कि टिल देना हमको सेटा गुटे ये दिया जाय बर्तमान गरीब लोक से माने छोट छोट
गरीब लोकंकर राइट टू एनक्रोचमेंट ऑफ पब्लिक प्रॉपर्टी एटा कोठी एटा गुटे बहुत इवॉल्विंग
कॉन्सेप्ट आमे सेमति करिया चाहूनो रास्ता बहुत एरिया अछि
एटा आपण जेतेटा एक्सीडेंट हेची सेते एनक्रोचमेंट ପାଇଁ କିଛି दायी नुह
सेटा सर सेटा जे ठीक कथा किंतु एठी जो रास्ता रा मजे फोटो उठेची
विथ ए पिंच ऑफ सॉल्ट
ଆପଣ ଆପଣ ପବ୍ଲିକ ରୋଡ ଏନକ୍ରୋଚମେଣ୍ଟ କରିବା ପାଇଁ ଯୋଉ ଗରିବ ଲୋକଙ୍କର ଆପଣ କହୁଛନ୍ତି ସେଟା କେମିତି ହବ?
ନାଇଁ ପବ୍ଲିକ ରୋଡ ରେ ଏନକ୍ରୋଚ କରନୁ ମାନେ ପବ୍ଲିକ ରୋଡ ରୁ ଯେତିକି ରାସ୍ତା ସରିଲା ପରେ ଲାଷ୍ଟ ଯୋଉ ଟିକେ ରାସ୍ତା ଅଛି
ଖୋଲା ପଡିଆରେ
ଟିକେ ଖାଲି
ଏନକ୍ରୋଚ କରୁନାହାନ୍ତି।
ଛୋଟ ହଁ ସେ ଖୋଲାରେ କରାହେଇଛି ରୋଡ
ଆକ୍ସିଡେଣ୍ଟ ହବ, କଂଜେସନ ହବ। ଆଚ୍ଛା
ରୋଡ
ରାସ୍ତାରେ ଯୋଉମାନେ ଯାଉଛନ୍ତି ସେମାନେ ପବ୍ଲିକ ନା ନାଇଁ ପବ୍ଲିକ ନୁହଁ?
ପବ୍ଲିକ।
ତାଙ୍କ ରାଇଟ ଟା କିଏ ନବ, କିଏ ଏଷ୍ଟାବ୍ଲିଶ କରିବ? Who will establish ଆପଣଙ୍କ right to earn your livelihood by encroachment?
ରାସ୍ତାକୁ ଛାଡିକି ସେମାନେ
right
କରୁଛନ୍ତି।
for free access is also guaranteed.
ରାସ୍ତା ମେନ୍ ରାସ୍ତାର ମାଇଲଡ ଛାଡିକି ସେମାନେ ସେପଟୁ
Serious accidents are occurring due to encroachment. Serious fatal accidents.
ସେଟା ଠିକ କଥା ଆମର ମାନେ ରାସ୍ତା ବଢା ହେଲେ ବାହାର କରିଦେବେ କିନ୍ତୁ ଏ ତ ଦୂରେଇକି ଅଛି ମାନେ ଅନ୍ୟମାନେ ବି 70ଟା ଦୋକାନ।
ଆଜ୍ଞା ଦୂରେଇକି ରହିବାର କିଛି ନଥାଏ, ଦୂର ପାଖର କିଛି ଡେଫିନେସନ ଅଛି?
ନାଇଁ ରାସ୍ତା ପାଖ ନାହିଁ, ରାସ୍ତା ଛାଡିକି
କ୍ଲିୟର ଷ୍ଟ୍ରାଟେଜି ଯେ ଆପଣଙ୍କର ଯଦି କିଛି ରାଇଟ ଅଛି ଦୋକାନ କରିବା ପାଇଁ ସେ ରାଇଟ କୁ ପର୍ସୁ କରନ୍ତୁ, ଯୋଉଠି ଦୋକାନ କରିବା କଥା କରନ୍ତୁ, କିନ୍ତୁ ରାସ୍ତା ଏନକ୍ରୋଚମେଣ୍ଟ କରିବା ଆପଣଙ୍କର କୌଣସି ରାଇଟ ନାହିଁ ଯେ ବିକଜ ଆପଣ ଗରିବ ଲୋକ।
କିସମଟା ରାସ୍ତା ଅଛି ମାଇଲଡ, କିସମଟା ରାସ୍ତା ଅଛି କିନ୍ତୁ ରାସ୍ତା ପାଖରେ କରାହେଇନି, ରାସ୍ତାକୁ ଛାଡିକି
ଯୋଉଟା କିସମ ରାସ୍ତା ଅଛି ସେଟା ହିଁ ରାସ୍ତା, ଆଉ ତାଠୁ ଅଧିକ ମୁଁ ହାଇକୋର୍ଟ କହିବେ ଯେ କିସମ ଥିଲେ ବି ହବ, କ୍ୟାନ୍ ଆଇ ଡୁ ଦ୍ୟାଟ୍?
କିନ୍ତୁ ମୁଁ ଚାହୁଁଛି ଗରିବ ଲୋକ
କିସମ ରାସ୍ତା ଇଟ୍ ଲୁକ୍ସ ଲାଇକ ପଡିଆ।
ଛୋଟ 100-150 ମାନେ ସ୍କୋୟାର ଫୁଟରେ ସେମାନେ ଘର କରୁଛନ୍ତି।
ରାସ୍ତାରେ ଶୁଣନ୍ତୁ ଆଜ୍ଞା, ଆପଣ ଯଦି ରାସ୍ତାଟା ଏଠି 5 ଫୁଟିଆ ରାସ୍ତାରେ ଆପଣ 150 ଫୁଟର ଘର କରିବେ କେମିତି ହବ? 10 ଫୁଟିଆ ରାସ୍ତାରେ କରିବେ। You must understand.
ମୁଁ ଫଟୋ ଉଠିକି ଆଣିଛି, ଆକ୍ଚୁଆଲି ବହୁତ ଛଡା ହେଇକି ହେଇଛି।
ଆମର we have a different look towards our public life. We don't owe any responsibility to anyone. ଆପଣଙ୍କର ଯୋଉଟା ରାଇଟ ଅଛି that militates against public right to use the road also.
ସେଟା ଆଜ୍ଞା 70ଟା ଦୋକାନ ସେଇ ସିଧାରେ ବି ଅଛି, ସେମାନେ ସାଇଡ ରେ ସେମାନଙ୍କୁ କାହା କିଛି କରିନାହାନ୍ତି, କିନ୍ତୁ ଆମରି 5ଟା ଦୋକାନ ଆଜ୍ଞା ଏମିତି କରୁଛନ୍ତି। ଆମର
ଏଠିରେ ଆପଣଙ୍କ ରାଇଟ ଏଗେନ୍ଷ୍ଟ ଇଲିଗାଲିଟି କଣ ଅଛି କି? ରାଇଟ ଇନ୍ ଇଲିଗାଲିଟି
ଏଇଟା କିଛି ନାହିଁ। ରାସ୍ତା ବଢିଲେ ଯଦି ଟେଣ୍ଡର କରାଯିବ ଆଜ୍ଞା, ଟେଣ୍ଡର ଯଦି ମାନେ ଇଏ ହବ ଆମେ ତାଙ୍କୁ ଛାଡିଦବୁ, କିଛି ଅସୁବିଧା ନାହିଁ, କିନ୍ତୁ କଥା ହଉଛି ଟିଲ୍ ଡେଟ୍ ଖାଲି ରହୁ ଟିକେ
without instruction I cannot.
ମାଇ ଲର୍ଡ
ଆପଣଙ୍କର କୋଉ ଅର୍ଡର ଏଗେନ୍ଷ୍ଟ ଆସିଛନ୍ତି ଦେଖାନ୍ତୁ ଆଗ।
ମୁଁ ଆଜ୍ଞା ରିଭିଜନ ଅର୍ଡରରେ ଆସିଛି, ମାନେ ରିଭିଜନ ଅର୍ଡର କିନ୍ତୁ ଟେକ୍ନିକାଲ ଲାଗେ।
ଇନପୁଟ ଅର୍ଡର ଦେଖାନ୍ତୁ।
ଅର୍ଡର ମାଇ ଲର୍ଡ କାଇଣ୍ଡଲି ସି ଆନେକ୍ସଚର 2 ପେଜ 22।
ଆପଣ 15 ଦିନରେ ଛାଡିକି ଯିବେ କି?
ଆଜ୍ଞା
ସେତିକି ଆପଣଙ୍କ ପାଇଁ କରିପାରିବେ। ଆପଣ 15 ଦିନ ଦିଆହବ, ଆପଣ ଛାଡିକି ଯିବେ ନା ସେମାନେ ପୁରା ହୋଲସେଲ ଭାଙ୍ଗିଦେବେ? ସେମାନେ ଯେତେବେଳେ ମେସିନ ନେଇକି ଭାଙ୍ଗୁଛନ୍ତି, ଆପଣଙ୍କର ଏସି, ଫ୍ରିଜ, ୱାସିଂ ମେସିନ, କୁଲର ସବୁ ଭାଙ୍ଗି ଯାଉଛି ତା ସାଙ୍ଗରେ। ଆପଣ ଭୁବନେଶ୍ୱରରେ ଦେଖିବେ ସେ ଭାଙ୍ଗି ପକେଇଲେ ତା ଭିତରୁ ମାନେ ଆପଣଙ୍କର ଅଲ୍ ମାନେ ସୋଫା ସେଟ୍, ୱାସିଂ ମେସିନ ଇଏ ତା ସହିତ ଭାଙ୍ଗିଗଲା। ସେମିତି ଆପଣ କେତେ ଦିନରେ ଉଠେଇବେ କହିଲେ?
ମାସେ ଟାଇମ ଦେଇଥାନ୍ତୁ। ମୁଁ
କଣ ଫେରେ ଆପଣ ପ୍ୟାଲେସ ତିଆରି କରିବେ? ମାସେ ଟାଇମ ଦେଲେ ସେଠି ପ୍ୟାଲେସ ତିଆରି କରିବେ ନା କଣ?
ନାଇଁ ପ୍ୟାଲେସ ନୁହେଁ, ଆମେ ଗୋଟେ କୋଉଠି ରିହାବିଲିଟେସନ ହବୁ, ଆଉ କଣ ଛୋଟ ଦୋକାନଟେ କରୁଛୁ।
ଶୁଣନ୍ତୁ ଆପଣଙ୍କର କର୍ତ୍ତବ୍ୟ ହଉଛି ଯେ ସେ ଯୋଉ କେସରେ କିଛି ମାନେ ନାହିଁ ଆପଣ ତାଙ୍କୁ ବୁଝେଇବେ ଯେ ଯେତିକି ସମୟ ଦିଆ ହଉଛି ଆପଣଙ୍କର ଭଲରେ ଯାଇକି କୋଉଠି ଦୋକାନ କରନ୍ତୁ। ସେ ରାଇଟଟା ଆପଣ ଏଷ୍ଟାବ୍ଲିଶ କରନ୍ତୁ ଯେ ଆଜ୍ଞା ମୋର ଗୋଟେ ଦୋକାନ ଅଛି, ମୋର ରିହାବିଲିଟେସନ ଦୋକାନ ଅଛି, ଷ୍ଟ୍ରିଟ୍ ଭେଣ୍ଡର ହ୍ୱାଟଏଭର, ବଟ୍ ତା ମାନେ ନୁହଁ ଯେ ଦ୍ୟାଟ୍ ଏକ୍ସଟେଣ୍ଡସ୍ ଟୁ ଏନକ୍ରୋଚିଂ ପବ୍ଲିକ ରୋଡ।
ନାଇଁ ନାଇଁ ଠିକ କଥା, ଯୋଉ ମାନେ ଆମେ ମାନୁଛୁ ଆକ୍ଚୁଆଲି ଏଟା ବାହାରି ଯିବ ଆଜ୍ଞା। ପେଜ 22 ମାଇ ଲର୍ଡ, ଆନେକ୍ସଚର 2 22. The petitioner Prashant Kumar Sahu has been in possession of 10x15 150 square foot. ମାନେ
କୋଉ ଜାଗାରେ ପଡୁଛି?
Operative person 23 orders में
23 ରେ
orders person
23
ରେ orders ଅଛି।
It was held that land is recorded on a जिला परिषद खाता classified as रास्ता. This is ଆପଣଙ୍କର village road କୋଉଠି 6 lane, village road କୋଉଠି 5 lane 4 lane ଅଛି। ଆପଣ village road encroach କରିବେ କହିବେ fundamental right to life।
ଭିଲେଜ ରୋଡ ନୁହେଁ, ଏଟା ହଉଛି ମେନ୍ ରୋଡ, ମାନେ ଧାମରା ରାସ୍ତା ଯୋଉଟା ଯାଇଛି।
ଜିଲ୍ଲା ପରିଷଦ ଆଜ୍ଞା କୋଉଠି ସେଠି ଆସିବ? ଧାମରାରେ ଜିଲ୍ଲା ପରିଷଦ ରାସ୍ତା କୋଉଠୁ ଆସିବ? ଆପଣ ସେ ଜାଗାକୁ ତ ବିଲଙ୍ଗ କରନ୍ତିନି।
ସେଟା ହଉଛି ଇଏ ରାସ୍ତା, ସେ ଯୋଉ ଜିଲ୍ଲା ପରିଷଦ ରାସ୍ତା, ରେକର୍ଡେଡ ଅଣ୍ଡର ଜିଲ୍ଲା ପରିଷଦ ରାସ୍ତା ମାନେ ଭଦ୍ରକ। এটা লেখা হয়েছে the তহসিলদার observed that the land being classified as রাস্তা
is objectionable nature, cannot be settled in favor of the petitioner,
never be settled.
and must be protected for the public use and future government project.
Mr. Ratha, nowadays cows are not there. Still, Gochara cannot be. Jolasai is not there. Rasta cannot be. Rasta enforcement cannot be protected by any law.
ଆମକୁ କିଛି ଦିନ ଦିଆଯାଉ କେବଳ ସେଟଲ କରିବା ପାଇଁ ଏତିକି
ରିପିଟେସନ ପ୍ରେୟାର ହିଁ ନାହିଁ. So I have been asking you that only. ଆପଣ ସେଟା ପର୍ସୁ କରିବେ, that's a different thing.
ଇଏ ମିସକେସ୍ ଟେ ଫାଇଲ କରିଛି.
ଆପଣ ଆଜି ଅଣ୍ଡରଟେକିଂ ଦେବେ କି ଚାଲିଯିବେ ବୋଲି, ନହେଲେ ଆର୍ଜନ କରିଦିଅନ୍ତୁ.
ମାସେ ଟାଇମ ଦେଇଥାନ୍ତୁ, ମାସେ ଭିତରେ
ମେମୋ ଦିଅନ୍ତୁ.
ଅଣ୍ଡରଟେକିଂ ଦିଅନ୍ତୁ, ମାସେ ଭିତରେ ଅଣ୍ଡରଟେକିଂ ସେଇଟା ଗୋଟେ ମାସ ଟାଇମ ଦେଇଥାନ୍ତୁ.
ସେଇଟା ଆପଣ ଦିଅନ୍ତୁ, ଆପଣ ଗୋଟେ ମାସ ଟାଇମ ଦିଆଯିବ. ଦେନ୍ ଆଇ ୱିଲ୍ ଡାଇରେକ୍ଟ. କାହିଁକିନା ଆପଣଙ୍କର ସେ ଅର୍ଡର ହେଲାଣି,
ଟେଣ୍ଡରଟା ବାହାରିଲେ ଆମେ ପଳେଇଯିବୁ, କଣ ଅସୁବିଧା? ଟେଣ୍ଡରଟା
ସେ ସବୁ ନାହିଁ, ଆର୍ଜନ କରିଦିଅନ୍ତୁ.
ଲେଖିଦଉଛି
ଆପଣ ମେମୋ ଦିଅନ୍ତୁ, ମେମୋ କପି ସର୍ଭ କରନ୍ତୁ, ଏଟା ଆସିବ, ମେମୋ ଦେଇଦିଅନ୍ତୁ, ଏଟାକୁ ସେଇଦିନ ଅର୍ଡର କରିଦେବି, ନେକ୍ସଟ 5 ତାରିଖ ଦିନ. ଆପଣଙ୍କର ଏଟା ଅର୍ଡରଟା ହଉଛି 20 ଫେବୃଆରୀର. ଏଠାରେ ଆକ୍ଚୁଆଲି ଛୁଟିରେ ଲିଷ୍ଟ ହବା କଥା ନୁହଁ. ଆପଣ କେବେ ରିଟ୍ ଫାଇଲ କଲେ କି?
ଏଇଟା ଫାଇଲ କଲି ମାଇ ଲର୍ଡ ପହର ଦିନ, ମାନେ
20 ଫେବୃଆରୀ 2026, 4 ମାସ ହେଇଗଲାଣି, 3 ମାସ ହେଇଗଲାଣି.
ଗରିବ ଲୋକ, ସେମାନେ ପଇସା ପତ୍ର ନାହିଁ.
ଗରିବ ଲୋକଙ୍କର ରାଇଟ ଟୁ ଏନକ୍ରୋଚ ପବ୍ଲିକ ରୋଡ, ଭିଲେଜ ରୋଡ ଆଜ୍ଞା ସେଠି ନାହିଁ.
ଏଇଟା ଠିକ କଥା. ଆକ୍ଚୁଆଲି ଏ ଛୋଟ ଛୋଟ ଦୋକାନ କରୁଛନ୍ତି, ଏମାନେ କିଛି ଏମାନଙ୍କୁ ଆଜ ଚାହିଁଲେ ବି କାଲି ଉଠେଇବ.
କିଛି ନ କଲେ ବି ତ କଣ ଏନକ୍ରୋଚ କରିବେ ନା?
ଘର ତ କରିନାହାନ୍ତି ନା, ଖାଲି ଦୋକାନ
ଦୋକାନ କରୁନାହାନ୍ତି. ଅନ୍ୟ ବଦାନ୍ୟ ଲୋକ ଅଛନ୍ତି, ତାଙ୍କ ଜାଗାରେ କରୁନାହାନ୍ତି, ପ୍ରାଇଭେଟ ଜାଗାରେ ଭଡା ନଉନାହାନ୍ତି.
ସେଟା ସେମାନେ
ରାସ୍ତା ସାରା ଆଜ୍ଞା ପ୍ରାଇଭେଟ ରୋଡ ଅଛି.
ରାସ୍ତା ବଢେଇଲା ବେଳେ ବି ଏମାନେ ଇଏ ମାନେ ଜାଗା ଇଏ କରୁନାହାନ୍ତି.
There is absolutely there is no concept of encroachment of public road for ଗରିବ ଲୋକ. ପବ୍ଲିକ ରାସ୍ତା କିସମ ରାସ୍ତା ଆପଣ କହୁଛନ୍ତି, ଗରିବ ଲୋକ ତାକୁ ଏନକ୍ରୋଚ କରି ଛୋଟ ଜାଗା. ଆପଣ ରାସ୍ତା କରରେ ଯୋଉ ପ୍ରାଇଭେଟ ଜାଗା ଅଛି, ତାଙ୍କଠୁ ଘର ନେଇ କରନ୍ତୁ.
ଛୋଟ ଛୋଟ ଦୋକାନ କରୁଛନ୍ତି,
ଆହୁରି ଛୋଟ ଛୋଟ ଦୋକାନ କରନ୍ତୁ ତାଙ୍କ ପାଖରେ, କଣ ଅଛି କି?
ଆଉ ରାସ୍ତା ବି ବହୁତ ଫ୍ରି ଅଛି, ମାନେ ତାଙ୍କ ପାଖାପାଖି ଲାଗିନି.
One of the honorable division benches I was appearing said in court, ଆପଣ ଘରେ କରୁନାହାନ୍ତି, ପବ୍ଲିକ ଡିଟି କୁ କାହିଁ ରାସ୍ତାରେ ନେଇ ବସଉଛନ୍ତି? ଆପଣ ପ୍ରାଇଭେଟ ଲ୍ୟାଣ୍ଡ ରେ କରନ୍ତୁ ଦୋକାନ.
ସେଇଠି ଆଜ୍ଞା ଗୋଟେ ଧର
ମାଇଣ୍ଡ ମେକଅପ୍ କରନ୍ତୁ, ଯଦି ଆପଣ ଦେବେ ଅଣ୍ଡରଟେକିଂ, ଦେଖିକି ଦିଅନ୍ତୁ ମେମୋ, it will be taken up on 5th. ସେଠି ଗୁଡାକ 25, 27, 28, 29, 30.
ଆଜ୍ଞା
ଲେଖନ୍ତୁ,
ମୁଁ ବର୍ତ୍ତମାନ ଦେଇଦଉଛି, ବର୍ତ୍ତମାନ ଦେଇଦଉଛି ମେମୋଟା.
You will not encroach the public road, and within 1 month you will leave. ଆମର ଗୋଟେ କଲଚରାଲ ଗୋଟେ ଡିଫର୍ମିଟି ହେଇଗଲାଣି ରାସ୍ତା ଏନକ୍ରୋଚ କରିବା. ଜେନେରାଲ ଆଟିଚ୍ୟୁଡ ହେଲା ଯେ ଆମେ ରାସ୍ତାରେ କରିବା, ସେଟା ଆମର ଗୋଟେ ଆକ୍ଚୁଆଲି ବିକଜ वी आर सो एंड सो କଣ ତାର ଅଛି? ଆପଣ ପ୍ରାଇଭେଟ ଜାଗାରେ କରନ୍ତୁ,
କିଛି ଆଜ୍ଞା କିଛି ବି ଲାଭ ହଉଛି, କାହିଁକି କହିଲେ ଗାଡିଟା ଖରାପ ହେଇଗଲେ ବି ଯଦି ଗୋଟେ ଦୋକାନ ହେଇଛି ପମ୍ପଚର, ଆମେ ଇଏଟା ଦେଇପାରୁଛୁ. ମାନେ
ସେ ଯୋଉ ପମ୍ପଚର କରୁଛନ୍ତି ଯୋଉଟା, ସେଟା ଆପଣ ପ୍ରାଇଭେଟ ଲ୍ୟାଣ୍ଡ ରେ ଦୋକାନଟା କରିବେ.
ସେଠି ଆଜ୍ଞା
ଆପଣ ରାସ୍ତାରେ ଯୋଉ ଅକୁପାଇ କରୁଛନ୍ତି, ସେ ରାସ୍ତାରେ ଯୋଉ ଆକ୍ସିଡେଣ୍ଟ ହେଲା, you are not taking that responsibility.
ଆଜ୍ଞା ଠିକ
ଆପଣ କେବେ ଯାଆନ୍ତୁ, go to villages, how the land has been, the roads have been misutilized. This is more kind of মানে the petitioner before this court. The petitioner before this court is encroacher of rasta, land kisama rasta. After the collector has passed order, Collector Bhadrak has passed order in OPL revision case number 05 of 2026, confirming the order of the sub-collector, dismissing appeal, confirming order of the sub-collector dated 17/10/2025, dismissing the appeal filed by the petitioner against order of the Tahsildar Vasudevpur dated 17/6/2025
in encroachment case number 90 of 2025-26. Stop.
Well,
Considering the land encroached by the petitioner is of the Kisama Rasta into court. Bracket road is recorded in the name of Jilla Parishad Bhadrak. It is submitted by the petitioner that the petitioner is a poor person and he has constructed shop, generator shop on a land of by encroaching land, by encroaching the road 10 foot into 15 foot to brackets 150 square feet, corresponding to plot number 998, खाता number 343, Moja Naikonidhi. Having gone through the materials available on record, the order of the Tahsildar, confirmed and appealed by the sub-collector, and order of the collector in revision, confirming the order, appellate order of the sub-collector. This court finds no merits in the contention of the petitioner as to his right to occupy and encroach public land, that is road. The right of citizen at large to use a public road without being hindered by any obstruction is also a right that militates against petitioner's right to encroach a public road, maybe for the purpose of earning his livelihood by opening a shop. The petitioner is well within his rights to open his shop at any place other than a road. If he is entitled for any settlement of land, he can approach the authority for settlement of land. If he is entitled for any benefit under any resettlement scheme for evicted shop owners, he is well within his right to apply for the same. But at no stretch of imagination, it can be said that the authorities cannot evict encroachment from public road. Stop. At this stage, the petitioner files memo stating that the learned counsel for the petitioner files memo upon instruction received, stating that the petitioners giving some time shall remove their encroachment and no coercive action may be taken such as demolition till the said date. Para. Memo कौन लिख ले देले मिस्टर? आपण मेमो कॉपी देले?
देना एक दी
आपण 7:20 हेलाणी आपण देरी करछन्ती
गोटे सेकंड
कि आपण केबे छाडी बोली कहले?
दी मास टाइम देबे
2 मास टाइम आपण फेब्रुआरी रु बसछन्ती आए फेब्रुआरी रु सिटी बसछन्ती से ऑर्डर हेलाणी 25 वर्ष रु वर्ष हे गेलाणी से रास्ता होई परिबनी
नहीं रास्ता एबे नाही सेठी माने से कोजन फ्यूचर जो रास्ता हुए सेटा दरकार हो
नाही कि रास्ता
लेखि दे ऑर्डर
आया कि कटक रे जो जगन्नाथ सड़क थिला सेटा वर्तमान गोटे बड़ हाईवे हिची सेते कोन अछि कि अब शेरशाह सूरी जोटा करतले वर्तमान NH 16
अगर फ्यूचर प्रोजेक्ट को लक्ष्य करी कि करछन
दे आर नॉट टेनेबल आर्गुमेंट्स कोठी कोन खाली जगह अपन अन्य जगह जे रहनांती the petitioners shall as stated in the memo, the petitioners undertake to remove the encroachment by by 17 July 2026. The said undertaking shall be filed before the Tahsildar, before the collector as well as the sub-collector. Stop. Along with copy of this order. Upon filing of the undertaking along with copy of this order, the petitioner shall not be evicted till till 17 not be erected till 17/7/2026. If the petitioner failed to file such undertaking before the authority, this order shall not be given effect to. The order passed by the Tahsildar, confirmed by the appellate authority, and also confirmed by the revisional authority shall be given effect to. Yes. सतर चार्टा कर दियंतु नले 24 ठीक
नेक्स्ट
25 रे किए मिस्टर 25 रे किए अपेयर करछन
स्टेट काउंसिल सचिदानंद नायक
एसएन नायक
25 मोर 27
27-28 रे एसके ब्रह्म एसी
ब्रह्म ना ब्रह्मा
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 29-30 माइलर माइसेल्फ
29-30 आपण
माइलर
yes 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 so SN Naik AC
yeah
Mr. Brahma also AC on 33 से G
नहीं yes मैडम
AC yes से आपण ना लिखछु त नाटा कहि दियो राइटिंग योर नेम
अक्षय कुमार पति
Mr. Akshay Kumar Pati is. Yes, next. 31.
When item 26, my lord, I am there in item 26, my lord.
Sorry.
May I please your lordship? My lord, item 31.
My lord, item 26, my lord.
से जो इकट्ठी टेक ऑफ हेगला सी लॉस्ट द कार ट्रैक 26
Item 26. My lord, I am here for the petitioner, my lord. The husband has approached this honorable
Mr. Vanshidhar Bag for a senior advocate along with Mr. Vijay Kumar Mishra for the petitioner. Yes, he is Mr. Bag.
Yes, my lord. My lord, here the husband is the petitioner. He has approached your lordship in this writ petition because of the ensuing summer vacation. The family court at Baripada is closed for interim custody of his minor daughter. My lord, the fact of the case is like this, my lord. The marriage between the petitioner and the opposite party number 3 took place in July 2016.
So I am issuing notice and pendency of this, but I have verified Mr. Bag for treatment and other. It is available.
My lord, only for that purpose of interim custody.
No, the court is available. The court. So because you see, because this is this problem at Baripada may happen in Baleswar and Cuttack also.
In Baripada, my instruction is they have entered into, but it is closed. They are not entertaining any civil matter, my lord.
No, they are not. You are right. But when there is an interim prayer like treatment and all that, they are. Because today somebody said injunction is not entertained in Cuttack. Can it be possible?
My lord, only
so anyway, you take notice and this pendency shall not be barred for filing of a custody application.
My lord, your lordship can for a moment.
And who will contact them? The child is
the local police station, my lord. That will be better, my lord. My lord, your lordship can for a moment, my lord. Your lordship may kindly see annex.
So you take without noticing the mother. Can order be passed?
My lord, no, I am not taking interim custody, my lord. Your lordship is right, my lord.
I understand that.
But for the treatment, my lord,
first of all, this should have been a habeas corpus. This cannot be a single bench matter.
No, my lord, not on habeas. That time I have not styled as habeas corpus. Mother has the right, my lord. Mother has the right, my lord. My lord, your lordship appreciate
it can be. It has to be a division bench. But anyway, since the WPC is there, I am issuing notice. take notice.
My lord, you also make appreciate for a moment, my lord. So for the interim custody.
Since we are running, so we are really behind the schedule. We have to conclude.
No, my lord, only 2 minutes, my lord.
Yes,
the
yes.
Direct, the wife will come to the police station and there she will accompany me to Utkal Hospital, Bhubaneswar for the treatment. And then she will take away. That, my lord.
That without hearing them, I will not die.
Then everything will become
it is as good as allowing the application.
My lord.
And always custody application.
My lord, I am not taking custody, my lord. Only for the treatment, my lord.
Mr. Bagh, this prayer has to be made before the custody court, not the High Court. That I was telling you.
Then your lordship direct the family court to entertain, my lord.
No, unless you file that, how do I know? Unless you file that, because
file,
this kind of applications,
within a week, we will file.
Yes.
Then you will entertain.
Pendency will not be a bar. Pendency will not be a bar to file custody. That I will clarify.
Yes, my lord. Yes.
The petitioner is before this court seeking under Article 226 and 227 of the Constitution of India with the following prayer. The petitioner is the father of the minor child. Is it minor daughter? Is aged about 4 years.
4.5 years.
4.5 years, who is also arraigned as opposite party, represented through her mother guardian. As has been disclosed in the application, the minor child requires is under continuous medical treatment, care and supervision at hospital at Bhubaneswar. Copy of the treatment records, such as prescription and other investigations, have been annexed to the writ application as Annexure 2 series. The petitioner father is apprehending that the minor daughter staying with her mother, the mother having the custody, and both the mother and child staying at the court road this semana.
Staying
with the maternal home of the mother. That is
village,
at the in-laws place of the petitioner.
Yes.
It is submitted that the father of the petitioner, the father of the minor child, is very much apprehensive that if if proper medical care is not provided to the minor child, she will suffer further complications, and for the purpose of treatment, she should be brought to the hospital at Bhubaneswar. The prayer made and the tenor of the application makes it apparent that the petition is for the custody of the minor child by the father. The learned senior counsel fairly submits that the petitioner is in custody, the minor child is in custody of the natural guardian, that is mother. However, he highlights the medical condition of the child for which the petition has been filed. In considered view of this court, the appropriate application should have been filed before the court having jurisdiction to decide the custody, which could have granted which could have passed further orders, granted further interim reliefs regarding treatment of the child. It is submitted by the learned senior advocate that the learned court at Baripada, learned family court Baripada, having jurisdiction. Family court Baripada is not during vacation, is not available to be moved. On being asked whether the petitioner has moved any application stating these facts, the learned senior counsel fairly submits that though the petitioner has not moved, but he can move within a week.
My lord, yes.
Within a week. So in this application, notice need not be issued, you are saying?
Not necessarily. It may be disposed of. Yes, my lord. It may be disposed of.
Okay. The what like or it should lie over.
No, my lord, dispose of it. Set it up. Approach karibo kahin rahi bathi aga.
Stating the facts, International Council, there seems therefore
has not moved, but he shall move the appropriate court within 7 working days or 10 working days. Within 10 working days. In considered opinion of this court, if any such urgency is brought to the notice of the learned court in learned family court, learned court in season of the matter, the learned judge in charge of family court along with copy of this order, the matter shall be dealt with in the proper perspective in accordance with law.
My lord, yes.
It is further submitted by the learned counsel for the. It is further submitted by the learned senior counsel that the petitioner will not praise the present writ application in its present form.
My lord.
Accordingly, the writ application is disposed of with the aforesaid observations.
My lord, yes, urgent copy, my lord.
Urgent certified copy as per rules, the parties shall have the liberty to act upon the copy of the order obtained from the official website of this court.
My lord.
But since it is already so late, it will take some time. Maybe
yes,
2 days.
Yes, my lord. Tomorrow, let it be tomorrow, my lord. No problem.
2 days have to be granted to. Yes, next. Item 31.
May I please, your lordship? My lord, one eviction notice was issued in favor of the father of the petitioner by the annexure 4, page 19.
So
and I had my lord. Thereafter,
31, Mr. Sachidananda Naik.
I am
Mr.
here.
Siddhartha Das.
My lord, I am here.
31, Mr. Siddhartha Prasad Das, Additional Standing Counsel for the opposite party. Yes, Mr. Mishra.
Yes. After obtaining that notice, I had approached before your lordship, and your lordship disposed of the writ petition by the annexure 5, running page 22, with a direction to the Tahsildar, grant due opportunity of hearing to the petitioner and take decision in accordance with the law within a period of 6 weeks from the date of receipt of the certified copy of this order. Thereafter, I filed the same by the annexure 6 on 2nd March 2026. Yes. Thereafter, lordship, opposite party number 3, Tahsildar had issued notice, and I had also appeared.
Yes.
Thereafter, during the pendency of that petition, now he has sent a letter to the learned sub-collector by the annexure 8, page 28, that the eviction date has been fixed to 5th June 2026 and requested to deploy the adequate police personnel and executive magistrate.
Notice देखो appearance date थिला 27/2/26 रे.
My lord.
बुझिले?
My lord.
आपनकर 2/4 रे आपन appearance थिला.
My lord.
Eviction अछि 26/5 ता भीतर order हेतिबो आपन सेटा चैलेंज करिवे ना.
My lord, that order has not
सेटा को आपन appeal रे चैलेंज करिवे.
My lord, the order has not been.
आपन केदिन appeal file करिवे.
Appeal file करिवे हजुर जति subject to एटा lordship dispose of हेजे.
कोंतुनी आपन appeal file करिवे कि नै first of all.
Yes, my lord, that is statutory. My lord.
केदिन appeal file करिवे.
1 week time.
आपन को दिया गला 15 working days पूरा. 2 weeks नियंतु appeal file करंतु. तार से पर्यंत evict हेबेनी और status को as on date. जदि evict हे जेते हम कहि परिबिनी.
No, I will file
because you must understand the learned state council doesn't have instruction, so he cannot assist me. You cannot assist me because you do not disclose the present status.
No, yes, ma'am.
So the petitioner had learned counsel for the petitioner. The learned counsel for the petitioner refers to the earlier order dated 27/2/2026, passed in WPC number 6052 of 2026. By the coordinate bench, wherein the the petitioner, the coordinate bench had directed the Tahsildar to undertake the proceeding under the OPLE Act, 1972, after issuance of notice to the petitioner and after hearing him. It is submitted that, as directed by this court, the petitioner was issued notice dated 23/2026. He submitted that during pendency of the proceeding before the Tahsildar, OPLE case number 92 of Gudie number during the order during pendency of the proceeding before the Tahsildar has written a letter to the higher authority, that is Sub Collector and Sub Regional Magistrate Puri, dated 26/5/2026, that the encroacher from the government land in OPLE case number 92 of 2022, 92 of 2022 shall be removed on 5/6/2026.
Right.
Though there is nothing on record, to show that to suggest that the OPLE case in which the petitioner is a party is still incomplete. But it is submitted by the Learned Counsel for the petitioner that as per his instruction, the OPLE case is still pending. In view of these submissions, in view of the submissions made at the bar, it is directed that the petitioner, if so advised, shall approach the higher authority in appeal against the order, if any, passed against him in the OPLE case. The appeal shall be filed within 15 working days, along with an application for interim order if sought for. Along with the application for interim order that may be sought for. Stop. Accordingly, the petitioner the petitioner shall file his appeal by 19/6/2026, which shall be taken up by the authority in accordance with law. During pendency of the appeal, the authority shall do well to consider the application for interim order and pass orders in accordance with law. Status quo as on date regarding nature, character, ownership and possession of the land in question in occupation of the petitioner. But code लिख लिया अपन
मतलब
सेना भी लिखा है. Occupation of the plot number 919.
It is mentioned the eviction notice, my lord. Page number 20, plot number 919. Mauja Kanji.
Yes, 486 919 सेटा.
My lord.
In
Khata number 927 and plot number.
Also, it is mentioned in the notice, my lord. Page number 26.
Khata number 927.
My lord.
Plot number
919.
919.
Area 2 decimal.
Area 0.02 decimal out of the total plot area shall be maintained by the parties. With the aforesaid observation, the writ petition is disposed of. Urgent certified copy as per rules. The petitioner shall have liberty to act upon the copy of the order obtained from the official website of this board.
Lordsmith, a humble submission from this side. If no appeal is filed, then the order may not be given effect.
Okay, that order I have passed in the other order. In case the petitioner does not file any appeal, as undertaken before this court, by by so and so date, the the order passed, this order passed in the writ application shall have no effect.
Keep lovely.
Yes.
My lord.
32.
My lord. My lord. Pardon, my lord.
May I please your lordship?
Undertaking ଟା ମୁଁ
ଦେଲେ ନା ଦେଇନାହାନ୍ତି?
ଦେଇଛି ତାଙ୍କୁ।
ସେ କପିଟା ଆପଣ ଫାଇଲ କରିବେ କୋର୍ଟରେ ନା ମ୍ୟାଡାମ କୁ ଦିଅନ୍ତୁ।
ମ୍ୟାଡାମ ଦେଇଛି। 25
ଆପଣ ଆକୁ ବି ଦିଅନ୍ତୁ ନା, ଷ୍ଟେଟ କାଉନସିଲ କୁ ବି ଦେବାକୁ ପଡିବ ନା।
ଷ୍ଟେଟ କାଉନସିଲ ମୁଁ ତାଙ୍କୁ ଇଏ କରି ଗୋଟେ କପି ଜେରକ୍ସ ଦେଇଦେବି ଆଉ।
ଆରେ ଆପଣ ଏମିତି କଲେ କେମିତି ହବ ଆଜ୍ଞା? ସେ ଫେର କୋଉଠୁ ଆଣିବେ? ଆପଣ ପଛରେ ଗୋଡେଇବେ, କୋଉଠୁ ସେ ପାଇବେ ଆପଣଙ୍କୁ?
ଷ୍ଟେଟ କାଉନସିଲ ତାଙ୍କୁ ନେଇ ମାନେ ଇଏ କରିଛନ୍ତି, ମୁଁ ତାଙ୍କୁ ଦେଇଦେବି, ତଳେ ଅଛନ୍ତି।
ଆରେ ତଳେ ଉପରେ କଥା ନାହିଁ, ଆପଣ କପିଟା ତିଆରି କରନ୍ତୁ ଆଗ, କୋର୍ଟରେ ଥୋଇଦେଲେ ବି ସେ ନେଇଯିବେ।
ଠିକ ଅଛି। 25, 27, 28, 29, 30 ମାନେ ଅର୍ଜେଣ୍ଟ ସାର୍ଟିଫାଇଡ୍ କପିଟା ଟିକେ
ଲେଖା ହେଇଛି। ସବୁଥିରେ ଅର୍ଜେଣ୍ଟ ସାର୍ଟିଫାଇଡ୍ କପି ହେଇଛି, ଅର୍ଜେଣ୍ଟ ହେଇପାରିଲେ ତ।
ଆଉ ଗୋଟେ କଥା ମାନେ ରିଭିଜନ କେସଟା ସେପାରେଟ ହେଇଛି ନମ୍ବର ଗୁଡା, ଗୋଟେ ନମ୍ବର ତ ହେଲା, ଆଉ ସବୁ ଗୁଡା ନମ୍ବର ଗୁଡା କହିବି।
ସେ ଇଣ୍ଡିଭିଜୁଆଲ ଅର୍ଡର କରିବାକୁ ପଡିବ, ଦେଖିବାକୁ
ଇଣ୍ଡିଭିଜୁଆଲ
ସେପାରେଟ ଅର୍ଡର କରିବାକୁ ପଡିବ, କାରଣ ଫ୍ୟାକ୍ଟ ଏରିଆ ବି ଅଲଗା ଥିବ।
ଆଜ୍ଞା, ଏରିଆ ବି ଅଲଗା।
ଆପଣ 10/15 ଦୋକାନ କରିଛନ୍ତି, କିଏ ତାଙ୍କର ଗାଡି ଶୋରୁମ କରିଛନ୍ତି, କିଏ ମୋବାଇଲ ଦୋକାନ କରିଛନ୍ତି, ଡିପେଣ୍ଡସ୍ ଅନ୍ ଦ ସାଇଜ ଅଫ ଦ ଶପ୍। Yes.
May I please your lordship? But the petitioner is the Naib Sarpanch of Pentopada, my lord, Gram Panchayat.
Sudananda Mahapatra for the petitioner, Mr. Siddhartha Prasad Das, Assistant Standing Counsel for the opposite party. Yes.
But the petitioner is the Naib Sarpanch of Pentopada Gram Panchayat, my lord.
Yes.
Author of Pento Gram Panchayat. Your lordship may kindly see Annexure 1, page 9.
Yes.
The property concerned is the Gram Panchayat's property.
Yes.
They have constructed, the Panchayat has constructed from its own fund certain shop rooms that has been, my lord, given to the shopkeepers on rent. Your lordship, Annexure 2 series, I have given these, my lord, agreements to those persons. My lord, certain GPLF, my lord, one writ application was filed by some person, one person, my lord, Srimati Bimola Behra, before this honorable court, my lord, for construction of GPLF building, office building. For that, my lord, direction was given, my lord, that to
page number 90.
take immediate steps for providing the layout and remove the encumbrances from the site immediately. These sub rooms are not coming under that encumbrances.
So that order is by division bench. You should have filed a memo for the division bench.
No, my lord, it is
division bench.
No, my lord, you also kalli hochi eviction kardebe sir.
সেটা করি হবনি, ଆପଣ ଆଜି ସକାଳେ କରିଥିଲେ ହେଇଥାନ୍ତା।
ନା ଏଇଟା ଡିଭିଜନ ବେଞ୍ଚ ର ସିନା ଅର୍ଡର ଟା।
ଆପଣଙ୍କର ଯଦି there is a division bench order which is coming in the way of a single bench, it cannot proceed.
ସାର୍ ଆମେ ତ କଲା ପରେ ସେ ଯାହା ଅଫିସ ନୋଟ କଲେ ନା ଆମେ କଣ କରିପାରିବା?
ନାଇଁ ସେଇଟା ଆପଣଙ୍କ କର୍ତ୍ତବ୍ୟ ହଉଛି ଆପଣ ମେମୋ ଫାଇଲ କରିବା କଥା ଡିଭିଜନ ବେଞ୍ଚରେ। ଅଫିସ କେବେ କରିପାରିବେନି, ଏଟା ଲିଷ୍ଟିଂ ହଉନି ୱିଦାଉଟ୍ ମେମୋ।
ନା ଯୋଉ ଅଫିସ ଗୋଟେ ଅଫିସ ନୋଟ ହୁଏ ଡିଭିଜନ ବେଞ୍ଚ କି ସିଙ୍ଗଲ ବେଞ୍ଚ, ସେମାନେ ଅଫିସ ନୋଟ ରେ ସିଙ୍ଗଲ ବେଞ୍ଚ ବୋଲି
ଆପଣ ଯଦି ଅଫିସ ନୋଟ ହେଲା ଯେ ଆପଣ ଡିଭିଜନ ବେଞ୍ଚ ଅର୍ଡର ଲେଖିଥାନ୍ତେ, because your cause of action is towards by passed by the coordinate division bench. ଆପଣ ସେଥିରେ intervention file କରିଦେଇଥାନ୍ତେ।
Your lordship may keep it fifth.
My understanding is that as I was suggesting today morning that you should have filed your intervention or recall there. This is an order of
No, this is not
this is now
recall.
3 months.
Very recent order.
No, recall is not required, my lord. Notice is issued on 26/5/2026.
ଆପଣ ଭଲ ବୁଝିଲେ, recall କରିବା ପାଇଁ ମୁଁ କହିଲି କି I suggested that you could have filed a intervention, recall or similar application.
ଦରକାର ନାହିଁ, ସେଠି ଆମର ସିଏ କହୁଛନ୍ତି ଏନକମ୍ବରେନ୍ସେସ୍ ଟା ଭିତରେ ରହିଲେ ହିଁ ହବ, ଏଇଟା ଏନକମ୍ବରେନ୍ସେସ୍ ଭିତରେ ନୁହେଁ, ତେଣୁ ରିକଲ୍ ଦରକାର ନାହିଁ।
ନା ସେଠି କହିବେ, ଶୁଣନ୍ତୁ, if they are taking your case is that they are taking refuse of this order 4198 and demolishing, that is your case.
ଆଜ୍ଞା, so they are misinterpreting that order passed by the honorable.
You should have filed that application along with the said petition.
No, ସେତେବେଳେ ନୋଟିସ ଟା ସାର୍ 2 ଦିନ ତଳୁ ହେଲା ପରେ ଜାଣିବାର ଆମକୁ ଭାଙ୍ଗିବାର ସ୍କୋପ ପାଇଁ ସେଇଟା ଗ୍ରାମ ପଞ୍ଚାୟତ ବିଲ୍ଡିଂ ଟା ଆମ ଗ୍ରାମ ପଞ୍ଚାୟତ ପାଇଁ, ଏଇଟା ଏ ବିଲ୍ଡିଂ ଗୁଡା ବି ଆମ ଗ୍ରାମ ପଞ୍ଚାୟତର।
The petitioner, the lauded counsel for the petitioner,
କାଲି ପାଇଁ ଟିକେ ବନ୍ଦ କରି ଦିଆଯାଉ, ଆପଣ ଯୋଉ ଦିନ ରଖୁଛନ୍ତି
ଏଇଟା ଲେଖନ୍ତୁ, ଲେଖିଲେ the learned counsel for the petitioner, the petitioners are before this court seeking intervention of this court.
सर मु तार इंटरवेंशन चाहूँ
अरे intervention of this court आपण चाहुनांती
इंटरवेंशन ऑफ दिस कोर्ट नहीं नहीं आपन को इंटरवेंशन चाहूँ ने ई डिवीजन बेंच आई एम सॉरी आई एम सॉरी माय लॉर्ड
सॉरी कोन आपण लाइटर वेन रे किछि ओडा नेबे नै
आई एम सॉरी लॉर्ड
at this time you should have all your energy to spend in lighter vein, otherwise आपण को व्यक्तिवस्त हे जिवे.
My learned senior has added responsibility now, so let's make that.
Again, sir.
Now he is feeding so many people. I was just going to tell them. He has become a huge family burden. So the petitioners before in the writ application seek intervention of this court in response to regarding the eviction notice dated 26/5/2026, which is annexed to the writ application, is in Odia, marked as annexure 4C. The said notice refers to the order of passed by the division bench dated 3/6 order dated 18/3/2026, passed by the division bench in WPC number 494198 of 2026. It is submitted by the learned counsel that the area under encroachment of the petitioners has nothing to do with the area that is subject matter of said WPC number 4198 of 2026. Since the order passed by the division bench has bearing on the adjudication of the writ application, the matter shall be listed before the division bench on 5/6/2026. सेति करी हबो
काली की एविक्शन ये कर काली की डिमोलिशन कर देबे.
बट प्रॉब्लम हला जे आपण सेटा को कलेनी, यू डिड नॉट हैव द अपॉर्चुनिटी. द बेंच वाज अवेलेबल.
काली की भांगी देले रीट एप्लीकेशन इनफ्रुक्चुअस हे जो
सेटा कोन करे आपण सेटा हाई कोर्ट
काली से 5/6 पर्यंत
सुप्रीम कोर्ट स्टे नै पर थांते नले हाई कोर्ट एटलीस्ट हाई कोर्ट रे चेष्टा कर थांते डिवीजन बेंच रे.
काली 5 तारिख पे किछ एक्शन
रिक्वेस्ट करंतु मिस्टर दास जे से कहबे से 5 तारिख रे आसीबो बोली. दैट मच that may he will
loco setter, Millard. With due respect, I mean, the petitioner has no loco setter because he has never been noticed. And
then it panchayat property
that the property
panchayat ro eman housni shopkeepers the petitioner hi loco stand hi
semana aswa kotha. Anyway, let us see in fifth what is happening. But dekho jodi seta kichi kari paribe request if you can put a word that they will be maintaining. You see, there is a division bench order and they have directly referred to them.
And there is a clear direction in this
case has been initiated. That case 1 of 2026 has been initiated as directed by the High Court.
Yes, madam.
That Odia annexure is states that. Yes, next.
এটা খালি 5 তারিখ পর্যন্ত নো কোর্সিভ অ্যাকশন উইল বি টেকেন.
সেটা করি হবনি. The problem is that how can I pass a conflicting order with a division bench order?
না ডিভিজন রে আমরা স্ট্যান্ড হচ্ছে যে সে তা সারা সবজেক্ট ম্যাটার ये জমি নহে সেটা হচ্ছে আমার স্ট্যান্ড সেতি পই করাই.
Whatever sir you have annexed that, your problem is that you have annexed that yourself.
हां मु कहू
সেটাই annex করছলে.
কহি কি সেটা কহি কি আভরমেন্ট নেইছি সেতে পারা 6 রে.
So whatever আপন সেটা অথরিটিং কোনতু. It is so easy. আপনকৰ যদি কহিব অথরিটিং আগে আমি তো সে লোক নো কি সে property no, so that's a different thing. But you have annexed the notice which refers directly to that particular judgment. Yes, next. 33. Yes, Mr. Sabat. You are Mr. Sabat.
Yes, my lord. May I please your lordship?
So Prabhakar Sabat for the petitioner.
Yes,
my lord. Commissioner for the state.
Mr. Misra. For state. Yes.
Your lordship, item number 33 is opposite party number 7 have been without given any opportunity, my lordship, for hearing has given phone number Kh on dated 15/5/26 for eviction of your house, my lordship.
ଆପଣ appeal ଯାଆନ୍ତୁ appeal 15 ଦିନରେ ଫାଇଲ କରନ୍ତୁ like the other matter ଯାଆନ୍ତୁ ହେଲା
My lordship. My lordship.
କରିବାକୁ ପଡିବ I cannot you see High Court cannot become the sub collector. High Court cannot become the revisional authority collector. ଆପଣ appeal ଫାଇଲ କରନ୍ତୁ ସେଦିନ ସେତି ଦିନ ଯାଏ I will direct it you will not be evicted, no coercive action or status quo as on date will be maintained.
My lordship, similar order also passed by Honorable Justice Sri B.P. Rautra copy, sir, my lordship.
No, sir, I have the highest regards for every order passed by all the judges. There is no difficulty. आपको बुझिया पड़िबो जे I cannot become the appellate authority.
Further, my lords, why is the petitioner naming a judge, my lords? This honorable court is enough. Why is
No, he seems to be a novice. I mean, naivety. Excuses naivety, Mr. Mishra.
My lordship, my petitioner is a landless, my lordship.
ଶୁଣନ୍ତୁ appeal ଯଦି କରିବେ କରନ୍ତୁ
my lordship, appeal କରିବା ପାଇଁ ମୁଁ ଗୋଟେ କିଛି ଦିନ ଟାଇମ ମାଗି ଦଉଛି ତାକୁ ଟିକେ status
ସେଟା ଆପଣଙ୍କୁ ଆଗ ଦେଇ ସାରିଲେଣି ଆପଣ ଦେଲା ପରେ ବୁଝି ନାହାନ୍ତି ଆପଣ ଆଉ ଗୋଟେ ଅନ୍ୟ କୋର୍ଟ କୁ ପଳେଇଲେ ଜଜଙ୍କ ନାଁ କହୁଛନ୍ତି ଆପଣଙ୍କୁ ଟାଇମ ଦେଲା ପରେ ସେ ଆପଣ ବୁଝି ପାରୁନାହାନ୍ତି
sorry my lordship
ହେଇଛି ସେ ଯୋଉ ମ୍ୟାଟର
my lordship
ହଁ 1906 କୁ ସେଇ 1906 ହଉ ଆପଣ appeal 1906 ରେ ଫାଇଲ କରିବେ ଆପଣଙ୍କର ପ୍ରୋଟେକ୍ସନ ରହିଲା କୁ ଯେ
not all.
It shall not be evicted till shall be maintained till
my lordship
till 3800
My lords, only one humble submission I have.
ଫାଇଲ କରିବେ ଆପଣ 1906 ରେ appeal ଫାଇଲ କରନ୍ତୁ so one week will be sufficient time ଅଧିକା time ଦିଆ ଯାଉଛି
Only one submission.
ରହିବ ଆଉ ଆପଣ ଯଦି ଫାଇଲ କରିବେନି ଅର୍ଡର ଇଫେକ୍ଟିଭ ହବ ନାହିଁ
absolutely my lordship file to on the appellate authority, my lordship.
ঠিক আছে ଆପଣ along with a petition for interim order that will be considered and due order will be passed and the status quo will be maintained till 3800
My lords, only one thing your lordship may clarify, if not evicted already, because the law form is
status quo as on date status quo
as on date.
Status quo as on date shall be maintained till 3800 ହେଲା
my lord
if you would have marked that case of Mr. Mishra was arguing he said that I do not know I mean I don't know what you are saying I mean Mr. Gopinath Mishra not Swayambhu Mishra he said I do not know what has happened ଆପଣଙ୍କର କଣ ଆପଣ ଜାଣିଛନ୍ତି ନା ଜାଣିନାହାନ୍ତି କଣ ହେଇଛି ସେଠି anyway ଆପଣ 1906 ରେ ସେଟା ସରି 1906 ରେ ଫାଇଲ କରିବେ 29 ଯାଏ ଷ୍ଟାଟସ୍ କର
that order may be passed
yes ଆପଣ ଫାଇଲ ନ କଲେ ଅର୍ଡର ହାଇ କୋର୍ଟ ଅର୍ଡର ଇଫେକ୍ଟିଭ ହବ ନାହିଁ
my lord
yes
my lord similar
also the same my lords
my lord similar item also 34 and 35 my lord
34 35 तो 33 34 35
my lord
35 I'm appearing for the state
the 35 sorry acha
my lord senior Miss Maharana is appearing for state
okay 33 रे Mr. Swayambhu Mishra
my lords 33 and 34 is allotted to me
34 Mr. Swayambhu Mishra AC 35 Miss Sarita Maharana AC
my lord another I also prayer my lord I also filed another 3 petition and D number also my lord allow and
ଶୁଣନ୍ତୁ ଆପଣଙ୍କର ଗୋଟେ elaborate arrangement କରାଗଲା oral mention to the better arrangement ହେଇଛି ସବୁ ଜିନିଷ ଆପଣ ଫାଇଲ କରୁଛନ୍ତି ବାକ୍ସରେ oral mention ଯେତେବେଳେ କେତେବେଳେ ହଉଥିଲା ଯେତେବେଳେ ଆପଣ କୋର୍ଟ ଥିଲା ଏବଂ ଯେତିକି ଆଲାଉ କରୁଥିଲେ କୋର୍ଟ ବର୍ତ୍ତମାନ ତ all memos are accepted even 11 ରୁ 12 ଜାଗାରେ 4ଟା ଯାଏ ଚାଲୁଛି ଅଫିସ so ତାଠୁ ଅଧିକା କଣ କରିହବ ତାକୁ ଆପଣ ଫାଇଲ କରୁନାହାନ୍ତି କାଲି ଫାଇଲ କରନ୍ତୁ but not in D number ରେ ହବନି ସେତିକି ଏଫର୍ଟ ତ କରିବେ ଆପଣ ଆଜ ଏ ଲୟର ଆଜି ଆପଣ ରିମୁଭ କଲେନି yes Mr. ସାବତଙ୍କର ହେଲା 33 34 35 35ଟା ମିସ୍ ସରିତା ମାନ ଆଡିଶନାଲ ଷ୍ଟେଟ୍ ଇନକମ୍
highly obliged
36ଟା ସେ ଆଡଜନ କରିଥିଲେ ସିମ୍ପୁଲାର ହଁ
37 your lordship kindly see order dated 30th March
37 state Miss Maharana
my lords I am there
37 Mr. Amya Kumar Mahanti for the petitioner Mr. Rajdeep Das
Rajdeep Pradhan, my lord.
It's a Rajdeep Pradhan for the opposite party state. This is
Your Lordship, kindly see order dated 30th March. Thereafter, the bench did not function. And in the meanwhile, my lord's vacation intervened in spite of my attempt could not be listed. Now, in spite of Lordship's interim protection, they have demolished a part of my structure on 26th. And I came to know from reliable source they will come on 5th to demolish the rest of the structures.
so you are saying despite the interim order, they have
Partly they have demolished.
already. Yes, Mr. Pradhan, how that could happen?
My lords, I do not have instruction to that.
I mean, obviously, you may not have, but you should, whenever you want to modification, variation of any order, just simply approach the court.
My lord, that eviction has been initiated by the BMC, my lord. I am appearing only for.
You are not appearing. Who is appearing for BMC? Notice notice any.
Notice it.
30 दिन ପରେ appropriate assignment ହେଇପାରିନି.
Because
the Lord's Counsel for the petitioner refers to the order dated 30/3/2026 passed by the coordinate bench, which is reproduced herein. It is submitted by the Lord's Counsel that in the situation that the matter was taken up, it could not be listed after 30/3/2026 as the bench was not available. 30 माने
तापर डिवीजन बेंच हला से मैटर नेलेनी.
The bench was not available. Despite the interim order, that was till tomorrow.
हाँ. से justice court number 21 could not take. से जेतु assignment नथला immediately नेले.
कौन लेकिन नहीं despite लेखोतुलु. As the matter could not be listed, as per instruction of the Learned Counsel for the petitioner, the part of his property has been already demolished. Stop. The petitioner is before this court against the order dated 23/3/2026. IA number आपण एबे कोटा फाइल करछन 1051402026. IA number 1051402026 is filed apprehending further demolition and protection against such demolition. The reasons for notice not being issued to the opposite party or the matter could not being listed are not very clear. Issue notice to the opposite parties, Learned Additional Standing Council upon advance copies appears and waives notice on behalf of OP number
1 and 4.
1 and 4.
1 and 4.
2 and 3. 2 and 3 by speed post with registration and proof of delivery shall be filed within 3 working days. Within 3 working days. IA 5968 and 1051402026 is to notice as above. The learned AAC shall obtain instruction. The opposite parties shall also file their response by the next date. Returnable date be fixed to TVC 6/2026. The matter shall be listed in the week commencing 6 July 2026 for orders to the next date of hearing. Status quo as on date regarding nature, character, ownership, and possession of the subject property as mentioned in court मिलिबो.
एटा आंसर 3 रे अछि. पेज 27 रे अछि. पर यार भी
नोटिस डेटेड 23/3/2026 प्लॉट नंबर 85/775 এটা কে জন ফাইল করছেন পিটিশনার?
জনে
that is stated to be in possession. The portion stated to be in possession of the petitioner shall be maintained by the parties. Yes.
urgent certified copy.
Urgent certified copy be issued as per rules. Copy of this order shall be the parties shall have liberty to act upon the certified copy of the order obtained from the official website of this court.
Grateful,
Yes.
grateful to you.
Item 38, 39, 40 withdrawal, no urgency.
For withdrawal, my lord.
No.
My lord, I have filed memo for withdrawal, my lord. And my lord, with limit. No.
No urgency. I cannot pass orders in.
No, my lord, with some development has been in the meantime. Some development. I want to add some documents to it, my lord. It's urgent.
File amendment. Withdrawal I cannot allow by terming it as to be urgent. You must understand there is a specific notification. The matters which cannot wait till reopening has to be taken up.
My lord,
I'll allow withdrawal stating that they are urgent.
My lord, it's urgent because my lord have had it.
I have to pass an order or not? Or it is automatically withdrawn by simply mentioning. I have to pass an order. How I justify that it's an urgent matter to be taken up out of turn before the which.
My lord, in the meantime, one document has been published by the government, which
whatever sir, you bring amendment or whatever you want to do, but don't
amendment still that cannot be stated to be urgent.
Mr. Misra, either you have an adjournment or I have to reject the prayer of withdrawal because after observing that this is not urgent to be listed during vacation.
Then, my lord, I may be permitted to withdraw the memo of withdrawal. Then
let it be there. Let it be there. You take your chance. You take your chance. I know. Why should I? I'm not interested what is happening to the matter ultimately.
After filing memo for withdrawal, how can my lord, I try for amendment and anything else, my lord?
It can be. At least I have passed an order. I remember. I can tell the name of the lawyer that after filing the memo, stating withdrawal of the memo is quoted herein. After some time, there is a change of mind. The Lord Head Counsel files another memo of date, stating that he wants to withdraw the withdrawal memo. Accordingly, the withdrawal memo is withdrawn. You can ask the counsel if you want. I will give the. So this has happened. So that there is nothing. So, but this is not a regular bench. You must understand. These are all recorded proceedings. We must do some justice to the entire listing system. You must understand that.
My lord, there were 5 orders, even minors. Then
I cannot give the reason that the petition is urgent because some development has taken place and the petitioner wants to add some documents. That is how it is. Because that is a different. That is a IA. IA can always be taken up in vacation, possibly.
My lord.
But suppose you now file a document of like you have filed on 25th of December.
My lord.
You are challenging order of 25th of December and you want to add a document of March, January, and you want shifting of the fingerprint from Bharampur to Delhi. So those kind of prayers cannot be entertained. Those are not to be made.
No, in the meantime, government has
because you must kindly read the notification for vacation court. We used to have a vacation court where every matter was taken up. At least my practice days. I was appearing for a corporation. I stood at almost 9:30 or like that. So those days are gone. Notification has changed.
My lord, may kindly have this case. My lord, have had it. My lord, I tried my best with the available documents to take. This was someone is.
Mr. Misra, you are saying that you want to add a document that cannot be ground to allow a withdrawal. I have told you. So I told you that I have to reject that prayer that for filing of additional document, withdrawal has to be allowed.
Mr. Misra should not. I let me reject my withdrawal so that I can file it.
अरे सेटा रिजेक्शन ला आपण करछन आपण केबे करिवे यू मे टेक ए चांस आपण बुझी पाले ताटो अधिका मु भी एते ओपन हवाटा भी भलो नो एट टाइम्स आई फील दैट आई एम टू मच ओपन मो जे आपण कहली जे आपण चांस नियंतु आपण बुझिबा कथा सेतिरे
ठीक अछि मैडम
हां आपण टेंशन रहला से छाड़ दियंतु 38
simply adjourn
at the end of the day we are thankful and
the day has not yet ended, my lords. I have
your lordships.
Mr. Misra is waiting since morning.
Your lordship's patience is Highly appreciated, Your Lordship. From the day.
Maybe one reason is that because the High Court, but maybe perhaps Mr. Abhijit Misra, Mr. Pradhan, and Mr. Das, all of you are waiting also. Maybe you also have to take the credit because the only court available now, only bench available.
Yes.
So perhaps you have to take the credit also. It is not the judge.
I'm watching since morning. The energy level and the patience.
Then your lordship is holding
the energy level and the patience is
That's the reason thing that at least whatever may be the critic and whatever, but this is the only bench available. So you are there.
We are deeply grateful. We express our gratitude.
Yes, Mr. Misra.
My lord, my lord, there are two CMPs. Both the CMPs arising out of an execution proceeding. And my lord, the only reason why I'm pressing the urgency is that.
Just give, but there has to be a transition. Your briefs are separate. He is bringing. This paperless also. Yes.
My lords, has your lordship been able to get the brief, my lords?
Mr. Abhijit Misra, at least one now will be now. Mr. Swayambhu is satisfied that he could not get the hint in the morning. That is how he is finding. When he mentioned that my matters are not in the list, I said something which I can say in open court.
Well, I got your lordship.
Yes. So it was some. I told him that you please wait. Let us see what is happening.
Well,
because even the registry has to work till 6-7.
Yes.
So they have a difficulty.
And your lordship staff also, who is taking down the orders, they will now also have to work to get these orders.
For the next 2 days.
Next 2 days.
Yes, Mr. Misra.
My lords, there are two
MP 739. Yes.
These CMPs are arising out of two separate execution proceedings. I will not bother your lordship with the merits. The only reason why I am pressing this CMP now, the urgency is that, my lord, what has happened in this case is that there was an attachment order. I am not aggrieved with the attachment order. Attachment order, we will challenge it and the appropriate forum is there. What the bailiff did, my lords, he came to the office of the superintending engineer. He asked everybody to come out of the office. He put the entire office under lock and key with maximum of the belongings of the people inside, still inside. And he put the white collar cloth and he seal wax and he left. Now, Millers, we moved an application before this honorable court, being this CMP. In this CMP, we prayed for an interim application that the lordship may kindly be pleased to open the office of the superintending engineer. Because the superintending engineer's office, if it is closed down, the RA bills cannot be signed, salaries cannot be paid. Now, Millers, the honorable court directed the director of the superintendent of the district legal service authority to give a report in confidential that whether or not the office is closed or not. Now, that report is also available for your lordships. Only I am praying, Millers, till the reopening, the opposite party will be in no way prejudiced. My humble submission is that only the office may be unlocked because, Millers, if the office is locked, Millers.
Mr. The coordinate bench which has passed the order is available, I think.
No, Millers, it was available. Millers, earlier I made a mention there. The coordinate bench, Millers, before the DRI made a mention. It was supposed to be listed today before your lordships. Today the coordinate bench is not available, Millers. And Millers, every day that is passing, your lordship may kindly come to my IA. I have laid out the grounds, Millers. Your lordship may see on what grounds I am asking for the office to be opened.
No, I am not there, Mr. Misra. Actually, what I am thinking something else.
Man,
since already this application was considered by the Burata Achi.
No, I have filed a fresh IA. I have filed a fresh IA.
Correct, but that report which was directed by the coordinate bench, I think in all fairness, that bench should consider.
Yes, I am not aggrieved with that, Millers. My humble submission is that on affidavit,
because I think you have I'll just check. I'm just going
your lordship may check. Now, there are certain events that has happened after the vacation started, my lord. That is why.
It is there, Mr. The bench which has passed the order, dated 4/5/2026. Pursuant to that, the inquiry has been conducted.
Inquiry was conducted. My lord, it is not in dispute, my lord.
No. Kindly listen. I got your point.
My lord.
Considering the seriousness and gravity of such allegation, this court directs the secretary, the legal LSA Dhekana, conduct an inspection and submit a report before this court before the next day.
Mal.
Correct.
Mal. The court was not, my lords.
As an interim measure, it is directed that petitioner shall approach the lauded executing court, who shall ensure that the order passed by it is carried out in its letter and spirit without any variation therein.
Yes. Now,
Correct.
what was the order?
So now, Mr. Misra, this bench is available on 9th.
On 9th, my lord,
Yes.
is from 2nd to 9th, my lords. Your lordship may see the grounds that I have put.
No,
Only I am
because
stating.
no, Mr. Misra, then it is already since 4th of May. We are in June. It is already 1 month.
That is
So you should be bearing with for another week, exactly a week.
My lord, flood is coming. We cannot regulate the flood, my lords. The salaries.
But at least despite the threat of flood, you have waited till
my lord,
after 4
there is
5.
My lord, flood is one of the reasons. The most important reason, my lords, is that we are not able to pay salary, my lords. Dorama dei pannu ame lokamanuku, my lords.
No, Mr. Misra, perhaps you are not reading the order. Apar by order ta achi to?
Yes, yes, my lords.
Dekhantu, it is directed to be listed on 11/5.
It was directed to be listed, my lords, on 11/5.
Yes.
But it was not listed.
And the vacation continued. Started on by
My lord, I have mentioned the matter, my lords, 3 times.
I understand, but that order was directed. This particular order
Lord,
has
I
to
am
be
not
considered
asking.
by the
Lord,
same
I am
bench.
not asking your lordships to any way to vary the order. I am not on merit, my lords.
No, not that. I have to open that that still cover report.
Your lordship is the motion bench, my lord. The state is hapless, my lord. Where do I go?
No.
Where do I go, my lords?
Most
our office, my lord.
At least you should have patience till 9th. That bench is available.
Your lordship may then direct the matter to be listed.
And you see,
all I pray, my lord, your lordship may direct the matter to be listed on 9th. I bow down. Your lordship may direct the matter to be listed on 9th. All I pray.
No, that I cannot, because you must understand that is not mine. Because I can't direct listing of before other benches. That you must understand. You have to move the deputy registrar for listing on 9th. Mentioning this order.
No.
That
liberty your lordship can give.
That is again sufficient.
My lord, the lordship may kindly observe in your lordship's order today that liberty is granted to the state to move the deputy registrar for listing on the 9th. That liberty your lordship may kindly grant. That will prompt the deputy registrar.
When I cannot curtail your liberty, as I've been telling, there is no point in granting liberty. So I am not restricting by saying that after vacation or anything. Simple adjournment.
May your lordship, if your lordship simply adjourns, then the DR will post it after vacation, my lords.
No.
All I'm praying.
No. You have to, because you should have mentioned in the memo that pursuant to the order passed by this court, by the bench, on 11/5/4/2026, it was directed to be listed on 11/5, and the bench is available on 9/5. That much. Those kind of articulation I did not have to tell you.
No,
you must do that.
I bowed on, my lord. But my
because I am not passing any order. I am not passing
the IA that I have filed after the vacation started, I am pressing that IA, my lords.
Without going through the order, I cannot, without looking at the order passed by the coordinate bench, I cannot proceed. I should look at the order. That bench has considered and passed a detailed order and with a direction to obtaining a report also.
Yeah, that report, my lords, I have, for your lordship's convenience, I have attached a photocopy of the actual photograph of the office, my lords. What more proof can I give, my lords, that the superintending officer...
You are not getting. Then the court did not ask you to furnish any photograph. The court asked you for report. So
for a report.
And hopefully, the court will go by the report. Because you see, you have achieved what you wanted. You wanted to move the court. The court accepted your plea, directed listing of the matter. Also directed report by a judicial officer.
But the office remains closed, my lord. That is the whole issue.
Correct. So let it be. Let the bench consider that at least. I mean, there has to be a committee of courts, Mr. Misra. There has to be a committee of courts. There has to be.
Our seal be we cannot file any affidavit before the court.
I was not sure of the date, but now I see it is exactly 7 days. So tomorrow you have to take steps. Or sorry, सेटा 8 रे हो काली नो 9 तारीख पे 8 रे होची आपनकर मेमो. But you have to please mention these things. आपनकर बेले बेले problem एया होची जे they cannot follow what is happening. সেটা ବି listing
I'll
କଣ
file a
କୋଉ
fresh
order
memo.
you have to say that ଆପଣ orders copy ସହିତ ବି ଲଗେଇ ପାରିବେ
My lord, I'll fix the copy. My lord,
Yes, yes.
I'll do
Thank
that.
you.
I'll do that.
Thank you,
My lord,
thank you.
My lord, all I'm praying is that your lordship may kindly just indicate that the liberty is granted to move the 9th. My lord, otherwise,
ଏତେ ଲେଖି ଦିଅନ୍ତୁ the petitioners the learned counsel for the learned additional standing counsel ଏଟା ଆପଣ petitioner
my lord, state is the petition. The executive engineer.
learned additional standing counsel 6 liberty to जो special date करेंगे 6 liberty to move the deputy registrar for listing of the matter as per the method notified during vacation.
Highly obliged. Highly obliged. Much obliged.
সেটা ଆପଣ ଯୋଉটা କହୁଛନ୍ତି ସେଟା ଓଭର ଆପ୍ରିହେନ୍ସିଭ କୌଣସି ରେଜିଷ୍ଟ୍ରିରେ କେହି ନୁହନ୍ତି ଯେ ଆପଣ ଲିଷ୍ଟିଂ ବନ୍ଦ କରିବା ପାଇଁ ସେମିତି କାହାର କିଛି ଇଏ ନୁହଁ ତାହେଲେ ସେଟା ଏତେ କାହିଁକି ଓଭର ହୁଅନ୍ତେନି ୟେସ୍ ଥ୍ୟାଙ୍କ ୟୁ
Highly obliged.